Hello, everybody. Nothing causes those sweet, soft tears to flow like felonious judgery. It's got the crying fez on it. Whoops. I always forget my camera's backwards. Oh, yeah. I don't even know if I'll make it. Hello, C-Rex. It's a long one. Hello, Nana Laura. Hello, isn't that special? Thank you so much. Oh, yay. I know it's early a little bit, but it had to be because there's like 5.5, 6 hours of Kansas. It's all of the Kansas dockets from today. So yeah, I didn't do the whole like where I watch it edit because that would have taken like 2 days to do. But I did remove all the time gaps. So it's ready to go. Hi, baby. Oh, you're gonna need a special treat tonight. Yeah, you're gonna need something that's gonna last you. How about how about you just fall backwards and roll around on the floor? Look at her. She's like, I didn't see nothing. Oh. Here you go, baby. Mwah. Isn't that special? I am so sorry, sweetie. I am so sorry to hear that. Hello, Spider-Man, sweetheart. Hey, I completely understand. You do what you gotta do. I appreciate you being here. I did. We're gonna start with that one. Hello, how you doing, Saul Goodman? I know, sweetie. I am so sorry. All right, well, hopefully I can cheer you up, okay? Make fun of all the judges. Make fun of the defendants. I got them all. I got them all. I sat on the refresh button today. Hello, Linda Applegate, sweetie. We're just getting started. Yep, I got them all. Hey, Barbara. Hey, I'm supposed to tell you that C-Rex misses you. When I called her tonight, she's like, I really miss Barb. I haven't seen her forever. And I was like, hey, she's back. And she says, well, if you see her, tell her that I miss her. So there, my job's done. No, sweetie, not late at all. You're right on time for the party. Hi, Tiny Kitten Esquire. Speaking of right on time, hey, baby girl. Oh, she's gotten so much more social since her surgery. And she's sleeping in the laundry now. At least she's not peeing in it. That was a bit much. Oh, I know what you're looking for. You're looking for your treats. You're like, hey, look, it's treats at the start of every stream. And we don't. Here you go, baby. Here, Earl. I see you popping your head out. I'm just looking for the other ones. They're around here. I know they are. She did. She did. She's not so flighty and spazzy. Yeah, so I like it because I couldn't even pet her before. She's like, my treats, get away. I'm eating. Don't you mess with me, lady. Earl, you didn't even touch your treats. Oh, he wanted to go get some water first. Oh, these guys were such a handful. I'm trying to brush my teeth before stream. And I had Billy trying to drink from the spigot while I'm trying to brush my teeth. And then Earl, he's like trying to grab things on the bathroom counter. And I'm telling him no. And then so I decided to pet him with a wet hand because, of course, that's gonna, tick him off. And and so I go to pet him, and he like flings his back legs and knocks a bunch of like hairspray and stuff like that, like knocks it off the counter. And I'm like, all right, fine, whatever. And then so I come back in here, and I'm putting the pillows back up to the top and stuff. And he's up here, but this box is not. And I look, and the box is in the litter box, and it's one of those litter boxes that has the open cover, so it's a super deep one with the splash guard because that's needed. And so the scratch box is in the litter box, and the litter box cover is like all wonky. So I got that all put back together. And then he's doing his sitting right here, and he's reaching and like grabbing on my shirt. Oh, it's been fun. It's been fun. These guys are keeping me busy. I don't have a hubs. It is my bedroom. I sleep in it with all of the animals. No, I am quite single. Yeah, they warned me about that. They were asking me if she was on kitten food, and I'm like, no, she's on adult food. They're like, good. Yeah, the mellowing out. Okay, guys. Well, if we don't start this docket, it's going to be 4 a.m. before it gets done. So, and I don't even know if we'll get through it all. It is long. Esquire is the all black one that was just here a second ago. Tiny Kitten Esquire. Ooh, hi, Bandit. Hi, baby girl. She's like, don't forget me, mama. Mwah. Oh, my baby tortoiseshell girl. Well, yeah, there is that. I get at least 3 hours in the bed most nights because I have to use my BiPAP machine for 4 hours. So typically I can get 3 hours, and then I have to like use it while awake for an hour when I start editing, because I don't go to bed till like 4 or 5 in the morning, and I have to start dockets at 7 or 8. So hello, LN. Yes, this is going to be like local news for you. Oh my gosh, I gotta show you something. Oh, it's not gonna let me do it. I'll have to do it on my phone. All right, guys. Oh, I'm getting tiny kitten or bandit kisses, and you're getting bandit butt. I cannot get to the buttons. She's just the best. I love this girl. Oh, and there's a special treat if we make it all the way to the end. There's a special treat at the end from Texas.
Mr. Watts, are you going to need a breakout room with your client? She is present by Zoom.
I don't believe so, Your Honor.
Okay, thank you. Judge, I think we're ready to rock and roll.
Okay, thank you, Chris. We'll go on the Zoom record at this point. And the case is entitled State of Kansas versus Jesse Kathy Adams, 24 CR 437. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Adams, appears in person and by court-appointed counsel Jim Watts. This matter does regularly come back before the court this date on the defendant's motion to suppress, filed with the court February 20, 2025, scheduled for hearing today at this time. And Ms. Norris, is state ready to proceed?
Yes, Your Honor.
And Mr. Watts?
Yes, Your Honor. Would ask witnesses be sequestered, please.
Court grants the motion to sequester witnesses. The court does find that Detective Tom Akers is to be the first witness.
Judge, I think I have them all.
Thank you, Chris. And Ms. Norris, you may call your first witness.
Your Honor, state calls Detective Tom Akers.
Sir, if you'd raise your right hand, I'll administer an oath. You do solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
And Detective Akers, please speak slowly and distinctly so we may take a good record. Please proceed with direct examination, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
My name is Thomas Akers. I'm a detective with the Butler County Sheriff's Office.
And how long have you been in law enforcement?
I've been with the Sheriff's Office for 14 years now.
And how long as a detective?
As a detective for the last 4.
And were you working your capacity as a law enforcement officer with the Sheriff's Department on January 25th of 2024?
Yes, I was.
And did you have cause to get involved in a case that was kind of, I guess, moving through the county involving Jesse Adams?
Yes, I was.
Okay. And can you explain, I guess, your initial involvement?
When the case was first put out, it was a kind of a rolling incident. Multiple deputies and other agencies were requested to assist to try to locate and to stop this vehicle. It was identified as a large silver Infiniti SUV. This vehicle was located by the Augusta Department of Public Safety. It was actually at the Casey's on 7th Avenue. I responded to Casey's in Augusta to assist in whatever capacity that I could.
Okay. And so you go to Casey's in Augusta. What do you find when you get there?
By the time that I had arrived, there was 3 occupants identified in the vehicle. They had already been removed. I don't recall the exact members of the Department of Public Safety that were there, but I know that the individuals in the vehicle were suspect of the ongoing incident. We had known at this point individuals in that vehicle had brandished a firearm and had threatened other individuals. This was the reason why they were requested to be detained. When I got to the vehicle, I noticed the driver door is open. Vehicles parked facing southbound at the gas stalls. The 3 occupants in the vehicle, of which include Miss Adams, they were at the back of the vehicle between the islands and the store, just kind of not free to leave at that point.
Okay. And, but they were not in handcuffs?
They were not.
And had they been patted down for weapons?
I don't know.
Okay. So then what happened? So and you said there's somebody from Augusta there, but you're not necessarily sure who it was?
Yes, there was a handful of officers there. I know at one point Chief Ackerman shows up. I know I did majority of my conversing with members of that department with Chief Ackerman, pretty much. Essentially, we had determined that, we had a need to check this vehicle. In addition to that, we requested Deputy Chip Weber to run a canine open air sniff on the vehicle, which was done.
Okay. So you get there, you're talking to Chief Ackerman. Are there any other officers there at this point?
Members from the sheriff's office include Sergeant Camp Schroeder, former Deputy Patrick Bruce. I know Chief Ackerman was there. Another officer from Augusta was there. I don't believe Officer Dean had been there at that time. I think she was called to the scene after the fact.
Okay. So, and then you say that Deputy Weber came in with his drug canine.
That's correct.
Okay. About how long after you got there did Deputy Weber arrive?
Pretty soon.
Okay. So like less than 5 minutes?
That's fair.
Okay. And then what happened?
So Deputy Weber ran his canine Lego. She alerted positive indication, which was reported to us by Deputy Weber. At that point, we conducted a search of the vehicle.
Okay. And what did you find?
The vehicle was pretty cluttered. It's a very large SUV. From the floor to the ceiling, it was pretty checked with items. As we were searching through the vehicle, actually, former Deputy Bruce explained to me that he had found some mushrooms in the back seat, which were photographed, which I photographed later, not necessarily in the back seat. But at that point, we had learned from speaking with members of the Augusta Department of Public Safety that Mr. Mogul, one of the individuals in the vehicle, was removed from the driver's seat. A Mr. Napier was pulled from the front passenger seat, and Miss Adams was found in the back seat. Based on this, we understood that, number one, the first 2 were already identified in the aggravated assault by the victims of this case. At this point, in finding suspected controlled substances in the backseat, we had further reason to detain and or arrest Miss Adams.
Those weren't mushrooms, sir. You mentioned the vehicle was cluttered. Well, it was just fungus growing on the old pizza boxes and stuff in the back seat.
Okay. And while you're doing the search for the drugs, were you able to locate any firearm?
We actually found a packing, like the plastic packing for a mock Beretta PX4 Storm, but it was a BB gun. We found that. I don't exactly recall where we found it, but I know that it was, I can't say. I don't exactly remember where it was found, but it was found within the vehicle.
Okay. And then you said you found mushrooms in the back seat near where Miss Adams had been sitting.
Correct.
Okay. So what did you do at this point?
At this point, we have to make a decision to clear the scene. Casey's a busy store, and we have 3 individuals in custody and being suspected of other issues, we have a need to interview them.
Okay, let's back up. The three individuals at this point, have they been arrested? Have they been cuffed? Have they been, more thoroughly searched? Before you said they were just milling around outside the vehicle, not free to leave the gas station while you did some investigation.
Correct. So to clarify or to draw the line of distinction, this was a fluid moving element. As soon as we had found what we believe psilocybin mushrooms in the back seat, at this point we have cause to continue on a criminal investigation against Adams for possession of controlled substances. That hadn't developed until after we found the mushrooms and had learned that she was in the back seat. So up to this point, they had not been placed in handcuffs. They had not been told they were under arrest. However, we were detaining them so that way we could continue this investigation into the aggravated assault. In fruition of having discovered the mushrooms and in the totality of circumstances from the victim report that we already had, we did arrest Miss Adams and Mr. Mogul and Mr. Napier with the intent to have them transported to the Butler County Sheriff's Office for formal questioning.
Okay. So, did you actually, I guess, put the cuffs on Miss Adams, or did someone else do it at your request?
Yes, I did not put handcuffs on anyone. That being said, I was coordinating with Chief Ackerman for the need of a pat search or a search of Miss Adams. Due to the fact that she's cross-gender, we wanted a female, and a female was available, Officer Dean in specific, so that way we could get a search done on her, so that way she could be safely transported.
Okay. So were you present when Officer Dean, who is a female officer with the Augusta Department of Safety?
I was not present during the search, but I did make that request to Chief Ackerman. I requested a female officer, not necessarily specifically Officer Dean. He made the arrangements for Officer Dean to be called to the scene. Then a search was conducted. She was then subsequently put in handcuffs. This was not done in front of me. I don't know necessarily who did, but I can honestly say that it was at my behest.
Okay. So, and so Miss Dean arrives, or sorry, Officer Dean arrives. Is she involved in any way in this investigation?
No, she was called to the scene. I would expect that she had no prior knowledge of necessarily the things that developed other than what was put on the radio if she happened to be listening. I didn't converse with her in detail about the investigation or what was discovered. If you would, there would be like 3 sets of groups working together toward a common goal. One, not at Casey's, actively searching for a spot where we had already quickly assumed that the gun had been thrown from the vehicle, which we later had confirmatory statements that it had. Officers were out searching there. Then we had officers standing by with the 3 individuals removed from the vehicle. And then I was a part of the group that was searching the vehicle.
Okay. So once the search is complete, a female officer from Augusta comes, does a thorough search of Miss Adams, and then she's basically put in handcuffs. And was anything found on Miss Adams when this search was done, when she was basically being arrested?
It was explained to me by, I can't recall exactly who told me. I want to say it was Chief Ackerman who told me that during the search of Miss Adams, Officer Dean had discovered some controlled substances, or at least a pipe concealed on her person, in addition to 2 plastic magazines for a BB gun. These items were seized as evidence.
Okay. And was there a bag of crystal substance also located on her person?
Yes.
And
Meth.
did you send, or did someone send those items for testing?
I did not. I'm not familiar with any testing. I know that Detective Sperry ended up taking lead on the investigation.
And that was at a later time?
Correct.
Okay.
I apologize. I have no clue if that was actually sent off for testing.
That's all right. That's not really the issue in the motion to suppress today anyway. But Detective Akers, I don't think I have any further questions for you, but Mr. Watts may have some follow-up. Thank you.
Thank you.
Thank you, Ms. Norris. And cross-examination, Mr. Watts.
How you doing this morning, Detective?
Not too bad.
Okay, I want to start where you arrive at the Casey's in Augusta.
Okay.
For my purposes in this hearing, I don't care what happened out on the road. You arrived at the Augusta Casey's. Who's already there?
I met specifically with Sergeant Camp Schroeder and Deputy Bruce, and I don't remember. There was a male officer from Augusta. I think Chief Ackerman showed up pretty quickly after me.
Yeah.
But I don't exactly remember who all from Augusta was there. If I remember correctly, there were 2 officers from Augusta, but I do remember Sergeant Camp Schroeder, Deputy Bruce, and myself being there.
Okay. Now, when you arrive, the vehicle that you're looking for, this silver SUV, is it parked at a gas pump? Is it in front of the store? Where is it?
It's parked at a gas pump. It's
Okay.
facing southbound, and it was about in the middle of the row of the islands.
And the persons that were in it, I take it when you arrived, they're already out of the car.
This is correct.
Okay. And you identified the 3 persons that were in the car identified to you, correct?
Yes, that information was given to me.
Okay. And as you understand it, there are 2 males in the front and a female in the back seat. You don't know which side.
That's correct.
Okay. Now, at the time you arrive, are the 3 persons that have been removed from the vehicle, they are detained, correct?
Yes.
Okay. And I want to make sure I understand that distinction. At that point, an investigation is still ongoing. They have not yet been placed in custody, but they are detained for investigation. Would that be fair?
That is fair.
Okay. And given the nature of this particular investigation, given that there were reports, remember back on the highway, of some guns being displayed, these 3, I assume, would almost certainly have been patted down for weapons very quickly.
If I had been there to remove the individuals, I would have removed them and patted them for weapons.
But they were already out, so it's fair to presume they've already been patted for weapons. Would that be fair?
Yes.
And there are other law enforcement officers there. I cannot imagine, given the circumstances here, that they wouldn't do that. Would that be fair?
That's fair.
Okay. And a pat for weapons, an external pat for weapons, just so we're clear, we're talking about not reaching into pockets, but basically an external pat down for something that is hard, that can be identified as a weapon.
Yes,
Correct?
pat search should be over the clothes, brief, full contact, and then unless you can articulate a weapon or something else very specifically, then we're not going into pockets.
Yeah, and given these circumstances, completely understandable. All right. So when you arrived, those 3 persons are standing outside. My client obviously is the female, Ms. Adams.
Yes.
She obviously was patted down as well, correct? At the time you were there, does Ms. Dean arrive to do a more thorough search of her?
Yes, this is it. I wouldn't be familiar with any kind of pat search that was conducted of Miss Adams prior to me being there.
Okay.
The only pat search I'm familiar with is the one that I requested.
Okay. Is that the one Ms. Dean did?
Yes.
Okay. So you requested, and then you made the request for Ms. Dean to get there. All
Through
right.
Ackerman.
Correct. Is that right?
That is correct. Through Chief Ackerman.
Okay. What Ms. Dean does is not a pat search. Would that be fair?
I don't know. I didn't witness it.
You didn't witness it. If Ms. Dean testified that what she did was considerably more intrusive than a pat search, would that be inconsistent with what you observed?
I didn't necessarily observe, well, I did not witness the pat search. However, my intent was for her to be searched.
Okay.
Intrusive search.
An intrusive search.
As in like we're going to make sure that she is removed from her, all of her possessions.
Okay. Was she placed under arrest?
At that time, under the pretenses that she was found in connection to, well, found in the proximity of controlled substances, yes,
Okay, so she's placed under arrest. Is that prior to or after Ms. Dean's search?
it would have been before. That being said, Miss Adams was never instructed that she was under arrest. It was a decision that I made, that it was expressed and explained to other officers on scene. This is the circumstances we had found controlled substance near her, but we did not discuss that with Miss Adams.
How do you place someone under arrest and not tell them that they're under arrest, but yet perform protocol that is only acceptable once they're under arrest?
Okay. Well,
Correct.
let's talk about those controlled substances. We were talking about mushrooms, correct?
Correct.
Okay. They're found in the back seat. Where in
Correct.
the back seat?
I don't exactly remember. I know that it was in the back seat. And I know that Deputy Bruce had discovered exactly where they were at. This information was reported to me.
Okay. You don't know if it's left side, right side. You don't know if it's under something or over something or sitting on top or under a pile of clothes, or you have no idea. Fair?
Correct.
Okay.
I know that it was in the back seat.
Okay. Who owned the car?
I'm sorry, can you restate that?
Who owned the car?
Oh, I have no idea.
Okay. And let's put it this way, another person was in control of the car, as in basically the driver.
Sure, yes,
That would have been Mogul.
yes,
Yeah.
Mr. Peter Mogul.
Okay. All right. So your position is that Ms. Dean, or excuse me, Ms. Adams is, although you don't communicate it with her, is being placed under arrest for, as you put it, proximity to controlled substances.
Within her immediate control, correct?
Do you know of any law that says it is illegal to have controlled substances in your proximity?
No,
No. It's illegal to possess them, of course, but
Correct.
proximity doesn't necessarily mean possession, and possession doesn't necessarily mean proximity. Be fair?
in an argument, yes,
In an argument. I assume you're right now at your office there at the sheriff's department.
correct,
Okay? You have a TV at home?
yes.
You're in possession of it?
It's at home, yes, and it's mine.
Okay? But you're not in proximity to it?
No,
Okay? If I walk over to your office and set down a bag of mushrooms on your desk, are you in possession of them?
very soon will be. Yeah, I understand it. And no, in that particular sense, no.
Okay. Okay. I don't think I have any other questions of you. Thank you, sir.
Thank you.
Any redirect, Ms. Norris?
Your Honor, just a quick follow-up. You mentioned earlier in your testimony that the vehicle was very full of stuff.
Yes,
So was there basically only one spot for the defendant to actually sit in the back seat?
that
Was
is,
it that kind of full?
yes. It was very clear due to the vacancy of items where Miss Adams would have been sitting. And as I recall, would have been about the middle of the back seat.
Okay, so basically everywhere else is full of stuff.
That's correct.
And were the sherms found? I mean, basically, did they go through all of the stuff that was stacked in the back seat, or would they have had to have been found in the open area, or I guess more open area where Miss Adams was sitting?
I do not specifically recall where they were found. That being said, they were found pretty early into the search that was reported to me by Deputy Bruce. We hadn't reached through the level of items yet. We were still in the process of that. So from my understanding, it was brought to my attention very early on during the search. It would have had to have been found. The best way I can describe it, before the bottom. It wasn't buried within the items.
Okay, so the big stack of things in the vehicle in the back seat, it was found before you actually went through that big stack of items.
Correct.
Okay. All right. Thank you. I don't think I have anything further.
Thank you.
Thank you, Ms. Norris. Any recross, Mr. Watts?
No, Your Honor, thank you.
Any reason why the witness may not be excused, Ms. Norris?
No, Your Honor.
Mr. Watts?
I don't believe so, Your Honor. Thank you.
And Detective Akers, you're free to go or stay as you wish. The court does need to take just a very brief 2 to 3 minute recess, and then we'll be back on the record.
While we're doing this break, Jesse, can you hear me? Okay, unmute there for a moment, real quick.
Jesse, if you tap your screen of your cell phone, it should bring up your camera and your microphone.
I see it. Sorry, it took me a
Here we
minute to
are.
find it.
There we are.
Hi.
I just want to ask you, while the judge is taking a short break, do you want to talk a little bit? Do you think we need to talk a little bit here?
Yeah.
Okay, Chris, can you put us in a brief breakout?
I sure can, Mr. Watts. Miss Adams, if you'll hit that join button, please. Okay, Judge, Mr.
Yep.
Watts. Mr. Watts is in a breakout room with his client.
Thank you, Chris.
Judge, I'm not too sure we didn't. Oh, no, Mr. Watts is still there.
I just believe he's not in his chair.
Yeah. I just lost him for a minute.
Okay.
Your Honor, do you have access to the court file or have the court file?
I do.
Okay. I was just going to be referencing a filing when we get back on the record. So,
Okay. Thank
Thank
you, Amber. All right. I think we have all parties back to go ahead and continue on with the
Okay,
motion to suppress. So the court at this time will go back on the record, and the record may reflect the presence of counsel previously appearing along with the defendant. And Ms. Norris, you may call your next witness.
Your Honor, this state initially would ask that the court take judicial notice of the notice of intent filed on 24 CR 437 on February 6th, which basically includes 2 different lab reports. One that specifically addresses the mushrooms and then the rest basically speaks to several meth items.
Thank you, Ms. Norris. And Mr. Watts, any objection to the court taking judicial notice of the notice of intent referred to by Ms. Norris, filed of record February 6th, 2025?
no, Your Honor, although for purposes of today's hearing, I don't know that they're particularly relevant, but no objection.
Thank you, Mr. Watts. Court does take judicial notice of the same. And Ms. Norris, you may call your next witness.
Your Honor, the state calls Officer Raquel Dean.
Officer Raquel Dean, you've been called as the next witness for the state. And Miss, if you'd raise your right hand, I'll administer an oath. You do solemnly swear the testimony you're about to give in the cause now hearing shall be the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Please proceed with your testimony. Please speak slowly and distinctly so that we're able to take a good record. And we'll begin with direct examination by Ms. Norris.
It's Kansas. They all speak slowly.
State your name and occupation for the record.
Raquel Dean, I'm an officer with the Augusta Department of Public Safety.
And on January 25th of 2024, were you working in your capacity as a law enforcement officer?
Yes,
And did you get a call to go to Casey's that day?
I did.
And can you just explain briefly how that came to you?
I was asked by my chief, Chief Ackerman, to come and search a female that they had detained, and that's what I left to go do.
Okay, so you get to Casey's. What do you do at that point?
I get out, I meet with Chief Ackerman and also Sergeant Strobe to find the female that I'm supposed to, excuse me, search. And they led me over to her, and that's when I began my search.
Okay. And at this point, when you're doing the search, is she in handcuffs?
I do not 100% remember if she was or not. I believe she was, because I remember her arm moving to try and block a certain area that I distinctly remember searching and where I had found something.
Okay. So, where did anyone else witness the search that you did?
Yes, Sergeant Strobe and Chief Ackerman was also there.
Okay. And so you're doing this there in the parking lot at Casey's?
Correct.
Okay. And you're doing a search on Miss Adams, but prior to this, you're not involved in this investigation.
Correct.
Okay. So you're just there as a female officer because it's a female detainee.
Correct.
Okay. And what, if anything, did you find on her person during this search?
In her coat pocket, I had found a small piece of plastic tubing that I had taken out. I think it was purple and probably an inch or two long. And there was a second piece of clear plastic tubing that I had also removed from that same pocket. When I continued my search, she was deflecting, I believe, on her left side, to kind of shove me away from searching that area. I continued. I told her to stop interfering with my search, and I eventually had pulled out I believe a sandwich size plastic baggie that had contained a white powdery substance in it. And that was it, located in her left leg and abdomen fold area.
Okay. And anything else?
That was all that I had gotten off of her person.
And did you actually have her empty her pockets, or were you actually physically searching all of her pockets?
Yes.
Okay, so you didn't have her empty the pockets, like empty them on the hood. You actually physically went in and emptied the pockets yourself.
Yes, I did.
Okay. And you didn't find anything that was related to like a gun or firearm?
No, I did not.
Okay. So basically some plastic tubing, small plastic tubing, and then a baggie with a white substance in it is what you found.
Correct.
And then once you were done with the search, what did you do?
I stayed there just to have eyes on her, make sure she wouldn't leave until custody was transferred over to a deputy with the Butler County Sheriff's Office.
Okay. And what did you do with the items that you found on her?
I gave them to, I believe, Sergeant Strobe, the tubing, or I'm sorry, the baggie, and then the tubing I had given to Deputy Bruce.
Okay. So you handed those items over to other law enforcement officers?
Correct.
Thank you. I don't think I have anything further.
Okay.
Thank you, Ms. Norris. And cross-examination for the defense, Mr. Watts.
Thank you, Your Honor. Ms. Dean, do you remember giving testimony on February 10 of this year?
I do.
Okay. Now, you remember at that hearing, you gave testimony that when you arrived, it was your understanding that she had already been basically done external pat down for weapons. Is that correct?
That is correct.
Okay. And in fact, we talked a little bit at that time about you're on the fire side rather than the law enforcement side, correct?
That is the division that I am assigned to. However, I still upkeep a full-time law enforcement certificate.
Oh, I understand that. I guess cost changes are people, and I get that. Okay.
Yep.
So what you were called to do, or what you did, maybe more accurately, is a much more intrusive search as a search incident to arrest.
Correct.
Okay. Do you remember testifying on February 10th that, and I wrote it down in my notes, at that point, your words, she was placed under arrest following the search?
Yeah.
That was your testimony on February 10, correct?
Correct.
Is that still your testimony?
Yes.
So they did a search. She was not told that she was under arrest at the time. They found items on her person and then placed her under arrest. That seems kind of somewhat backwards.
In fact, your testimony is she was placed under arrest as a result of the items found during the search, correct?
Yes.
Okay. I have no other questions. Thank you.
Thank you, Mr. Watts. Any further direct examination, Ms. Norris?
Your Honor, just briefly, you did not do any investigation. This case was not even Augusta Department of Safety's, was it?
Are you asking me?
Correct.
Yeah, no, the crime that initially had occurred, from my understanding, was in the county. It did not originally occur in the city of Augusta.
Okay, so this was not Augusta Department of Safety's case.
No,
Okay, and you didn't do any investigation,
I did not.
and you basically did a search on the defendant, Miss Adams, at the request of your chief.
Correct.
Okay, and when you did the search, would there be, do you guys wear PRDs? Would you be wearing a PRD since you were in fire?
I was not, since I was in fire.
Okay, nothing further, Your Honor. Thank you.
And any further cross-examination, Mr. Watts?
Just one thing, Judge, and I'll be as brief as I can. You write a narrative in this case?
I did.
Okay. Do you happen to have it with you?
I do.
Okay. Before I ask you to look at it, who is Sergeant Strobe?
Sergeant Danny Strobe with the Department of Safety,
With which department?
with the Augusta Department of Safety.
Okay.
Excuse me.
I'm going to direct you to your narrative dated, looks like it's written Tuesday, February 6th. Do you have that in front of you?
I do.
Okay. And I look at the narrative, and you do narratives as much as possible in a chronological order. Would that be correct?
Yes.
Okay. Now, you weren't wearing a body cam, personal device, correct?
That's correct.
Did you have a chance to review any other officers' personal devices before you did your narrative?
I did not.
Okay. Only reason I ask that is because it's pretty common for officers to review their narratives or review their cameras as they're recording, as they're writing narratives for obvious reasons. Your third paragraph of your narrative speaks to the details of the search, does it not?
It does.
Okay. Talk about in the groin area, something tucked between the left leg and vagina and so forth.
Yes.
Okay. That's the very first sentence of the very next paragraph.
Sergeant Strobe then placed Jesse under arrest.
Okay. I have nothing else. Thank you.
Thank you, Mr. Watts. Anything further, Ms. Norris?
Your Honor.
Any reason why Officer Dean may not be excused from the proceedings? Ms. Norris?
No, Your Honor.
Mr. Watts?
No, sir. Thank you.
And Officer Dean, you're free to go or stay as you wish.
Thank you.
Have a good day.
You too.
And state may call its next witness.
No further witnesses, Your Honor.
Thank you, Ms. Norris. Any witnesses, Mr. Watts?
Not at this hearing, Your Honor, but to be perfectly blunt, I'm surprised by that because the Deputy Bruce was subpoenaed for this hearing. And that subpoena, because I checked just before the hearing, was returned and served in this matter. Detective Akers repeatedly referred to what Deputy Bruce in particular told him. Deputy Bruce is not here. Now, that would not have been hearsay, assuming Deputy Bruce had been present. But Deputy Bruce is not present, surprisingly enough.
And Your Honor, the defense did not object to Detective Akers basically giving his testimony as he saw fit. So
Defense did not object because the state had that witness subpoenaed and returned. but did not put on.
Your Honor, again, defense did not object at the time of the testimony. So that's why the state was resting, because everything got in that the state was interested in getting in.
Oh, that's dirty.
Well,
So
Judge, at this point, I'm going to move to strike any testimony from Detective Akers that's based on what Deputy Bruce told him.
and again, Your Honor, he did not object as hearsay.
Okay, thank you, Ms. Norris. Thank you, Mr. Watson. Court finds that there was no objection made by the defense at the time of testimony of Detective Akers. So subsequently, the court does overrule and deny the same.
Fair enough.
And the
Your Honor.
court does note that Deputy, I think it's Deputy Bruce,
Yes, sir.
was subpoenaed, and the return of that subpoena was filed with the court. Thank you, Mr. Watts.
Judge, no witnesses at this hearing at this stage would obviously like to be heard. The burden, of course, rests with the state here.
And argument by the state, Ms. Norris.
Your Honor, we would ask that the court find that the defendant's motion to suppress should be denied. Law enforcement had dogs run around the vehicle. They alerted. Mushrooms, or what appeared to be illegal mushrooms, were found where the defendant had been sitting in the vehicle, which was she was a passenger in, but like I said, it was found where she had been sitting, and it was noted that there was so much stuff in the vehicle that there would have been only, basically one spot where she could have been sitting, and it was that area that they were found almost immediately. She was then searched incident to arrest by an Augusta Department of Safety female officer, and then transported to the sheriff's office for interviews. Your Honor, it appears that the search was incident to arrest for drugs, and we would ask the court deny defendant's motion to suppress based on the legitimate search incident to arrest.
Thank you, Ms. Norris and Mr. Watts.
Thank you, Your Honor. Well, that's a nice theory, Your Honor, but it doesn't bear with the facts that we've heard here today. This case turns on some really fundamental, important things about the order in which officers do things. Ms. Adams is subjected to 2 searches. One of them is very quick, and it's as soon as she removed from the car, the Deputy Akers says he didn't observe it, but he cannot imagine under any circumstances that a pat-down search would not have been done, particularly given the circumstances of this case with the report of firearms. Although it turns out they weren't actual firearms, that doesn't make any difference. Firearms being displayed from the vehicle. Ms. Adams, and no one disputes that Ms. Adams was given a pat-down search following her removal from the rest of it. The order matters a lot. And the testimony that matters is not from Detective Akers, who wasn't there. He didn't observe the search. He didn't observe the pat down. He didn't observe them being removed from the car. He didn't observe much of anything. He got this second or third hand from other officers who were there. Interestingly enough, the psilocybin that the state relies on as the basis for her arrest, the state didn't charge her with. They charged the owner and driver of the vehicle, if I remember correctly, with the psilocybin. They did not charge Ms. Adams. So they didn't think it was attributable to her enough to charge her, but now they're going to rely on that arrest. Again, Detective Akers did not see and did not observe. What we have, in fact, is testimony from the person who conducted the search firsthand. Officer Dean arrives to do what she describes as a much more intrusive search. It is a search incident to arrest. It is a search into pockets. It is a search inside the clothing. It is a search, as she describes it, inside the folds of the stomach between the leg and the vagina. It's a search incident to arrest. The problem is that there's no arrest yet. And she makes that incredibly clear in her very own statement, and it could not be any clearer. She makes the written narrative as she testified that Sergeant Shelby, by the way, an Augusta officer there at the scene, not secondhand, firsthand, Sergeant Shelby then placed Jesse under arrest. And by the testimony of Officer Dean, who conducted the arrest, placed under arrest as a result because of the items found during the search. What the state seeks to do is to search the defendant, find the items, and then justify that very search as a search incident to arrest for the arrest that has not been made yet. You don't get to do that. You don't get to arrest a person or search a person thoroughly, a search incident to arrest, then arrest them, and then claim that that search is a search incident to arrest. Now, Detective Akers says this is a fluid situation. I'm sure it is. There are a lot of agencies. The problem that Detective Akers has is he's that second agency. He's not there at the time this search is conducted. The persons who are there, the person who was there, the person who was there most directly makes it very clear. There was a intrusive search conducted, and then the defendant arrested as a result of the items found during that intrusive search. And that is what you absolutely cannot do. That intrusive search requires, when you're talking about a person, in almost every circumstance, a search incident to arrest. You can't do a search incident to arrest and then make the arrest. Thank you, Your Honor.
Your Honor, if I might be heard just briefly in rebuttal.
Yes.
Your Honor, Mr. Watts has apparently forgotten already what Detective Akers has already said. Detective Akers was on scene almost from the very beginning. He wasn't there when they were taken out of the vehicle, but he was the one basically watching the dog search the vehicle, watching the vehicle be searched, and then making the decision to have a law enforcement officer who is female to come do the search incident to arrest, because they were arresting Miss Adams. He was the one making all of those decisions. He makes it sound like Officer Dean, who is on fire and not involved in this whatsoever, other than to do a search incident to arrest because this defendant is female. That is her only involvement. She's not there. She doesn't know. That's what she said. That's what she wrote in her report, but it's not Augusta's case. They're there for backup only. The decisions are being made by Detective Akers, and he mentioned it more than once while he was on the stand, that he was the one that made the decision that she should be arrested. He was the one that everybody was bringing information to. He was the detective on the scene that was calling the shots. So I would disagree. State's position still stands. The motion to suppress should be denied. And again, I think Mr. Watts not clear on what Detective Akers was saying. I'm not sure if he wasn't listening or what, but either way, Your Honor, we would ask that the court deny the motion to suppress.
Thank you, Ms. Norris.
And I would also note for the court, Your Honor, we did not charge Mr. Mogul with the psilocybin mushrooms possession. He was charged with a lot of things, but that was not one of them.
Court makes inquiry to counsel because I don't have available the read back today, but it's the court's understanding that Detective Akers testified that he placed the defendant under arrest before the intrusive search, but the defendant was never advised that she was under arrest.
That is
that
as I recall, Your Honor.
Is that counsel's understanding, Ms. Norris
Yes, Your Honor.
and Mr. Watts?
Judge, I have that recollection. I'm not sure how you do that, but okay.
Court makes inquiry to counsel. I'm not familiar with how someone is placed under arrest without knowledge being communicated to the defendant of the arrest. I'm unaware of any case law to that effect.
Your Honor, I think
Is
Detective Akers,
effective. Yeah,
Your Honor, I think Detective Akers was basically stating, or at least that it was kind of my understanding, that he was not discussing what was going to be happening with Miss Adams with Miss Adams. He had made the decision to arrest her and called in for the search. He just wasn't necessarily telling her this information, but he was making those decisions with other officers as they were proceeding through this whole case. I don't really think it's necessary that he has to tell her for it to be a legitimate arrest based on the search they did of the vehicle and them finding the contraband. I mean, whether he tells her or not, she's, you know, under arrest and she's being searched. Incident to same. And if she's actually in handcuffs, it's probably fairly obvious.
I would be very open to any case law that council may be aware of that's relevant to this issue.
Judge, I don't know of any case law of this issue. I guess the problem I have with the state's position is if I carry the state's position to its logical conclusion that the decision to arrest is an arrest. And the decision to arrest, while it may, an officer may make a decision to arrest someone, that doesn't mean it's effectuated. If I were an officer, I could sit here in the office and decide to arrest Miss Norris. That doesn't mean she's under arrest. We have to do something in order to place her under arrest that's going to, either by words or actions.
And Your Honor, I think there are plenty of
Communicate to
actions
her.
that they took thereafter.
Thank you, Amber. Please let me finish.
Sorry, I thought you were.
That's going to have to communicate to her in some way that she's been placed under arrest. It might be words, it might be actions. There's got to be something that's relevant here. The interesting thing about this is Officer Dean, who doesn't testify to this in February, by the way, but testifies to it here, that she may have been in handcuffs while she's placed under arrest. I have done dozens of cases, as I'm sure Ms. Norris has, where persons are placed in handcuffs as detained at a scene, but officers are very quick to point out that that's done for personal safety reasons and not because they're under arrest. So the admission or the placing a person in handcuffs by themselves doesn't define arrest either. The legal standard as arrest is placing a person in a confinement where they are not free to leave isn't really very helpful either, because you could say the same thing about detention. And we know there's a distinction between detention, which Ms. Adams is clearly being detained, and full-blown arrest based on probable cause. It would be my position. Again, I don't know of any cases that speak to this sort of remote arrest, where a decision is made to arrest someone, and the argument is made that that decision to arrest is itself an arrest, that there doesn't have to be some action taken or statement made to clearly communicate that there has been arrest. I don't know of any case where an arrest is done by mere decision. It's much the same as custody. An officer can claim that a person's in custody on a pursuit, for example, but until such time as they actually catch the person and detain them in some way, they are not in custody. So I don't know of any case law that says that the decision to arrest is by itself the arrest.
Thank you, Mr. Watts. And further argument, Ms. Norris.
Well, Your Honor, I believe Detective Akers noted that the three individuals out of the vehicle, including the defendant, were detained, but that they were basically being watched. They were not in handcuffs and they were wandering or, sort of, meandering there in the parking lot where all of this is happening. So it didn't appear that they were already in handcuffs. And then the decision to arrest, there are actions taken thereafter. The law enforcement calls in a female officer to do a search incident to that arrest. That is accomplished. Other items are found, but I think because of the Augusta officer basically doing the sheriff's department a solid Mr. Watts is calling whatever she says as actually what's happening when she admits she's on the fire side. She was just there. It was not an investigation. It was not even Augusta's case. It was the sheriff's department's case. So it was the sheriff's department who was making the calls. And so even if the sheriff's deputy did not say specifically, you are under arrest, the actions taken by the law enforcement officers lead you, he said, either you have to say it or you have to take an action. Well, there were actions taken, several of them thereafter, after the decision was to arrest her based on what they found in her seat in the SUV after the search of the vehicle.
The only time they have to read you your rights is if they are going to be asking you questions. If they're not questioning you, they don't have to read the Miranda rights.
Based on a dog hit by the sheriff's office. And I don't
Thank
know
you,
of any
Ms. Miller.
case law one way or the other, Judge, without, any further research.
I will note,
Well,
I will note just in passing, Your Honor, and this is outside the record, and I understand that. After reading Deputy Bruce's narrative, I understand entirely why the state did not call him.
all right. All right. The court subsequently has had an opportunity to consider the testimony that was taken here today. The court does find that there was action taken by law enforcement. Court subsequently does adopt the argument of the state here too, and subsequently does overrule and deny the defendant's motion to suppress.
Would the court consider withholding that final decision until Deputy Bruce can actually be brought in to testify? Perhaps a motion to
Well,
reconsider?
I think, Miss Norris, I don't know what Deputy Bruce is going to testify to, but I think it is an unusual circumstance where an individual is subpoenaed and the return is made, and then that individual is not available for testimony.
Your Honor, there were multiple witnesses we subpoenaed that we did not call.
Okay. Well, that is true. All right. The court will stand with the decision that's been rendered here today.
Will the court consider a motion to reconsider with Deputy Bruce's testimony?
I think that would be appropriate. Yes, I think that's a proper forum to put it in. Let me see. Let me go off the record at this point to get a time for a motion to reconsider with Deputy Bruce being present.
And if I inquire with Amber, I think Deputy Bruce is actually now former Deputy Bruce. Is that correct?
That is correct. He's no longer with the sheriff's office.
Let me do this. We're off the record. Amber, can you call over to the sheriff and see if we've got everybody here today. See if we might be able to locate where he is.
I doubt the sheriff's office would be much help with that. He's no longer with them. I have his contact information, but
Okay.
like I said, I was not concerned about it. Defense did not object. So I just blazed right through. And like I said, there were multiple other witnesses that were subpoenaed that I didn't call either. So
That is correct.
I have his address and we have contact information, but I don't know that I can necessarily get him here in the next, 5 minutes. And I have a full day this afternoon. So as do you.
I understand you do. So we'll just need to go through scheduling for a motion to reconsider with Deputy Bruce present. It's Mr. Watts's motion to reconsider with Deputy Bruce being called to testify. I think it's appropriate for the defense to have the burden to subpoena in Deputy Bruce. Can you give that information to Mr. Watts at this point in time so he has that available for subpoena purposes?
Your Honor, he
Judge,
can get it from the subpoena that's already on the record.
That's
In the
what I'm
record.
doing right now. Yeah.
You got it? Okay.
I have a address for Deputy Bruce on the subpoena. He has, and he was served by tack and mail at that address in this case.
Okay. And what address do you have?
And Your Honor, I'd prefer that we
I-
not put that on the record.
Yeah, I'd prefer we
It's-
not on a
it's-
public.
It's, okay, you want to go off of Zoom? I mean, you want to go off of YouTube and communicate?
And Your Honor, he has the proper address, the one that we
I
have that's on our
Okay.
subpoena. He has that.
That's all I
I
need.
don't want to put that out on Zoom.
Yeah.
That we will not put that out. We've got the proper address for a motion to reconsider with Deputy Bruce being subpoenaed in by the defense. And Chris, I was gonna suggest a motion date and time that we might have available, criminal motion. And Chris, can you hear me?
Judge,
Yeah.
would April 28th at maybe 1:30? I think we're gonna have a jury trial the next day, but we could do that. That would probably be about the soonest we could do it.
Yeah, I don't know if that's too soon or if that's appropriate. Today's
Or do you want to go a
the
little further out?
17th, probably a little bit out, further out.
Okay. Maybe May 12th at 9:30. That's the day before another jury trial, but we could fit it in there.
Judge,
Okay,
it looks like when I'm in front of Judge Webster that morning.
Okay.
Well,
all morning.
I think I take that back because I don't think that's correct. I think that case has been converted to a felony and I don't think it's in front of Judge Webster at all anymore. Neil Beeben, I don't believe that's a felony matter at all. Give me just a moment, Your Honor. Let me grab that file.
Yeah,
Yeah, it actually was a felony. Now it's a misdemeanor.
Oh, it's the other way around.
Yeah, so you are in
Okay.
front of Judge Webster,
Okay.
likely.
Yeah, I'm in front of Judge Webster then.
okay. And she would be on a docket basis most all morning.
Oh, yes, that's
Yes.
true.
Do you think we could do,
And I'm gonna have to do it early, Judge, because I'm in front of Judge Ricky at 10. So
10?
that morning's not a good one.
Okay, our next date, Chris?
May 19th, we have about that whole day.
Well, I know, I'm in front of Judge Crum at 10 o'clock on, looks like 1, 2, 3 cases. Docket, looks probably a prelim docket. Although I haven't pulled those files.
It's sentencing
Ricky-
docket, Jim.
Sentencings and Judge Ricky at 1:15, and then of course Judge Crum in the afternoon for the 2:30s.
Yes, for the PHC. Okay.
I would say, Chris, if you could avoid Mondays, they're not very good for
Yeah.
Yeah.
either one of us.
Okay, hey guys, is Wednesday, well, probably that will be somebody's evidentiary hearing day though, too.
I can't keep track of what days, which judge has got a Wednesday
Yeah.
on. There's
But
probably a
yes,
schedule out
generally
there
Wednesdays
somewhere.
are prelim days.
They're
for most folks. So
prelims.
if you can do Tuesday or Thursday, maybe?
Oh, let's see what we can do. Right now, well, that one. Okay, May 27th, we're open about all day. And May 29th, both of those were open about all day.
The 29 works better for me, 27's jury trials, and there's also other stuff already set.
Sure.
So maybe in the afternoon on the 29th?
Yeah, that works.
How about 1:30?
Okay, so May 29 at 1:30. I think we've got everyone that is agreeable to that. So court will go back on the record and the record may reflect the presence of counsel previously appearing along with the defendant, Miss Adams. The court will schedule the defendant's motion for reconsideration for Thursday, May 20, 2025 at 1:30. And this is a motion for reconsideration of the motion to suppress with Mr. Watts responsible for the subpoenaing of former Deputy Bruce.
And Your Honor, that's the 29th or the
May
20th?
29th,
May
Okay.
9th at
20
1:30.
May 29, 2025 at 1:30. I'm sorry if I misspoke.
And Your Honor, then we would remove the pretrial and jury trial that are set April 25 and April 29 officially.
Any objection, Mr. Watts?
No, Your Honor.
And I don't know about speedy trial on this. Is there any objection to this being counted against the defense?
Judge, it would have to be a motion to suppress is always counted against the defense. So yes, it would count against the defense.
Okay. So 1:30, May 29, 2025. This is the motion to reconsider.
Okay, I did remove those from our schedule for the PTC plea and the jury trial for this month.
Thank you, Chris.
Just to double check, Ms. Adams, did you get those dates? The April 25 and 29 dates are removed. You do not have to be here for those. However, we will have a hearing much like this one on May 29 at 1:30.
And Ms. Adams, you are on mute.
Yes, I got that.
Okay,
Okay, and Ms. Adams, the court does retain you on the bond that you have previously posted. I do order you to stay in contact and communication with Mr. Watts and your bail bondsman. Keep them advised all times. Current address, telephone number, place of employment. And the court does order you to be back present here by Zoom on May 29, 2025 at 1:30 on the motion to reconsider, with the defense being responsible for the subpoena in of former Deputy Bruce.
Okay,
Anything
thank
further,
you.
Miss? Thank you, ma'am. Anything further, Miss Norris
No, Your Honor.
and Mr. Watts?
no, sir, thank you.
There being nothing further to come before the court is in recess.
Okay,
Everyone
and
have a good day.
I do still have 2 witnesses in the waiting room. Do you want me to bring them in?
Deputy Bruce wouldn't happen to be one of them, would they?
Nope.
And
Mr.
Chris, we
Fowler?
don't need to bring them in. If they have any questions, they know how to get a hold of me.
Okay, I'll just close out of the hearing.
Thank you.
Thank you.
In the matter of Charity Hahn and Jordan Phillips. It is case number 2017 DM 581. Tony Potter appears representing Jordan Phillips. Matt Olson appears representing Charity Hahn, who appears in the office of her lawyer by Zoom. This matter comes before the court at this time essentially for a status review. The court notes that there was a court proceeding back on March the 3rd. The court did ultimately take an issue under advisement, the issue of personal property value offset against a $45,000 judgment. The court has issued a decision entitled Order Ruling and Judgment regarding household goods and furnishings that was filed in the court on March 2025. So I will inquire with first, Mr. Potter, are there any other issues before this court that further hearing needs to be scheduled on or taken up today?
I don't believe so, Your Honor. I can advise the court from the last hearing. Jordan has the property listed with Cindy Carnahan as the realtor, and he has had an estimate provided to him by Burns Home Improvements for contracting work for repairs and some other issues with the house. That is $52,000 that he's going to pay so that he can get the house taken care of and then marketed. I provided that to Mr. Olson earlier this week, and so I think Jordan is in the process of getting the house listed for sale.
All right. I do note that under the terms of the decree in this case, upon Charity moving out, the property was immediately to be sold. Immediately essentially means generally without delay. Mr. Olson, is your client satisfied with the progress that Jordan is making on getting this property not only listed, but readied for sale?
Well, I guess I may inquire, sorry to answer your question with the question, Your Honor. Mr. Potter, Mr. Potter did send over the estimate, I think on Monday of this week, so I've had it well in advance of the hearing, but I guess I'm not understanding if Mr. Phillips is going to be requesting an offset from my client, or if there's going to be an additional request of the court that this estimate be split or subtracted from the $45,000 payment that he owes to my client. I guess clarification on that would assist us in how we move forward. And then to answer the court's question, I mean, it does take time. I'm assuming Mr. Phillips wants to maximize the value of the house. So, again, we're getting into the time now in the spring that I think is the quote unquote hot time of the year to list homes for sale. So we were hoping and anticipating that be done here in the next couple of weeks or whatnot. But again, I think the first question would help us at least understand what we potentially may have issue with or what we do moving forward.
All right. I think it's a fair question. To answer the court's question, Mr. Olson, first of all, the court would just make the observation in the view of the court, it's not Charity Hahn's responsibility to subsidize updates and improvements that would enhance market value. Now, I don't know if that's what's going on here, but that is often the case, especially on high-end properties. Second of all, I've looked at the language in the decree, anticipating this issue might eventually come up. Quite frankly, the language of the decree, which is in place in this case, states no duty to preserve the real estate property in any defined condition. There's no definition or even suggestion regarding ordinary wear and tear and what that would mean in the context of this case, nor is there even some general, as attorneys often try to do, reserve jurisdiction of the court on any and all matters dealing with the fairway property not set forth herein. None of these clauses exist. Therefore, in the view of the court, there is nothing in this decree involving this property for this court to either construe or enforce. Therefore, if there is some legal right or remedy that Jordan Phillips has, he can pursue it, just not in this case. There's nothing for this court to act upon in this regard, because I have no provision in the decree to enforce. Therefore, I can't really answer the question other than that, Mr. Olson. Anything else, you just need to talk to Mr. Potter about.
Okay, and that clarifies, Your Honor. I appreciate it. On that note, then, I don't think we have any issues with the little bit of delay that's occurred as the house is not yet listed, and I do understand the provision of the journal entry of judgment decree of paternity. The only housekeeping items that we have, Your Honor, is Mr. Phillips was slated to pay $71.34 in child support beginning this month, April 1st. He's only paid $3,000, which was the prior obligation that he had. The court already referenced, but there's a court order with respect to child support. We filed a motion in November of last year. The court did retroactively modify child support dating back to January 1st, and then the court outlined in its prior order that Mr. Phillips was going to pay an additional $2,032 per month for April, May, and June to get caught back up. So there's where the $71.34 comes from. That payment has not been made in full. So we would request that immediately be rectified and fixed as soon as possible, if not today. The other part, Your Honor, is if the court would recall, there's provisions in the same journal entry for reimburse. Well, there's not provisions. Mr. Phillips was to pay the utilities for the home. My client ended up covering those. Mr. Potter and I have already worked out through an agreed order reimbursement for the utilities. There were 2 installment payments that were to be made to Ms. Hahn. Mr. Phillips has already made installment 1 payment, but he has not made installment 2. The second installment payment is $19,951.94 for utilities that my client has paid. That has not been paid either. So again, we would request that be done as quickly as possible, if not immediately, because again, these are amounts of money that my client's paid out of pocket, and we've already agreed upon the reimbursement. It just needs to be taken care of by Mr. Phillips.
That child support repayment, that's more than I make in a month. That's wild. That's a lot of money.
All right, Mr. Olson, when was the $19,000 installment actually due?
I was apologize, Your Honor. I'd have to go back and look at Mr. Potter and I's agreed order.
The order says that it's
The
due
one
from
that
the
was- Okay,
proceeds
and I
of
maybe
the
made
sale.
a mistake there. Sorry, Tony, go ahead.
I'm sorry, I didn't mean to interject. I
Nope.
know what the order says. It says it needs to be paid from the proceeds of the sale.
Okay.
Okay.
And I didn't have that clear. I apologize.
All right. And I'll also note, Mr. Olson, that his obligation is to pay this enhanced amount during the calendar month of April. The court doesn't define it by particular date. If he makes the rest of the payment by April the 30th, he's in compliance in the view of the court. Of
Understand, Your Honor.
course, I would expect that it would be made fully by April the 30th.
It will be, Your Honor. I'm sure it's just an issue of communication with accountants and things, and just to make sure that we're all on the same page. The utility issue was ongoing over 7 years, and unbeknownst to Jordan, so we're trying to correct that issue as well. I appreciate the court's comments as far as the information that's in the decree, and I understand what the word immediately means. Unfortunately, I wasn't involved in drafting this order, and so we're trying to take into account when the property was vacated, Jordan's work, and getting all of those things coordinated. I believe that he is trying to be proactive in getting this done. I don't feel like there is any delay, but I certainly can review those issues with him. As the court can see now, he's joining us, so it's not that he's turning a blind eye. I think that probably my office sent him the wrong link for today's hearing, so I know that we are moving forward with the case.
All right. Obviously, you haven't listed with a realtor. I'm sure that Jordan will be following the realtor's recommendations about how to get the best possible price. And it also might, if improvements to the property are made, it might actually facilitate a prompter sale, which benefits everyone.
I would assume so, and I think that is his plan. Correct, Your Honor.
And I have no doubt that Mr. Olson will carefully monitor this situation and bring the matter back before the court if he is dissatisfied with the progress that's being made.
Yes,
I do
sir.
appreciate Charity's patience as Jordan attempts to get the property ready for sale and actually selling it. All right. Good luck to the parties in that regard. Mr. Olson, anything further?
No, it's time, Your Honor.
Mr. Potter?
No, Your Honor.
Very well. And if there's nothing further, the Hahn and Phillips matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
Thank you, Your
Thanks,
Honor.
Tony.
Entitled State of Kansas versus Brian E. Stiles. It's case number 2025 CR 70. Mr. Stiles appears in the office of his attorney, James Watts. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for evidentiary preliminary hearing. Is an evidentiary hearing still requested, Mr. Watts?
It is, Your Honor.
The state may call the first witness, Ms. Norris.
Thank you, Your Honor. The state calls Jeffrey Noel.
All right. If Mr. Scove is intended to be a witness, let's go ahead and put him in a waiting room. All right. Mr. Noel, if you could raise your right hand, I'll administer an oath. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Very well. You may question the witness, Ms. Norris.
Please state your name and occupation for the record.
Jeffrey Noel. I'm a sergeant at the Butler County Sheriff's Office
And how long have you been with the sheriff's office?
since 2010.
And what is your job at the sheriff's office?
I'm the sergeant over the Civils Offender Registration and Warrant Division.
Okay. Were you working your capacity as a law enforcement officer on February 12th of this year?
Yes,
And as part of your duties, on that day, were you out serving or attempting to serve warrants?
I was.
And at that time, did you have a warrant or warrants for Mr. Stiles?
Yes, I did.
How many?
May I look at my report?
Sure.
Here's, we had 2 Butler County warrants, and then you also had 2 municipal El Dorado warrants, so 4.
Okay, so 4 warrants. Were they misdemeanors, felonies, both?
One of them was a felony.
Okay. And the other 3 were misdemeanors?
The two city warrants were misdemeanors. The other one, I'm not sure. It looks like it was from a CR criminal case. I don't recall if it was a misdemeanor or a felony.
Okay. So at least one felony, though, you were out to serve warrants on Mr. Stiles.
Yes.
And where did you go to serve that, and what happened?
We arrived, we pulled up at 1401 South High Street in El Dorado, just south of the traffic way there on High Street. As we pulled up, I observed a male subject in a black hoodie with a hood over his head. And he was looking down and walked away in a kind of a quick fashion.
And did he fit the physical description of Mr. Stiles?
Yes.
And are you familiar with Mr. Stiles?
At the time we'd received the warrant, I don't know that I met him in person.
Okay. And on the screen, do you see the person that you eventually identified as Mr. Stiles?
I do.
And can you describe him and his surroundings?
He's wearing a dark colored t-shirt and he's sitting next to Mr. Jim Watts.
Okay. Your Honor, we would ask that the record reflect that he has identified the defendant, Brian Stiles.
Record so reflects.
Thank you. And who was with you when you approached this? What is it? A house in the 1400 block of High?
Yes, it's a house. It was Deputy Thornhill, Travis Thornhill.
Okay. And how far away from you was the person in the hoodie?
It was a relatively close distance. I was parked on the street, on the right-hand side of the street. The house would have been on the other side of the street, and he was a little bit in the yard and a little bit farther south, but not too far away.
Okay. And you said that he appeared to walk away quickly.
Yes. I felt like he was avoiding us, and it was suspicious to me, so I began following. It had snowed just prior to that, so I ended up following and quickly noticed that the tracks in the snow had gone back behind the house into the field behind it, and he was nowhere to be seen, but there was tracks.
Okay. So did you continue to follow the tracks?
We did. We ended up following the tracks back through the property. We lost it for a little bit and then found the tracks again. Ultimately, it was a little bit over a mile that we ended up following the tracks and across the river at least once. Took about 50 minutes before we ended up finding the individual.
Okay. And you said something about the river.
Yes. We went through the property, following the tracks, and then it ended actually crossed to some railroad tracks and then down into to where the river was and ended up crossing the river and followed it for a little while. And then we picked up the tracks again. Eventually he was spotted with a drone. And I believe he had fallen in the river as well.
So he went over the river and through the woods, and did he end up going to grandmother's house, or did he skip that part?
And then gotten back out. He was eventually picked up near the water treatment facility by other officers.
Okay. And did you he was taken into custody, I'm guessing, at that point?
He was identified and taken into custody.
Okay. And do you know who that officer was?
Lieutenant Scove with the El Dorado Police Department was part of that. There were multiple other deputies and officers as well.
Okay. And where did he go at that point?
He was taken into custody. EMS came out and looked at him. He was suffering from some medical concerns because of the temperature. He was transported to Susan B. Allen Hospital where they treated him, and then he went to jail after that.
Okay. So did you see him once Lieutenant Scove and the others took him into custody?
I went to the jail and sat with him, or not the jail, excuse me, the hospital, and sat with him at the hospital, and then ended up meeting with him later at the jail.
Okay. What did he look like when you had contact with him?
At the hospital?
Right.
By the time I got there, they already had him undressed and in like a gown and medical hospital clothing. His clothing was wet. He was very cold, shivering.
Okay. And did you have opportunity to interview the defendant at some point?
Yes. Later at the jail, I did.
Okay. And what did he tell you about what happened that day?
In the beginning of the interview, I showed him a copy of our Warrant Wednesday posters that we put on Facebook and asked him if he had seen it. He told me he did. That the day that he arrested, he saw it.
And the day that you arrested him, was that a Wednesday?
I'm not sure. I'd have to look at the calendar.
Okay.
No, but they get posted every Wednesday. I think it was, but I don't want to say for sure without looking at the calendar, whether it was a Wednesday.
Okay. So he's telling you that he has seen the Warrant Wednesday of himself
Yes.
prior to you showing it to him.
Yes. When I showed him, he'd seen it. He told me he'd already seen it.
Okay. So he knew that he had warrants for his arrest.
Yes.
Okay. And what else did he tell you about what had happened?
Then I showed him a map where we had drawn what we suspected was the route that he took. He looked at it and agreed that it looked to resemble something similar to the route that he did take when he was running or walking or trying to get away from us. And then I also showed him some screenshots from the drone footage and was told that he knew that we had drones looking for him because he had heard it on a scanner, a police scanner, which was on his cell phone app.
Okay. So he was using a cell phone app to basically, I guess, figure out where law enforcement was to avoid them.
Yeah, to listen to our radio traffic so he'd know what was going on our side.
And did he talk to you at all about the getting in out of the water?
He did.
And why he was doing that?
I showed him a screenshot of him in the water and asked him if he fell or he jumped in. And he told me he was in the water a few times, just trying to get away. And I asked him if he's trying to get away, and he responded yes or yeah.
Okay. And did you ask him whether he had seen you when you first came up to the 1401 High Street address?
If I can just consult my report for a second.
Sure.
I asked him to just try to figure out why he was, trying to get away from us. Or and he told me that he was scared and he had turned the scanner on his phone basically right as he was leaving when we pulled up.
Okay, so he did see you and Deputy Thornhill, or some deputies?
Yeah, apparently so.
Well, when he was leaving, when I showed up, he turned on the scanner and walked away from us because he was scared. So I don't know if I asked that specific question, whether or not he saw us, but judging by the fact that he switched on the scanner and left the area and he was scared.
And he was scared. Did he tell you why?
Because he had never had felonies before and he had misdemeanors cases before, and he knew the warrant was for felony.
Okay, so Didn't want to go to jail?
Right.
Thank you, Sergeant. I don't think I have any further questions, but Mr. Watson will have some follow-up for you, okay?
Mr. Watts, do you have questions for this witness?
I do, Your Honor. Deputy, how you doing?
Good.
Let me ask you kind of at the start. You go to a house on High Street, correct?
Yes.
1401 South High, and that's south of town, kind of down by the bypass, correct?
Yes.
In fact, I think it's actually south of the bypass. Is that right?
Just south. Yeah.
Okay. So that's kind of the starting point. To go to, I assume you're looking for Mr. Stiles when you go there?
Yes.
Okay. If I understand it correctly, as you go there, you don't find him, but you see this person with a hoodie up walking quickly away, which you believe is Mr. Stiles. Would that be fair?
Yes.
Okay. And that starts a chase isn't the right word, a track that goes for about a mile, give or take. Is that right?
Yes.
It circles around through some fields, crosses the Walnut River, or at least a creek at some point, maybe more than once. Correct?
Yes.
Okay. And during this chase, again, isn't the right word, that this joint hike maybe, you see him at times, you don't see him at times, you're following foot tracks most of the time. Would that be fair?
We actually never had a visual on him. We lost him really quickly. Foot tracks were what we were following.
Okay. So you're following his tracks because you believe that this is Mr. Stiles, that he's going through the field and you're following him. Okay. Here's my question for you, sir. Over the course of this mile or so that this took place, did you ever at some point identify yourself to this person you're tracking as a law enforcement officer?
I never had that opportunity to.
At some point during this, even at the beginning, do you ever I demand that this person stop?
I don't believe I did. He was gone out of sight pretty quickly.
How long did this whole thing take?
I believe it was approximately 50 minutes.
Okay. Almost an hour. All right. And this is what, mid-February. It's cold.
It was cold, yes.
Yeah.
Just snowstorm was like the day prior.
By the way, in the cold and snow, anything particularly unusual about a person having their hood on their hoodie up and kind of having their head down and the hoodie up?
Not just the fact that a hoodie's up in the cold, but people's demeanor sometimes you can do this for several years and certain things just kind of catch your attention.
I guess this is what the last part of it. Anything illegal about wanting to avoid contact with law enforcement?
If you're interfering with the service of a warrant, I believe so.
Okay. But as you noted, you never identified yourself as a law enforcement officer, nor did you give a command to stop.
We do have the word sheriff on our vest. And we're in uniform.
Okay. You never commanded him to stop.
No, I didn't have the opportunity.
And you can't even know with certainty that he knew at what the time when he takes off, at least, that you're a law enforcement officer, do you?
I would think that after listening to the scanner, he knew people were looking for him.
Well, that's not what I asked you, sir. When he first walks away there at the 1400 address, you don't know with certainty that he's even aware that you're law enforcement, do you?
With certainty, I can't say 100%, no.
Okay. But nothing else. Thank you.
Any further questions for the witness, Ms. Norris?
Your Honor, follow-up on that.
I'll allow it.
Sergeant, would you look at the last paragraph of your amended affidavit? Starts with during the interview.
Okay.
Second line.
Okay. Apparently he told me that he saw two deputies arrive on scene and proceeded to walk away.
And when you say on scene, is that the 1401 address?
Yes.
And that address, is that an address where defendant is known to live?
Yes. It was the address that we had where he was living.
Okay, so that's why you went there.
Right.
And were you able to actually, were you basically getting out of the car when you see him fleeing, or have you been up to the door? You said you were parked across the street, so I guess.
I had just pulled up. We hadn't gone to I hadn't gone to the door or anything yet. We were just pulling up, and this person in the hoodie was leaving the area.
Okay, in a suspicious looking way.
Right.
You've seen other people do, because you serve papers and warrants all the time.
Right.
Okay, so instead of just going up to the house and knocking on the door, you followed that person.
Right. At that time, I went and looked for the track, see where he was going, hoping to contact that person. And then quickly noticed that no, this person went into the pasture, and at that point, I basically decided that he had trying to get away from us, that person.
Okay, and while you're tracking the footsteps, did the shoe pattern ever change from in the yard?
At one time, actually, there was a horse that was back in there, and it delayed us more because the tracks went two different ways, and we ended up having to go in circles and found the tracks and then continued on the correct pattern.
Okay, so but the tracks that you ended up following throughout this were the same tracks that you saw in the yard made by the person in the hoodie.
I mean, they were tracks in the snow. We didn't really examine the tracks too closely. It had just snowed, so there wasn't a lot of tracks, but.
Okay. Nothing further. Thank you, Your Honor.
Any follow-up questioning necessary, Mr. Watts?
No, Your Honor.
All right. Officer Noel, you can stay with the meeting or leave it at your choice, but if you stay with the meeting, I would ask you to mute yourself. You have further witnesses to present, Ms. Norris.
No, Your Honor. Thank you.
Does the defendant intend to present evidence at this hearing?
No, Your Honor. Would ask to be heard briefly.
I'm sorry?
Would ask to be heard briefly, Your Honor.
Yes.
But no witnesses. That's
Okay, go ahead with whatever
okay.
presentation you wish to make, Mr. Watts.
Judge, I think the question here is not whether or not Mr. Stiles is avoiding law enforcement. The question is, under these circumstances, is doing so is a crime. My mother-in-law, before she passed, anytime law enforcement was around, she got immediately nervous. If a law enforcement officer gets behind her and she turns left, then turns right, and turns left and turns right, the law enforcement officer is clearly following her, turns left and turns right, even assuming she has a warrant for her. Is she committing a obstruction? I think the answer to that is no. If the law enforcement lights up his lights and orders her to pull over, is she now committing a crime? I think the answer here is yes. Had law enforcement at some point identified themselves as law enforcement, something beyond wearing the shirt, and ordered Mr. Stiles to stop, and then he continues to run, I think you have an interference here. But on the facts we have here, avoiding law enforcement, even if you know you have a warrant, is not by itself a crime. We've heard no testimony that he ran when ordered to stop. We've heard no testimony that he offered any resistance when ordered to surrender himself. What we have is, I don't really want to talk to law enforcement right now because I know I have a warrant, and so I'm going to leave. They followed me, and that follow runs for about a mile until ultimately he is found with another officer. Interestingly enough, that other officer who might have arrested him, I think that Mr. Scov, and I don't have a narrative from Officer Scov in my reports, but there's nothing that indicates that at that point he resisted, that he fought, that he attempted to flee when law enforcement ordered him to stop. I think a crucial element here is missing, that law enforcement never ordered him to stop, and I don't think he's obligated to turn himself in, even if he knows he has a warrant. I just don't think this rises to the level of obstruction, Your Honor.
Is officer identification an element of the crime?
Judge, I don't have a copy of, let me pull up the statute here.
No, Your Honor, it is not.
I thought that would be your answer, Ms. Norris, but Mr. Watts seems to think that is an inherent element to this offense. And hasn't the standard that's been used in the past, he either knew or should have known that they were there to execute process?
Well, the old standard, Your Honor, was that there had to be substantial interference. I think that standard has largely fallen by the wayside.
The standard now is knowingly, so know or should have known. I would agree, Your Honor.
Watts, I'll give you a moment if you're looking up something.
The standard under the subsection that is charged by the court or by the state here on A3 is knowingly obstructing, resisting, or opposing. Now, I guess my question is walking away from law enforcement when they have not ordered him to stop obstructing, resisting, or opposing?
I don't know. Is jumping into a river to avoid law enforcement and freezing your arse off? You can't tell me the guy didn't know he was running from the cops.
There's nothing in the statute that requires me to turn myself in, even if I know I have a warrant, which is what essentially the state's asking my client to do.
All right.
My position is walking away from someone absent an order is not obstructing, resisting, or opposing as defined by the statute.
But based on the evidence presented, wasn't that the net effect of his actions?
It may well have been. Did it make law enforcement job more difficult? It may well have. I don't think my client's required to make law enforcement's job easy.
They're just not supposed to make it more difficult, according to the statute. It
Well,
would appear.
if making it more difficult constitutes obstructing, resisting, or opposing.
All right. Ms. Norris, I want to make sure on this. Has the state filed an amended charging document, or are we under the original charging document?
Your Honor, we are under the original charging document that was filed February 14th. I referenced an amended affidavit earlier when I was talking to the law enforcement officer.
All right. This isn't the same question raised by defense counsel, but the court will raise it because the court has the responsibility to raise its jurisdiction at any stage of the proceedings. How is it that the court could construe the charge in this case as a felony charge? There's absolutely nothing in the charging document that would indicate that this was charged as a felony, except for the statement at the end that it's charged as a level 9 non-person felony. The text is obviously extremely bare bones. It's the typical throw all elements of the possible crime in there and hope that you catch it. There's absolutely no factual specificity other than the date and the individual involved. Though obviously the evidence in this case certainly makes it clear exactly what the officers were there to serve. But how does this become a felony case based on this charge?
And Your Honor, I will admit that the specificity, we would ask basically that the court allow the amendment to basically, or in the discharge of any official duty in the case of a felony, which would encompass a felony warrant, which is what was, well.
It just doesn't say that. That's all.
Your Honor, I'm aware of that, and I would be moving to make the proper amendment to same.
Your position, Mr. Watts?
As to the amendment, Judge, I know that these cases, these charging documents are freely amendable up until the point essentially where you begin a jury trial. My issue is my client, to be perfectly blunt and perfectly honest, is aware of the basis for this being a felony. I knew going in that that was going to be the basis for the felony. Frankly, if I object to it, the state's simply going to refile the case, and we're going to have to do this all again.
All right. Court will allow the amendment, but I do want you to state for the record exactly what language you intend to add, counsel, and where you intend to add it. I think you kind of outlined that. I want to make sure. Are you simply going to add felony before warrant?
Your Honor, it would be at the end, in the discharge of any official duty, in the matter of a felony in violation of KSA 215904.
Very well. Court will allow the amendment. Mr. Watts, you have an interesting argument here, and the court's considered it. However, the court is aware that in similar cases, I think that the current state of the law is there is a should have known standard here. With that standard in place, the court does find that there's probable cause that the felony crime now of interference with law enforcement has been committed and that the defendant, Brian E. Stiles, committed it. Mr. Stiles will be bound over for trial on what is now clearly a felony charge as charged in the charging document. I'll ask if he wants the charging document to be read to him at arraignment. Mr. Watts?
Judge, we have a copy of the information before us, even noting the coming amendment. We'd waive that formal reading, enter a not guilty plea at this time, ask the case be set for appropriate pretrial and jury trial settings.
All right. But he used the same date as before, Mr. Watts, earlier today, setting jury trial on June the 10th, starting at 9:00 a.m. unless announced differently later. I will establish a pretrial conference for 10:00 a.m. by Zoom, Friday, June 6th. Mr. Stiles, it works well when such pretrial proceedings are held with you in your attorney's office, just like today. So I'm going to order you to appear at James Watts' office for your next court appearance and no other location unless approved by advance by this court. Any questions about that, Mr. Stiles?
No.
All right. So in your attorney's office, we'll conduct by Zoom pretrial conference Friday, June 6th, 10:00. Jury trial set the following week to start on June the 10th. As always, I encourage the parties to confer with one another to see if some sort of agreed upon disposition of this charge can take place. Ms. Norris, is there anything further that you believe we need to address at this time?
No, Your Honor, thank you.
Mr. Watts, anything further currently?
I don't believe so, Your Honor. at this
Very
time.
well. Then if there's nothing further, the Brian Stiles matter will currently be in recess. County, Kansas, case entitled State of Kansas versus Albertus J. Bilby. It's case number 2025 TR 472. The defendant, Mr. Bilby, appears in the office of his attorney, James Watts. Jared Regier appears on behalf of the state of Kansas. This matter comes before the court at this time for an evidentiary preliminary hearing. Is the state ready to proceed?
Yes, Your Honor.
And I trust, Mr. Watts, that your client is still desiring an evidentiary hearing be held.
That is my understanding, Your Honor.
All right, Mr. Regier, you may call your first witness.
Thank you, Your Honor. The state calls Officer Zachary Hobson to the stand.
Your Honor, if I
Could you
may,
raise your right hand, please? You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your Honor, would ask witnesses be sequestered, please.
All right, anyone else that's on this meeting as a proposed witness will need to wait in a waiting room, Zoom waiting room, until they're let in to testify in the case. Mandy, if you would take care of that. May question the witness, Mr. Regier.
Thank you, Your Honor. Would you please state your name for the record?
Zachary Hobson,
Where are you employed?
City of Rose Hill, the Rose Hill Police Department.
Okay. And what is your professional title within the Rose Hill Police Department?
Police officer.
Okay. And how long have you worked as an officer?
3 years with Rose Hill and 5 years with another department.
So approximately 8 years overall?
Yes, sir.
Okay. Were you on active duty in your professional capacity on Saturday, September 22nd, 2025?
Yes.
Where were you at?
I was approximately the 1200 block of North Rose Hill Road.
Okay. And is that in Butler County, Kansas?
Yes, sir.
Okay. Do you recall if you were in a vehicle or on foot at the time?
I was in a marked patrol vehicle.
Okay. And then was your marked patrol vehicle stopped or in motion?
In motion.
Okay. Could you please describe your surroundings for the court as you recall them?
So I remember the Dollar General would have been on the northwest corner of the road. There's a bank across the street from that, and a Casey's on the southeast corner at the intersection of Rose Hill Road and Rosewood.
Okay. And at this particular intersection, did you observe any vehicles that specifically drew your attention?
I had been made aware by another officer of a truck entering town from the north that I had known to have been driven by Albertus Bilby.
Okay. And how did you come to know the identity of the driver of this vehicle?
I'd had interactions with him before on unrelated events.
Okay.
Specifically, he was identified as the primary driver of that vehicle several months prior at a tire shop in town where he was having maintenance done on that truck.
Okay. And this individual, Albertus Bilby, do you see that individual present in the Zoom conference?
Yes, sir.
Could you please point them out and give a brief description for the court?
Let me pull up the list of people that are here. He's not currently on my screen, but I did see him earlier. I don't know that I can pull up his photo at the moment because he's in a separate room. I see 6 participants currently. Just those of us that are on this specific testimony.
Officer, are you unable to adjust or enlarge your screen?
No, I can bring up a list of participants in the chat log, closed captions, and that appears to be about it.
Your Honor, given the technical difficulties, the state would be requesting direction as to how to proceed. If the witness is unable to identify the defendant due to a mere technical issue, that will present some issues. I'm not sure if that's a quirk of this current format or not.
All right, I'm just a little unclear. Who can you see on your Zoom screen?
I see myself, Mandy, James Watts, Jay Rieger, yourself, and Court 31.
There is an individual seated with Mr. Watts. Can you see that individual?
Can't bring up his, let's see, maybe. No, I cannot bring up his video.
Okay, so you can see Mr. Rieger and you can see the court, but you can't see Mr. Watts?
I can see that he's present, but I can't bring up a video feed of his camera.
Okay.
Well, maybe I can. Hold on. Okay, never mind. I see him.
Your Honor, may I re-ask the question?
You may.
Officer, do you see Albertus Bilby present in the Zoom conference?
I do, sir.
Could you please point them out and give a brief description for the court?
Yes, sir. He's a white male, thin, wearing a black button-up shirt, the white patch on the sleeve, dark hair.
Your Honor, let the record reflect that the witness has identified the defendant.
The record so reflects.
Officer, on February 22nd, 2025, did you observe the defendant entering this particular truck that you had referred to on the record?
Yes.
And where did you see this defendant enter this truck?
In the Dollar General parking lot at the gas pumps.
Okay. Are there any particular physical features about this defendant which makes him especially notable to an average bypasser?
Yes, he's on his driver's license, 6'7" and about 170 pounds. He's easily noticeable from a distance.
Okay. And when you observed the defendant, did the physical characteristics that you observed correspond with that?
Yes.
Okay. Going back to the truck itself, was there anything about the truck that that you consider a violation of the law?
Yes, sir. Did not have a license plate.
Okay. Did you ever see the truck exit the Dollar General parking lot?
I did.
Okay. And do you recall if the truck entered a roadway specifically?
It did. It exited the parking lot from the northern entrance, made a left-hand turn on a northbound Rose Hill Road.
Okay. And after it entered the northbound road, did you pursue this truck?
I did.
Okay. And why did you pursue this truck specifically?
Based on the traffic violation of not having a license plate, failing to stop on exiting a private drive, and me having known it being driven by Albertus Bilby, whose license is suspended, I attempted to initiate a traffic stop using lights and sirens.
Okay. So is it your testimony that after you began pursuing the truck, you activated your emergency lights and sirens?
I did.
And did you activate your emergency lights and sirens before or after you saw him fail to yield before entering the roadway?
It was roughly about the same time as I was leaving another parking lot to the south, and I had to get through a red light.
Okay. And after you activated your emergency lights and sirens, what happened next?
I followed the vehicle. I noticed I was doing about 98 miles per hour, and I was not catching up to the truck. I turned on my same direction radar and noticed the truck speed of 88 and a 55.
Okay.
Continued to follow it onto westbound 160th, which was gravel. And because of the fresh snow and the loose gravel and the mud, I lost line of sight contact around 143rd and 160th, which is 55th Street in Sedgwick County, where we were at that point.
Okay. Now, going back slightly, you mentioned that you activated your radar. Are you certified to use this equipment?
Yes, sir.
And are you familiar with its operation in your ordinary course of business?
I am. I'm an instructor, radar instructor.
Okay. Do you use testing on this equipment to check that it's working properly?
Yes, sir.
Could you please describe this testing for the court?
Sure. There is a self-test that I initiate at the beginning of every shift, which checks the internal systems of the radar and verifies that it's working properly. There's a second test that I do with two tuning forks to verify that it is still accurate.
Okay. And how often does this testing take place?
At the beginning of every shift.
Okay. Was the stalker radar on the date in question working properly?
It was.
How do you know?
Because I verified it at the beginning of my shift.
And did you conduct this verification process personally?
Yes, sir.
Okay. When you mentioned that you observed a speed using your stalker radar, can you confirm that the radar was specifically measuring the truck you were in pursuit of?
Yes. So there are two displays on the radar. There's a display for the strongest signal and a display for the fastest signal. So it would filter between other traffic that is slowing and yielding to my patrol car and Albertus's truck. It would filter those two and display his as the fast speed.
Okay. And again, you may have mentioned this previously, but did you measure a specific speed on the defendant's truck?
Yes, sir. 88 miles per hour.
And what was the legal speed at this location?
55.
Do you consider that a violation of the law?
Yes, sir.
What violation specifically?
I believe it's KSA 1557. It's just general speed rule.
Okay. While you were in pursuit of the defendant's truck, did you ever see the defendant exit the lane he was driving in?
More than once, yes.
Okay. And how many times would you say?
On an actual laned road twice and on a gravel road once.
Okay. When the defendant failed to maintain a single lane, maintain his lane, what did he do specifically?
He crossed a double yellow line into oncoming traffic and forced cars to the shoulder to avoid a collision.
Okay. How many cars did you observe being forced to the side to avoid a collision?
On the first instance, there was one car, and on the second instance, right before Southwest 160th, there were two vehicles.
So is it your testimony that as a result of driving into ongoing traffic, two vehicles had to depart from the roadway to avoid a collision?
Yes, sir.
Okay. Did you ever observe the defendant make a turn?
Yes.
Where did this turn take place?
From northbound Rosehill Road, he made a left turn onto westbound Southwest 160th.
Okay. Prior to making this turn, did the defendant announce an intent to signal in any way that you can recall?
No, there was no signal.
So is it your testimony, Dave, that you did not observe any turn signals in operation prior to the turn?
That's correct.
Okay. Did you ever see the defendant approach a stop sign in his vehicle?
Yes, sir. One.
Where was this stop sign?
At Southwest 160th and 143rd Street.
Okay. Did this defendant yield to this stop sign?
No, sir. He ran the stop sign.
Did the defendant stop at any time before or immediately following reaching the stop sign?
No.
Okay. Now to circle back slightly, you had previously mentioned that the defendant was driving on a gravel road. Could you please describe what occurred at that moment for the court?
Sure. The road condition was not great. It was muddy and snowy. So much so that even at, I think I was doing around 80 miles an hour, it was very difficult to maintain control of my patrol car, which is 4-wheel drive.
Okay.
And there was, I believe it was either FedEx or UPS truck that had to yield to the shoulder for Albertus. And there were 2 cars in the oncoming lane that were also on the shoulder that had to have yielded to Albertus because of the crest of the hill. They would not have seen my patrol car yet. And as I came over the hill, they had already moved to the shoulder.
Did you ever determine the defendant's speed while he was driving on this gravel road?
No, I was trying to keep my car on the road. I wasn't trying to operate the radar at the same time.
Okay. But is it your testimony today that when you were trying to approach the defendant's vehicle, you were driving at a high rate of speed on this gravel road?
Yeah, based on pacing and my catch-up speeds at the maximum safe speed of around 80 miles an hour, I was not catching him, so he would have had been doing at least 80 himself.
Okay. And when you saw the defendant driving on this gravel road, did you see any debris as a result of this speed?
There was some dust and rocks being kicked up, but other than that, no.
Okay. In your experience as a law enforcement officer, in situations where debris is being displaced by moving vehicles, is it possible that such debris can result in damage to surrounding property?
It could.
Okay. Did you ever successfully make contact with the defendant?
I did.
Okay. And where did this contact take place?
At the defendant's residence on Flatland Trail.
Okay. What happened when you made this contact?
Initially, I made contact with members of the defendant's family and was able to convince them to have Albertus step out of the house where I made initial contact with him.
Okay. At this residence, is this located in Butler County?
No, sir, it's in Sedgwick County.
Okay. So is it your testimony today that when you activated your emergency lights, initially you were in Butler County, but the incident ultimately terminated in Sedgwick County?
That's correct.
Okay. And again, I apologize for jumping around slightly. During your pursuit that you had testified to on the record, did you ever deactivate your emergency sirens or emergency lights?
Yes, sir. When I lost visual contact with the vehicle, I turned off my emergency equipment.
Okay. And at what point did you lose visual contact with this defendant?
It was around 143rd and 160th. It would have been just west of there. Again, hill. And in my recollection of events, I did not remember exactly where Flatland Trail was. So myself and the officer that was backing me on this pursuit circulated the area briefly to see if we could find the vehicle after we had deactivated our emergency equipment, before putting the address into GPS, which we got from dispatch, and attempting contact with Albertus at his residence.
Okay. So to recap slightly, you've already testified that as to the gravel road, the failure signal while turning, the running the stop sign, and the other vehicles having to enter the shoulders of the road to avoid a collision. Did all that occur before or after you deactivated your flashing signal lights?
Before.
Before? Okay. Did you ever arrest the defendant for any violations of the law?
I did.
Okay. And what were these violations?
Evade and elude, reckless driving, driving while suspended, illegal display of tag, no proof insurance, and the traffic violations, which are speeding, improper driving on a lane roadway, fail to signal, fail to stop when exiting a private drive. Those are the ones I remember off the top of my head.
Okay. Barring and redirect, no further questions, Your Honor.
Mr. Watts, any questions for this witness?
I do, Your Honor. Officer, you wrote a affidavit in this case, correct?
Yes,
Do you have it before you?
I have my narrative, but I do not have the affidavit.
Okay. Are they the same thing essentially?
They're close. The affidavit's a bit abbreviated for charging purposes, but they're very close.
Okay. The reason I ask that is I note at the start of this, you identified a vehicle that is associated with Mr. Bilby, correct?
Yes, sir.
Okay, and I say that only because I presume it's a car you see around town and you kind of know who drives it.
Yeah,
Okay. It's Rose Hill, small town, kind of know who drives what. Fair?
fair.
Okay. So the idea is the vehicle is associated with Mr. Bilby. You also, when I wrote from your affidavit and look in the report, you note a person matching Mr. Bilby's description duck into the back seat.
That's correct.
Okay. You never did get a look at the face of the person in the vehicle to identify him as Mr. Bilby, did you?
I did.
And when did you do that? This during the 80 mile an hour behind the car?
No, as I was driving through the Dollar General parking lot as he was at the gas pumps, there was very little window tint on the truck that he was driving. I could see through the back window into the back seat where he was leaning in.
Okay. Last thing. Mr. Bilby's location, his address, where you basically you went to his house to pick him up, correct?
Yes,
That address is in Sedgwick County,
correct.
right? You certified as a Sedgwick County officer?
No, sir.
And at that point, as you indicated, you had essentially called off the pursuit due to road conditions, snow, etc.,
And a break visual contact. Yes, sir.
and lost sight of the car.
Correct.
And not only had to do that, but get onto GPS and figure out where Mr. Bilby lived so you could go to the house, correct?
That's correct.
Okay. How long between breaking off contact to arriving at Mr. Bilby's house?
Maybe 10 minutes. I don't know off the top of my head, but that's my best guess.
Okay. Last thing, and I'll let this go. When you arrived at the house, you spoke with two persons,
Yes, sir.
a female, but you don't identify.
Mhm.
I assume a younger female?
Yeah, she's between 17 and 19, maybe younger.
Okay. And she indicated basically you didn't want to talk to her, or she didn't, excuse me, she didn't want to talk to you.
Correct.
Okay. That is her right, of course.
Absolutely.
Okay. And shortly after that, Jess arrives, who you believe is Mr. Bilby's father.
He is.
Okay. Mr. Bilby, Jess, basically told you to come back with a warrant, didn't he?
Yes.
Okay. Did you come back with a warrant?
No, sir.
Why not?
Because I was able to convince Jess and the other female that was there to have Bilby step outside.
Okay. How would you convince Jess and the other female to have Mr. Bilby step outside?
Well, I explained to him that because he had contact with the female over the phone, they had been texting each other back and forth about what I don't know. It's my assumption that it was about Albertus running into the house. I don't know that for sure, but that it was interference with law enforcement to allow Albertus to remain in the house, knowing that after I'd explained to him he'd ran from us and we had charges on him, to allow him to stay in the house and evade us.
Okay, I have two questions about that. One, how were you aware at that point of text between Mr. Bilby and this female?
I'm not 100% certain that that's what happened, but based on some observations I had before Jess had arrived, they were already in contact with each other. So when the female mentioned to me that her father, that Jess was on his way home.
Okay,
when I how long that Jess would be, she looked down at her phone as if he had been in communication with her. I don't know that is for certain. I didn't search the phone. There were no search warrants done on any phones.
Okay.
Yes.
So there's text between the female and Jess, what you're referring to, correct?
That's a possibility. I don't know that for sure.
Okay, fair enough. Now, here's what I guess I'm trying to figure out. You're telling Jess and or the female that them declining to let you enter the house without a warrant is interference?
With the knowledge they had of Jess being in the house, it would have been yes.
Okay.
Because I had explained to them that we had charges on him and that he was under arrest. And if they allowed him to, if they harbored him in that house, it would have been interference.
Harboring a fugitive. It's a crime.
Okay. Well, I would disagree with you as to that, but we'll leave that in. at another matter for another time. I have nothing else, Your Honor.
Any reason why this witness cannot be excused at this time, Mr. Regier?
Not at this time, Your Honor.
All right. Mr. Hobson, you can leave the meeting or stay with it at your choice. If you do stay with the meeting, I would ask you to mute yourself.
Thank you, sir.
All right. Do you intend to call any further witnesses, Mr. Regier?
Yes, Your Honor. The state would call Officer, forgive me, Your Honor. Yes, Your Honor. The state would call Officer Harshbarger to the stand.
Sir Harshbarger,
Yes, sir.
go ahead and join us fully with video. I will administer an oath to you at this time. If you'd raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may question the witness, Mr. Regier.
Thank you, Your Honor. Would you please state your name for the record?
Daniel Harshbarger,
And where are you employed?
City of Rose Hill Police Department.
Okay. And at the City of Rose Hill Police Department, what is your professional title?
Patrol officer.
Okay. And how long have you worked as a law enforcement officer?
Since 2021.
Okay. So approximately 3 to 4 years overall?
Yeah.
Okay. On Saturday, February 22nd, 2025, were you on duty in your professional capacity?
Yes, I was.
And where were you at?
City of Rose Hill.
Okay. Do you recall specifically where you were within the city of Rose Hill?
Yeah, I was on patrol and was going all through town.
Okay. And to the best of your knowledge, is the city of Rose Hill within Butler County?
Yes.
Okay. On this date and time in question, were you made aware of any specific vehicles in particular?
Yes, I was.
Could you please describe this particular vehicle for the court?
Black colored pickup truck,
Okay.
Dodge, I believe.
All right. Were you notified of who the owner of this vehicle was?
I was.
Okay. And who was the owner?
Albertus Bilby.
Okay. Had you ever had any contacts with this truck or Mr. Bilby prior to this date and time?
That truck, no, but Mr. Bilby, yes.
Okay. Approximately how many times had you had contact with Mr. Bilby, would you say?
Several times. I don't know the exact number.
Okay, just as a guesstimate.
At least 5 prior encounters.
Okay. And do you recall where any of these encounters took place?
All within the city limits of Rose Hill.
Okay. Is it safe to say that prior to this particular date and time in question, you had a certain degree of familiarity with Mr. Bilby?
Correct.
Okay. Did you ever locate this this black truck you had previously referred to?
Yeah. Previously to this day?
On the date and time in question.
Just over at the fuel pumps at Dollar General.
Okay. And when you located this truck, were you in a marked patrol vehicle?
I was.
Okay. Did you ever park your marked patrol vehicle?
I did.
And where was your marked patrol vehicle parked?
The parking lot of the Rose Hill City Hall.
Okay. Where is this Rose Hill City Hall parking lot compared to the Dollar General parking lot?
Pretty much across the street, just a little catty corner, but
Okay.
and pretty much shares the same cross street.
Okay. Would you describe these two parking lots, other than the roadway, to be adjacent to each other?
Yes.
Okay. Did you when you parked your patrol vehicle, did you observe the black truck?
I did.
Okay. Was there anything about the black truck that struck you as unusual?
From where I was, no.
Okay. Did you observe anything about the truck that you would consider a violation of the law?
I did not specifically.
Okay. Did you ever observe Mr. Bilby around this truck?
I did.
Okay. Did you ever observe the face of Mr. Bilby around this truck?
Yes.
Okay. Do you see Mr. Bilby present in the Zoom conference?
I don't see anybody other than
Let me see if I can change my screen here.
Okay.
Oh, there we go. Yes, I do.
Okay. Could you please point Mr. Bilby out and give a brief description for the court?
He is thin built, medium length hair, tattoos on his arms, wearing a dark colored shirt, blue jeans.
Your Honor, let the record reflect that the witness has identified the defendant.
Record again so reflects.
Officer Harshbarger, did you ever see the defendant enter this black truck?
Yes, I did.
Okay. Did you ever observe any individuals in the black truck besides the defendant?
I did not.
Okay. Were you able to observe, well, let me rephrase that. Once you observed the defendant enter this black truck, what happened next?
He started to leave.
Okay. Would you describe when he left, would you describe that as a slow or fast moving exit?
Unaware because of where I was positioned at that time.
Okay. Did you ever pursue the defendant in the black truck?
I did. I joined a pursuit with Officer Hobson.
Okay. Did you ever activate your emergency lights during this pursuit?
I did.
Okay. And when you say that you joined Officer Hobson, approximately how far from your patrol his patrol vehicle was your patrol vehicle?
When I initially joined, he was probably a half mile to 3/4 mile in front of me.
Okay. During this pursuit, did you ever did this pursuit take you through any city limits?
Yes, we left Rose Hill city limits.
Okay. During the pursuit through Rose Hill city limits, did you happen to observe the speed at which you were driving?
I did.
And what was the speed?
I believe my top speed was 102 miles per hour.
Okay. As a result of, although you were driving at the speed, did you ever successfully reach the overtake the defendant's black truck?
I did not. I just caught up with Officer Hobson.
Okay. Did you ever successfully make contact with the defendant?
No.
Okay. Barring a redirect, no further questions.
Watts, any questions for this witness?
None for this witness, Your Honor. Thank you.
All right. Officer Harshbarger, you can stay with the meeting or leave it at your choice. If you do stay with the meeting, I would ask you to mute yourself.
Thank you.
You. Mr. Regier, do you have any further testimony to present?
Not at this time, Your Honor, barring, of course, any, although the state would reserve the need for rebuttal as is appropriate.
Watts, do you intend to present evidence at this hearing?
Not at this hearing, Your Honor. Thank you.
Very well. The court, having heard the evidence presented, finds there's probable cause that the crime of flee and elude law enforcement has been committed, and that the defendant, Albertus J. Bilby, committed it. Albertus Bilby is bound over for trial on count one of the information, the only felony count involved in this case, or does note the continued pendency of Class C person misdemeanor improper display of tag and driving while license is suspended or canceled, a Class B non-person misdemeanor also. We will proceed to formal arraignment at this time. Mr. Watts, does your client desire the charging document to be read to him?
Your Honor, we have a copy of the charging document before us with waive its formal reading, enter a not guilty plea at this time. That's the case be set for appropriate pretrial and jury trial settings.
Court will establish appropriate pretrial conference and jury trial settings. June 10, counsel, for jury trial.
Should be fine, Your Honor.
No objection from the state, Your Honor.
Establish a pretrial conference the week before, Friday, June 6, 9:00 a.m. The pretrial conference, Mr. Bilby, will be done by Zoom with you appearing in your attorney's office, just like you did today. Okay?
All right.
So it'll be a Zoom pretrial conference, June 6th at 9:00 a.m. The defendant ordered to appear in the office of his attorney, James Watts. The jury trial, should it go the following week, currently scheduled to begin on Tuesday, June 10. The start time will be 9:00 a.m. for that jury trial unless announced differently at pretrial conference. So June 10 for jury trial, June 6, 9:00 for pretrial conference by Zoom. Those dates now established. Mr. Regier, is there anything else we need to address currently?
Your Honor, I'm not sure if the court is making any orders concerning the bond. Also, if the court is not aware, before today's hearing, my office did file an amended information, adding an alternate charge to count one, both flee and elude, merely under different subsections of the statute. Is the court finding probable cause for just the first or both alternatives?
I wasn't aware of the amended charging document, counsel. However, the court's ruling today was based on the reckless driving component of flee and elude as alleged in your original count one.
Very good, Your Honor.
All right. Mr. Watts, anything further at this time?
Nothing else, Your Honor. Thank you.
Then if there's nothing further, the Albertus Bilby matter will currently be in recess. This meeting may be entitled in the matter of the marriage of Brianna M. Kirkpatrick, now Helton, and Caleb B. Kirkpatrick, respondent case number 2021 DM 135. Beginning with petitioner, would counsel announce appearances for the record, please?
Good morning, Your Honor. Steve Turley on behalf of the petitioner, Brianna Helton. I appear by Zoom. Brianna is with me at my office. She also appears by Zoom.
Susie Locke on behalf of the respondent, Caleb Kirkpatrick, who appears in my office and via Zoom.
Matter comes before the court at this time upon a motion for attorney fee determination and final judgment filed by Mr. Turley on behalf of his client on January 27 of 2025. Ms. Locke, I received what looks like a Kansas Payment Center history report from you. Mr. Turley, do you have that?
I do.
Okay. Mr. Turley, what relief are you seeking today?
There are two issues before the court, Judge. One, well, before I proceed, do you have my exhibits that I mailed out?
I do.
Okay, great. There are two issues before the court. One is whether interest should be added to the judgment. And the second is whether my client and I should be awarded attorney's fees, and if so, in what amount. Within the materials that I sent you, Judge, one was Exhibit 5, which is a proposed order. That order is agreed to by counsel, but you'll notice, Judge, that there are some highlighted parts of the document. Those highlighted parts are where we have open questions and need some direction from the court. So we've got the journal entry pretty much worked out once we get a decision from you, Your Honor, on these remaining items.
I notice your creativity in the title, order, Mr. Turley.
What would you have called it, Judge?
Mr. Turley, this court is of a strong belief that each order and journal entry filed in a domestic case should define exactly what's covered by the terms of the order, at least some summary. I only make that comment is that it's difficult when looking through a listing of documents, especially an electronic file, when everything's called order, journal entry, order, journal entry, without definition as to what these orders and journal entries are all about. It just seems that the title should really explain a little bit better. That's not really what is before the court today, Mr. Turley. I do appreciate any drafting efforts that were made prior to today. I see paragraph 6 has question marks, and that's regarding your request for attorney fees.
Yes, the question marks are where we have open questions.
I'm looking at paragraph 7, which is your attempt to do a breakdown of disposition of proceeds.
Yes, Judge. The open questions are the attorney's fees and the additional interest, if any. The other amounts are agreed to.
Why is interest an issue, Ms. Locke?
Your Honor, the additional interest that has been occurred from this date of the sale until the date of this hearing, we don't think should be applicable because the funds have been held in Mr. Turley's account. We also suggested that the amount of the judgment should be released by an agreed order with the remaining balance held until these remaining issues could be resolved. But Ms. Helton she wanted to wait and resolve everything at once. So our position is we shouldn't be paying interest on a judgment when the judgment could have been paid, but we didn't have the opportunity to pay it because the funds are held pursuant to the court order.
Mr. Turley?
Ms. Locke is mostly correct that the funds remained held. I agree with her that she had proposed at one time that we do a partial distribution. And I explained at the time that I didn't agree. This wasn't my client's decision, it was mine. Part of the reason being attorney's fees is an issue before the court, and that would have required me to do additional work, which would have just further exacerbated the problem that we perceived to have existed. So, and then I will also observe that this hearing is approximately 2 months later due to no fault of my client or mine. I'm not saying it's anybody's fault, but we weren't the ones who requested the continuance. So our position is interest accrues by law. It's mandatory. It's not discretionary. Statute's very clear on that. And so that one's simple, though. I think you've heard everybody's pitch on that issue.
All right. The court's prepared to rule on the interest issue. A combined judgment was entered of record on November 22nd of 2024. It will be the court's ruling regarding what interest can be enforced against the fund. We'll start at 11/22 of 2024 on a judgment amount of $29,438.70. Interest will terminate as of the date the money was actually deposited into Mr. Turley's trust account. What date was that, Mr. Turley?
I don't have that answer at my fingertips, but Ms. Locke and I can figure that out.
All right. At that point, Mr. Kirkpatrick had essentially paid what he owed. He didn't physically turn it over perhaps, but at that point, the funds that belonged to him were under the control of Mr. Turley's office, and the court deems that to be the appropriate date to terminate the computation of interest. I don't really know what we're talking there, several $100s perhaps?
Yes.
I also will note that Mr. Kirkpatrick has been, for the most part, complying with the court's order regarding how he was to purge himself from contempt. He made appropriate $1,200 payments in November, December, January, skipped February for some reason, but then made payments in both March and April. Now, $200 of that each month is to be credited toward arrears, is it not?
Yes, and that will be included in the calculation, Judge.
All right.
And Your Honor, as a brief update, when Mr. Kirkpatrick and I were discussing before the hearing today, we both noticed the February payment. He made that payment this morning, and I sent the confirmation to Mr. Turley. So he is fully caught up on any arrears.
Well, okay. He made the February payment in April. All right. So what he did is he doubled up in April
Correct.
to make up for the payment he missed.
Yes.
All right. Well, I appreciate those efforts, truly. All right. So, Mr. Turley, is it a fair statement then the remaining issue is what, if any, attorney fees that should be allowed to your client for having to pursue her prior motion?
That's correct.
All right. And let's clarify for the record what amount you're currently seeking.
So, Judge, this is outlined in our Exhibit 6, starting at page 26 of the materials. And that's our motion. And then the next exhibit after that is my affidavit regarding my client's costs and attorney's fees. Attached to that affidavit is a billing summary with all of the entries and charges. I went through it, initialed each page, and signed that document. And then after totaling everything up, we're asking for $11,406.
Mr. Turley, let me make sure I understand. You're wanting Caleb to pay for your attorney fees in pursuing relief on behalf of your client, not related to contempt?
That's correct.
And why is that fair?
So at the trial, Your Honor will recall, basically all of the facts were related to things that Mr. Kirkpatrick either had not done in violation of a court order, those things being the contemptuous behavior, and also those things he did or didn't do that negatively affected the minor child. So these parties had come up with a parenting plan, and the evidence at trial was that there were serious concerns about drinking that Your Honor even noted yourself. And so our position is Mr. Kirkpatrick caused all of this litigation through his poor decision-making and at times contemptuous behavior. So we think that as a matter of justice and equity, my client should be entitled to her attorney's fees on everything. And as I noted in the affidavit, she was charged a significantly reduced rate as compared to my current customary rate.
All right. Ms. Locke, your client's response to this request for attorney fees.
Your Honor, we would ask the court deny the attorney's fees. Related to the parenting time, the court reduced my client's parenting time. Related to the other contempts, and the only spots where the court actually found my client guilty of contempt were the failure to pay the spousal maintenance and the child support. The court then entered a purge order, essentially, which said the contempt would be purged if you complied with paying $1,000 a month in support and paying an additional $200 a month. My client has done that. He's been compliant with the court's purge order. So that should purge his contempt. There should be no additional award of attorney's fees related to that. Additionally, there's some case law cited by Mr. Turley, and one of those is the financial needs and the ability to pay of my client. Well, as the court just noted, Miss Helton has had the opportunity to take at least almost $30,000 worth of cash that's sitting in her attorney's trust fund, a judgment that was awarded to her. But she elected not to. So we would question whether there truly is a financial need. These funds have been sitting there for 4 months now that she could have accessed, and we would have entered an agreed order for. So our position is that at this point, the award of attorney's fees is not just inequitable, it is truly a punitive sanction, and it's not reasonable and it's not appropriate.
Any reply argument, Mr. Turley?
Yes, Judge, and there's just a couple things I'd like to touch on in addition to what I said earlier in response to Your Honor's question. So Ms. Locke correctly notes that in our motion, we've cited some law for the proposition that the court can and often does award attorney's fees in a contempt situation. So as to the contempt piece of this, I don't even think that's a close call. Mr. Kirkpatrick was under a court order. He disobeyed it willfully, as Your Honor found. And importantly, in this case, this was not a situation where Brianna charged into court on some technical violation or something like that. She waited a very long time for Mr. Kirkpatrick to become compliant, or gave him the opportunity to become compliant. And as I recall, at trial, there were text messages and other things of that nature entered into evidence that showed her informal efforts to get what she was due from the agreed upon judgment. Mr. Kirkpatrick ignored those requests. She had to pay her lawyer. And so if she's not awarded attorney's fees on the contempt issue, it effectively deflates the agreed upon judgment that she contracted for and she had to enforce through the contempt motion in the first place. So as a matter of justice and equity, we think that part of it should be an easy call for the court. In all candor, Judge, as Your Honor already alluded to, the closer call in my estimation is whether Brianna should be awarded any attorney's fees on the custody and parenting time issues that were tried to the court. And there's two reasons that we think that the court should award attorney's fees there as well. One is the disparity in financial positions. I cited for the court the Dunn decision in our motion. And as Your Honor, I'm sure already knows, the Dunn decision stands for the proposition that when evaluating a request for attorney's fees, the court has to consider need and ability to pay as it would in a spousal maintenance dispute. And that's effectively what Dunn did, was expand or translate the spousal maintenance analysis to the attorney fee analysis. And so the district courts in Kansas award attorney's fees often just for that reason alone. When one party has superior earning ability and superior financial position, it is, as a matter of fairness, the party in the inferior position will be awarded their fees oftentimes just to make things fair and right. The second reason is the reason I already explained to Your Honor. My client would not have filed that motion that was ultimately granted in part by Your Honor had Mr. Kirkpatrick not made bad decisions for himself and for the child. And so is it, as a matter of fairness, is it fair that Brianna would have to spend money to protect the party's daughter because of Mr. Kirkpatrick's bad decision-making? We think that given those two things, an award of attorney's fees across the board is appropriate, fair, just, and equitable. Finally, so that's the fairness piece of this, Your Honor. The other piece of this is reasonableness. In Kansas, typically when a court rules on attorney's fees, it's a two-step analysis. Step one is whether the fee is reasonable at the outset, and two is whether it's fair under the circumstances. As to reasonableness, I would submit that my affidavit makes it quite clear that the fee is reasonable in this case. Again, Ms. Helton was charged something far below my customary rate at the moment for reasons explained in the affidavit. And the total cost was around $11,000. And so for a case taken to trial with judgment entered with only one attorney involved for much of the proceedings, I think that's eminently reasonable under the circumstances. So Brianna is indeed asking for the full $11,000 and change, but if the court is not inclined to grant full relief on that question, we would at least ask for something like $7,500 or $7,000. Unless Your Honor has any questions, that's all I have to say.
My question for you, Mr. Turley, would be to follow up on Ms. Locke's valid point. Your client has accessible to her over $34,000, which is sitting or has been in your client trust account. Why shouldn't the court consider her resources and her ability to pay your attorney fees, since she's the one that has initiated litigation, and have her pay her own lawyer?
So with regard to Ms. Locke's argument that somehow Brianna's decision not to release the money early should be weighed against her, if Your Honor is asking about that, I can respond to that specific.
No, I'm not.
Okay.
I understand her reasons for that.
Okay. So as to the general question, Your Honor asks specifically, she's got this cash, why doesn't she just use it to pay you? Well, she's going to. Like, I'm going to get paid one way or the other, whether it comes out of Brianna's dollars or Mr. Kirkpatrick's dollars. I would just observe, Judge, that especially as to the contempt, that's completely unfair to my client. He just didn't follow court orders. My client tried to get him to multiple times, as Your Honor saw at trial, and he disregarded those requests. So if she's not awarded her attorney's fees on the contempt in particular, what the court is effectively doing is reducing the court order, the child support even. That negatively impacts the child in this case, if the court were not going to award attorney's fees on a contempt. And in all seriousness, Judge, I don't think I've ever encountered a situation in my years of practice where attorney's fees are not awarded on a contempt of this kind. So, I mean, as to that issue, the court's decision is not whether to award her attorney's fees because she has money. The court's decision really is, at base, do I penalize her because he didn't follow the court orders? And I just don't think that's fair.
Currently, I'm first intrigued about how you are able to determine so readily what's an easy decision for the court and what is a more difficult one. But with that said, the court at this time does feel that justice, fairness, and equity requires that Mr. Kirkpatrick be responsible for some measure of accountability and reimbursement of attorney fees in relation to the contempt action that was filed in this case. After all, it was necessary for Brianna and her attorney to conference with each other. In other words, some sort of interview process. Mr. Turley's office had to research the non-payment items. He had to do drafting of his motion. He had to appear in court to argue the case and then present that case, and afterward draft an order stemming from those proceedings, which led to the documentation of the finding in contempt. However, the court is going to limit the attorney fee award to the matters which dealt with contempt. After all, while Brianna received some relief from the court in regards to the remainder of her motion, she did not prevail on 100% of the issues. The court deems it appropriate then to limit an attorney fee reimbursement to what this court believes is a reasonable amount for Mr. Turley's involvement in the narrow issue of contempt that was presented to the court. The court is going to allow 10 hours. And Mr. Turley, you are an experienced attorney, that you're able to charge a fair amount in conjunction with a contract with your client. The court's not going to interfere with that. But what the court's going to do, since you're wanting Mr. Kirkpatrick to pay for your fees, there's no contract between you and him. If you're wanting him to help subsidize your attorney fee bills, the court's going to utilize an amount which, after some research and thought, the court determines to be an appropriate average amount for attorney fees in this locality. And the court determines that to be a rate of $292 an hour. So the court will allow 10 hours at $292 an hour for the amount of $2,920 to be paid from Mr. Kirkpatrick's share of the fund that's being held by Mr. Turley's office. Any remaining amounts is between the attorney and the client. All right, with that attorney fee issue determined, Mr. Turley, what else does the court need to address today?
I think that's it, Judge. I do not begrudge the humor and sarcasm, but as to the title of this document, I'm open to suggestions.
Well, I noticed that you said this was a motion for attorney fee determination, journal entry or order of attorney fee determination, and whatever other matters might be covered, and determination of interest. It would make it clear then to any scanner of the documents in this file that this is the order which deals with those issues. That's all I'm stating.
Okay.
All right. Thank you, though. I appreciate your request for clarification from the court. All right, Ms. Locke, is there anything else from your perspective that we need to address here?
The only piece is the KPC overpayment, which was in line 5, I think, of paragraph 7, that Mr. Kirkpatrick will in fact get credit for all of the $200 additional payments that he made.
I think Mr. Turley had already pledged that he would make those adjustments. Am I correct, Mr. Turley?
Yes, those numbers just need to be updated through April. I agree.
All right.
No additional questions, Your Honor. Thank you.
Very well. Then if there's nothing further at this time, the Kirkpatrick matter will currently be in recess and the meeting may be ended for all at this time.
Thank you.
Okay, before going into the motion for bond reduction, Mr. Cooper, do you need to meet with your client in a breakout room?
Well, only if he tells me he needs to. No?
No.
Okay.
It'd be good for now.
Okay.
Judge, can
Well,
I ask, did Blake file a motion or not?
Yeah, I filed it on April 9th, Cheryl.
Okay, thanks.
And I see I've got the court file and I show that motion to reduce bond filed April 9. So let's see. We'll go ahead at this point in time and go on the Zoom record. Case is entitled State of Kansas versus Shane Pitman, 25 CR 135. State of Kansas appears by Assistant Butler County Attorney Cheryl Pierce. The defendant, Mr. Pitman, appears in person and by court-appointed counsel Blake Cooper. This matter does regularly come back before the court this date. This is a motion to reduce bond filed by the defendant April 9, 2025. And argument to the court, Mr. Cooper.
Thank you, Judge. Mr. Pitman has been in custody for some time now, probably close to a month. At this point in time, He has been unable to make bond at this point in time, which is set at $50,000 cash or surety. So we are arguing that the bond at this point is excessive. Mr. Pitman is a lifetime resident of Kansas in the Wichita area. We don't believe he's any risk to run. I don't think he has a history of missing court that I'm aware of. Additionally, Judge, I've said in my motion here that Mr. Pitman is diabetic. He suffers from diabetes. He's not being given correct medication or diet requirements at this point in time in the jail. He hasn't really had anybody who would listen to him about that, and has been kind of set off by himself. Frankly, for the time that he's been there in jail, he's not having those types of issues taken care of. We don't want him to get sick. Something that he could better handle himself if he were to be allowed to bond out. He would follow any conditions that the court would place upon him, Judge. I don't think there's going to be any issue, including an EMD, if the court would be so inclined. He is able-bodied and can work. He's had a job. I think he could obtain a job fairly quickly. But this is a situation, Judge, where if you place upon him even bond supervision requirements where he would check in, he would be amenable to that as well, Judge. We would just like to have the opportunity to have him out and being able to deal with this case, not sitting in there and being able to take care of his health. Even a great reduction would be helpful in this at this point in time. But with respect to what we were first asking for, is we'd ask for an OR bond with any conditions the court would deem necessary, and if not an OR bond, then something much lesser than the 50,000, is he's just simply not able to make that at this point in time.
Thank you, Mr. Cooper. Court makes inquiry. What would the proposed address be for Mr. Pitman?
Sure. Judge, let me. He gave that to me. You've got it.
I know where my house is.
Is that Faulders, Shane?
Yes, and then Lane.
Okay. That's in Wichita, Judge. It's in the Harry and Edgemore area of Wichita.
Can you respell that, please?
Yes. Faulders, Lane.
Thank you.
And any other individuals that Mr. Pitman would be residing with at that address?
Yes, I have a roommate.
And the roommate's name?
Her name is Beth. Bong, B-O-N-G. I rent from her. She's the owner of the house.
Okay. And Mr. Pitman, do you have any family that reside in Butler County, Kansas?
No, I do not.
Okay.
Does your family reside in Wichita though, Shane?
Most of them, yeah, but most of them, all the rest of my family has passed.
Okay.
Okay, so no other contacts with the community other than his residential address with the landlord, Beth Bong. Is that correct?
I have a sister, two sisters, and one's in Central County. One lives in Wichita, and the other one in McPherson.
Okay, and what are their names?
Nicole Pitman.
Nicole Pitman, and where does she live?
She lives in McPherson.
McPherson, okay.
She's a DON of nursing at McPherson Health Clinic.
Okay. And the other sister?
Natira, N-A-T-I-R-A, Treadwell, and she is a personal trainer at Genesis.
Her last name is Treadwell, and she's a personal trainer. That couldn't be more fitting.
But I see them on holidays. I don't, they're so busy all the time, you know? I've been so
And
busy working.
she's in Wichita?
Yes, she works at, I can't remember which Genesis she works at.
Okay. And do you have any proposed employment if you would make your bond?
Yes, Your Honor. I mean, again, I don't have anybody that would post the bond for me that has money. I don't really have any money, but I have several opportunities to go work. Pizza Hut. My good friends work at Pizza Hut, and they offered me a job. I was thinking the Oxford House, they could help me too. I was thinking about maybe seeing some type of outpatient treatment and doing Oxford House and them helping me with employment as well.
And which Pizza Hut?
Probably the one on close to where I'm going to be, probably on Webb Road.
Okay.
But again, I'm going to be able to, I'm not going to just leave my option to just Pizza Hut. I'm going to try to get employment anywhere possible.
Okay. Prior to becoming incarcerated, where were you employed?
I was working for DeBella Exteriors.
How do you spell that?
DABELLA Exteriors.
And what type of work did you do?
I was a sales rep for they're a remodeling company.
Okay. And any further input to the court, Mr. Cooper, pertinent information?
I don't believe so. I think we've covered it, Judge. Just simply the fact that he is from this area and obviously just wishes to stay here, and so I don't think we're going to have an issue with Mr. Pitman not appearing for court. He wants to take part in this case. And wants to get this resolved.
Thank you, Mr. Cooper. And argument to the court, Ms. Pierce.
Well, Judge, I was, first off, the information that was provided at the time of his arrest was that he was not a resident of Sedgwick County. He was actually Reno County. That may be in a mistake on his driver's license or something of that effect, but it's not what was reported to law enforcement. The second thing I would tell you is that he has quite a bit of criminal history. He is at least a C on the grid. He has a person felony as well as multiple non-person felonies, felony drug charges, as well as several forgeries. I think there's also history of failure to complete and have his probation revoked, which may have been what may have, I don't know. I was looking to see if it resulted in a prison stint, but I don't know that for a fact. So, but he does have history of having his probation revoked as well. As the court probably is aware, and looking at the criminal charges, these are level 1, level 3, level 4, level 6 felony charges. They are human trafficking charges, significant presumptive prison with his history or without his history. I asked for a $75,000 cash or surety bond, and I got a $50,000 cash or surety bond. So I don't think that a $50,000 cash or surety bond in the face of these particular charges and his criminal history is unreasonable, Your Honor. So that would be, I don't believe that a reduction is appropriate, and would ask the court not to do so. Like, as I said, there's been multiple probation violations as well as just the convictions in and of themselves, Your Honor. And I do believe that his violations did result in being sent to prison as well at the El Dorado Correctional Facility. So this isn't a first time flyer. This is somebody that's been a part of the system for quite some time, Your Honor. Thank you. I have nothing further.
Thank you, Ms. Pierce. Mr. Pitman, I've taken the opportunity to review through your file, taken an opportunity here today to try to familiarize myself with your particular circumstance. I think that a high bond is appropriate in regards to yourself. I consider a high bond to be, in your case, $25,000 cash or surety bond. And the court is going to order electronic monitoring. Actually, the court's going to order that if you do make bond, that the bond, you have a check-in, weekly check-in with court services, whatever they deem appropriate. And the court would expect you to gain gainful employment. The court, unless the court would be advised otherwise, you would be at the 1614 Falders Lane, Wichita, Kansas, at Harry and Edgemore address with your roommate / landlord, Beth Bong. And the court is mindful of your diabetic situation and your medical and diet necessities. And once again, the court would order electronic monitoring that would be imposed upon you. But the court does grant the motion to modify the bond from $50,000 cash or surety to $25,000 cash or surety bond. Any other matters to come before the court, Ms. Pierce?
Judge, I just want to clarify, that's $25,000 cash or surety with weekly check-ins and EMD, or just with weekly check-ins?
No, both.
Okay, thank you.
I want him to actually be reporting to a person weekly, and electronic monitoring is imposed upon him at all times.
Great, thank you, Judge.
And then I have a requirement of employment as well, Judge, correct?
Yes, employment, that he be gainfully employed if he's on this bond.
Okay. I just want to make sure Mr. Pitman is aware of his conditions. So,
any questions, Mr. Pitman?
Yeah, I don't have any immediate nobody to pay my bond. I don't have any family to pay. I mean, I would check in. I would go to treatment if you wanted me to, Your Honor. I would be part of the Oxford House system. I haven't been revoked on probation since 2015, and I just successfully completed and paid all my fines and fees to my federal probation on December 20th, 2023, I believe. I was released. I successfully completed that with my GED. Since then, have not had any traffic violations, anything. I've not been incarcerated at all since I was released from federal prison in May 6, 2022, Your Honor. I don't have any court dates I've missed. I understand that I have an extensive history, but I've not been in any trouble since I've been released from federal prison. And again, I successfully completed that with payment of all fines and not had any troubles at all. Your Honor, I ask if you just please just give me a chance to get out and show that I'm working and serious about this case to get this case resolved. Your Honor, again, I don't have, my mother died in 2020 during COVID, and she was the main support for me. So I really have nobody out there that would financially back me but myself. And I've been doing that since I've been released. And I've shown that without being any trouble since I've been released, no charges, anything since 2015 when I went into the system on this last charge, Your Honor. And I humbly plead with you to please. I understand the 25,000. I'm okay with the ankle monitor or anything, but I don't have any means of financial support except for myself, and I have a dog. That's it. Me and my dog are the only people I have that would, and I have a good friend that runs the Oxford House on Kellogg and Rock Road off Orm, the Orm House. I've been there before, and I just asked you, if you give me a chance, Your Honor. I don't have any money. I don't have any money. All my money is gone. All my money that I got from inheritance is gone from 2020. So I just plead with the court, please.
Thank you, Mr. Pitman. The court has taken into consideration the fact that the state initially made a motion to the court that the bond be set at $75,000 cash or surety. At the time of first appearance, that was rejected by the court. The court said a minimum bond of $50,000 cash or surety. It's coming back to the court, and what the court attempts to do is to set the minimal bond that will ensure appearance by individuals back before the court. In regards to the charges that are pending, where it would appear that these would be, and from what little I know about your criminal history, just being advised here at this motion time, it would appear that you may very well have a presumptive prison sentence. I do not know that, and that is a whole nother process that the court will need to go through. But when the court's looking at a severity level 1 person felony in count 1 and count 2, a severity level 3 person felony, count 3, a level 4 person felony, count 4, level 6 person felony, and count 5, an A misdemeanor. Mr. Pitman, I truly do understand your circumstances. You're advising the court that you do not have anyone that would assist you in regards to making your bond, but I absolutely do not believe it is appropriate to grant you an OR bond in the case. I think that a bare minimum to ensure your appearance is at the $25,000 level, subject to the conditions that I've already gone through. So the court retains the ruling that previously was set forth in this hearing, $25,000 cash or surety bond, subject to the conditions that I just enumerated. All right, any other matters to come before the court? Ms. Pierce?
No, Your Honor.
And Mr. Cooper?
Not today, Your Honor. Thank you.
And I believe that this does come back before the court May 7, 2025 at 2:30 on the preliminary hearing control docket. There being nothing further to come before the court is in recess. Everyone have a good day.
Thank you.
Jim, you want to take up Mr. Fowler?
I would. I'm looking for him online.
Okay.
Just just checked the jail. He is not there, and I'm looking for him in the.
He's at the Sally Port.
Okay. I'll need to meet with him briefly just to confirm the PSI. It should not take very long.
Okay, thank you, Jim.
If it's only going to take a minute, I'm going to go ahead, instead of putting him in a breakout room, I'm just going to step out of this room.
Well, we have the rest of the people here, so, we still need to do a breakout.
When you get done talking to Mr. Watts,
Okay.
let me know.
Okay, yeah.
Well, I think we probably have to.
I don't see him up there.
Okay, Judge, we have Mr. Watts and his client back from the breakout room.
Thank you, Chris. And Jim, did you get an opportunity to meet with Mr. Fowler? And you're on mute.
I guess I was, aren't I? Yes, Your Honor, we're prepared to proceed.
Okay, thank you. At this point, we'll go on the Zoom record. Case is entitled State of Kansas versus Emery C. Fowler, 24 CR 516. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Mr. Fowler, appears in person and by court-appointed counsel Jim Watts. Also appearing at this time is Court Service Officer Brian Smith and Community Corrections Intensive Supervision Officer Christy Ashenfelter. This matter does regularly come back before the court this date for sentencing. In anticipation of sentence, the court has ordered a pre-sentence investigation report. The court has received the same. I trust that counsel for the state and the defendant have received a copy. And before proceeding any further, is there any objection to the criminal history as set forth, which does indicate a criminal history score G as in grade? Mr. Sweeney?
No objection, Your Honor.
And Mr. Watts?
Your Honor, I have reviewed same with my client. We believe it is correct. We have no objection.
Court finds no objection to the criminal history as set forth. Therefore, it does become part of the basis for sentence herein. Before proceeding to sentence, the court will listen to recommendations from counsel as to appropriate sentence, beginning with the state and Mr. Sweeney.
Thank you, Your Honor. Your Honor, on the count number one, the sole count, the state is recommending the standard in mid-box 15 months in the Department of Corrections. The defendant would be eligible for 20% maximum good time percentage and would have a post-release supervision duration of 12 months. Your Honor, he does have 1 day of jail time credit. This is a presumptive probation case and a case where there was an assessment for Senate Bill 123 treatment. However, given a low SASE score, he doesn't qualify for the Senate Bill treatment. So the state would be recommending that he be placed on the 12-month community corrections probation. Conditions of probation, as I've reviewed them, appear appropriate, including comply with recommendations of a drug and alcohol evaluation. The only difference is that without the Senate bill, I guess that's on his own dime, whatever those recommendations turn out being. Everything else appears appropriate. As far as costs and fees associated with the case, Your Honor, the state, pursuant to plea agreement, is not requesting a fine. I did not see a KBI laboratory report, so none will be requested. We would, however, be requesting the court cost, supervision fees, community corrections fees, and attorneys and bids fees.
Thank you, Mr. Sweeney. And recommendations as to sentence, Mr. Watts.
Thank you, Your Honor. Your Honor, the recommendations of the state are in keeping with the plea agreement. We believe they are appropriate. In this case, we would join same. The only thing I would note, Your Honor, is my client asked that he be permitted to do this probation reporting over in Wichita, which is much more convenient for his travel rather than El Dorado and Butler County. I have let him know that sometimes the Wichita cases don't get as much attention, and that's not a consideration for him. He would ask to be able to transfer this case.
Thank you, Mr. Watts. Anything further from Court Services, Mr. Smith?
No, Your Honor. Thank you.
And from Ms. Ashenfelter with Community Corrections?
No, Your Honor.
Thank you. And Mr. Fowler, prior to the court pronouncing judgment and sentence upon you, is there anything you'd like to state in mitigation of your sentence? And once again, Mr. Fowler, can you hear me?
Yeah.
Okay, thank you. Mr. Fowler, is there anything you'd like to state in mitigation of your sentence?
No, sir.
Do you know of any reason why the court should not pronounce judgment and sentence upon you here today?
No, sir.
And Mr. Watts?
No, sir.
Mr. Fowler, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 15 months in prison. The court does order 20% good time credit, jail time credit of 1 day, post-release supervision period of 12 months. Subsequently, the court does find that you have a presumption of probation herein, and the court does place you on 12 months community corrections probation. The court has no objection to transfer from Butler to Sedgwick County. However, you need to make arrangements with community corrections, and they need to clear you for transfer before you report to Sedgwick County. You need to report to Butler County until that transfer has been effected. The court does impose all standard conditions of probation upon you, along with those that are set forth on page 5 of the pre-sentence investigation report. Court does order you to pay the court cost herein, community corrections fee, correctional supervision fee. The court makes inquiry. Mr. Fowler, are you currently employed?
Yes.
What type of work do you do, and is it full-time?
It's
And approximately how much do you earn per hour?
$20 an hour, and I remodel houses.
Are you pretty much full-time employed?
Pretty much, yeah.
Okay, well, the court does order that you reimburse for court-appointed attorney fees and the bids application fee. And the court does order that at $150 per month, $150 per month on for all your costs herein. Subsequently, the court does advise you, Mr. Fowler, pursuant to KSA 223608C, that you shall have 14 days after the judgment of the district court to appeal your sentence. The court advises you, pursuant to KSA 214619G, of any expungement right you may have, and the court advises you of your prohibition of possession of any firearm.
Yes.
Any other matters to come before the court? Mr. Sweeney?
No, Your Honor.
And Mr. Watts?
No, sir. Thank you.
Mr. Smith?
None from court services, Your Honor.
And Ms. Ashenfelter?
Yes, Your Honor. If I could please get a breakout room with the defendant after this hearing.
Yes, that'll be the order of the court. And do you have any questions, Mr. Fowler?
No, sir.
There being nothing further to come before the court, court is in recess. Good luck to you and have a good day.
You too.
And Judge, I believe that's the only case I have in this docket this afternoon.
Jim, that's what I show also. So I'll let you study up on that suppression motion from this morning.
Actually, Your Honor, I've already filed a motion to reconsider and sent the list for subpoenas over to Cheryl this morning.
You're on top of that.
Well, I try to be.
I got you. That was an interesting case.
I should ask, Judge, while I got you,
Yeah.
I was trying to ask Chris this. A year or so ago, you'd sent out a list of, well, it's over a year now, a list of recurring Zoom numbers. Are those numbers no longer any good?
We have a new Zoom account, so I'll send you the new ones.
Okay, is there a recurring list that you'll send out, or I just look for them?
I will send you a reoccurring link or list.
'Cause I kept that pinned on the wall so I could kind of give it to clients when they were
I
asking what
will.
Zoom links were.
I will get it sent out here before too long.
Appreciate it. Thank you.
Thank you.
Have a good day.
All right, bye-bye.
Do we have Mr. Favre or Mr. Paul?
We do not. I'm actually trying to get a hold of Mr. Aubrey.
Okay, everyone that's in the Zoom hearing will take about a 10-minute recess until 2 o'clock. Court's in recess. You want to take up cases at this point? Joe,
Ready
you
to
want to? Okay.
Let's go.
Joe, I have Makia Huggins.
Yes, sir.
Is that who you're wanting?
Whichever judge prefers to take first, I'm fine with either one.
Okay.
Joe, it's your choice. And Al, you have Makia Huggins there with you?
Yeah, go on in.
Yeah, let's take up Makia Huggins. All right, we'll go ahead and go on the Zoom record. Case is entitled State of Kansas versus Makila Lachelle Huggins. Case number is 24 CR 206. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Huggins, appears in person and by court-appointed counsel Joe Favre. Also appearing at this time is Court Service Officer Christine Donovan and Intensive Supervision Officer with Community Corrections, Christy Ashenfelter. This matter does regularly come back before the court this date for sentence. In anticipation of sentence, the court has ordered a pre-sentence investigation report. The court has received the same. I trust that counsel have received a copy, and before proceeding any further, is there any objection to the criminal history score as set forth, indicating criminal history score E as in eat? Ms. Norris?
No objection.
And Mr. Favre?
No objection, Your Honor.
The court finds no objection to the criminal history as set forth, and it does become part of the basis for sentence herein. Before proceeding to sentence, the court will take up the request filed for dispositional and durational departure by the defense and will take recommendations as far as appropriate sentence is concerned. And beginning with that motion and request, Mr. Favre.
Yes, Judge. We are requesting the court to make dispositional findings today. In the alternative, we ask the court to consider a durational finding. But Ms. Huggins, at this point, is already well into a community-based treatment program that she is being very successful at. Ms. Huggins' felony criminal history was somewhat of a surprise. We knew she had multiple felonies, but we did not think she had tripped the special rule at this time. That was what was discussed at the time of the plea being entered. Ms. Huggins has support in the community. Her mother is currently taking care of her nieces and nephews, 6 of them, ranging ages 1 to 13. And Ms. Huggins is the primary support for respite care for those children whenever her mother has to go to work or run errands or things of that nature. So we feel there's multiple substantial and compelling reasons to justify granting this departure. Mainly, the main reason is that there is a community-based program that Ms. Huggins is in and is successful at that is going to help her be a successful member in the community at addressing her addiction. which is the underlying cause of her criminal history and criminal behavior. But also, we believe that there's a substantial and compelling reason to not take away family support, family structure, especially vital family support that Ms. Huggins is currently providing for her mother and her nieces and nephews. And lastly, it is probably the least important issue, but at the time of the plea, it was discussed that we thought this would end up with her being her third felony theft as opposed to being her fourth, which would have not tripped the special rule. So it was intended that she go on probation, although obviously, you know, the sentencing happened after she picked up her third conviction for felony theft, so it just didn't plan out that way. So we think there's a compelling reason in trying to honor the intent of the plea negotiations. So we're asking the court to follow the recommendations of the PSI if the departure's granted, place Ms. Huggins on community corrections probation for an appropriate term with all standard conditions of community corrections.
Thank you, Mr. Favre.
Oh, and I apologize, as I did fail to mention, she's also employed as well in the community and works as well. That as well.
Thank you, Mr. Favre. And recommendations as to sentence, Ms. Norris.
Thank you, Your Honor. Regarding count 1, the felony theft, would ask the court assign defendant to 10 months in the Department of Corrections. Defendant would be able to earn up to 20% good time credit and would be subject to 12 months post-release. She has earned 54 days of jail time credit. As previously noted by counsel, this is a presumptive prison case based on the special rule of the 3 or more prior felony thefts. And Your Honor, counsel is accurate in that basically I think that we had some crossover. She had a Sedgwick County case that at the time when we did the plea had not been disposed of and has since been. So it does put her in the special rule presumptive prison category when we did not necessarily expect her to be there as a criminal history score E at time of plea. Your Honor, there is no restitution. The victim in this case is Walmart. They did not request restitution. The court will need to address or assess standard costs of the action to the defendant, address court-appointed and bids attorney's fees as Mr. Favre is pointed, states not requesting a fine. And I don't believe I have any further recommendations for the court at this time.
Thank you, Ms. Norris. Any further recommendations from defense, Mr. Favre?
No, Judge. We just asked the court to consider waiving a portion of her attorney's fees. Ms. Norris mentioned that, but she is working at a customer service job with more water, and I think it's $15 an hour, Mikey. Is that right?
It's 14.
14. Okay. That's all, Judge.
Thank you, Mr. Favre. Further recommendations from court services, Ms. Donovan?
No, Your Honor.
And recommendations from community corrections, Ms. Ashenfelter?
No, Your Honor.
Thank you, Ms. Ashenfelter. And Ms. Huggins, prior to the court pronouncing judgment and sentence upon you, is there anything you would like to state in mitigation of your sentence?
No, just other than the fact that since I've been out of jail, I've been trying to do everything the right way. I mean, I got a job, I've been attending church, I've been staying out of Walmart. I mean, I've been following every guideline that I was supposed to. Like I said, I thought that I was supposed to be on probation, but then a special rule had popped up. And then, I mean, now I'm back here in front of you, so I don't know. Like I said, I'm trying. I've been doing everything that I'm supposed to do. I'm successful in treatment. I don't have any problems in treatment. They actually been letting me lead the group treatments. I mean, yeah, I've been refrained from drugs since I've been out of incarceration. So, I mean, that's all I really have to say.
Do you know of any reason why the court should not pronounce judgment and sentence upon you at this time?
Any reason why they shouldn't?
Why I should not pronounce judgment and sentence upon you?
I mean, other than the fact that I'm doing what I'm supposed to, no.
And Mr. Favre?
No, Judge.
Ms. Huggins, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 10 months in prison. The court does find a special rule does exist herein that places you in a prison category. Subsequently, the court does find that there are substantial and compelling reasons to not have you serve the balance of that prison sentence. Court does find that you are having success in a community-based program. Subsequently, the court grants the motion for dispositional departure and places you on community corrections probation. You're placed on community corrections probation for a period of 12 months. Subsequently, the court does adopt all standard and recommended pre-sentence investigation report probation conditions as set forth on page 5 of the pre-sentence investigation report. And this is all for felony theft, a severity level 9 non-person felony. The court does need to make inquiry. Are you currently full-time employed? Are you working 40 hours per week?
No, sir. I can only work part-time because I have a hip disability and Social Security won't let me work over 20 hours.
Based on your lack of financial wherewithal, the court does not order reimbursement of court-appointed attorney fees, nor the bid's application fee. The court does impose all the cost and fees as set forth on page 5 of the pre-sentence investigation report. Unless I would stand corrected, I believe that's $443. And the court does order you to pay that at the rate of $40 per month. $40 per month. Subsequently, the court does advise you, pursuant to KSA 22-3608C, that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you, pursuant to KSA 21-4619G, of any expungement right you may have, and the court advises you of your prohibition of possession of any firearm.
Yes, sir.
Any other matter?
Where will I
Excuse me.
be reporting, sir?
You'll be reporting, I've placed you on community corrections. I believe that that's the recommended placement for
That's in
you.
Wichita?
Well, we will have you meet with Miss Ashenfelter immediately after this Zoom hearing in a breakout room where she will advise you about where you will meet. I do not know if I do not have any objection if you request transfer to Sedgwick County, but you have to clear the transfer first through Butler County if you're making a request for Sedgwick County.
Okay.
Any other matters to come before the court? Ms. Norris?
Your Honor, did you cover appeal and expungement rights?
I did.
Thank you.
Anything further, Mr. Favre?
No, Your Honor.
And Ms. Donovan?
No, Your Honor, thank you.
And Ms. Ashenfelter?
No, Your Honor.
There being nothing further to come before the court, court is in recess. Christy, do you want to meet with Miss Huggins in a breakout room?
I think she may have already gone in there, Judge.
Okay.
They're both
Well,
in there.
Okay, they're both in. Thank you very much.
Your Honor, I had previously said that I did not need to break out Mr. Higinbotm, but I actually need to ask him one really quick question. If that's possible for me to do that, and then I'll be ready to proceed with him.
That is possible.
Thank you.
Yeah, happy to do it.
And he's at the jail, Chris.
Good afternoon, Judge.
Hi, Richard. Richard, you want to take up your case?
Sure, we're ready to go.
Okay. I believe it is Miss Wilson.
It is. Tally, go ahead and start your video, please.
Okay, any matter to take up before going on the Zoom record?
There we go.
Good afternoon, Miss Wilson.
Good afternoon.
And before going on the record, anything to take up, Mr. Paul?
No, Your Honor, we're ready to go.
And is this Miss Norris or Mr. Sweeney?
Your Honor, this is my case.
Thank you. We'll go on the Zoom record. Case is entitled State of Kansas versus Tally Elizabeth Wilson, 24 CR 52. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Ms. Wilson, appears in person and by court-appointed counsel Richard Paul. This matter does regularly come back before the court this date for sentence. Court also notes presence of Court Service Officer Jessica Morgan and Intensive Supervision Officer with Community Corrections Christy Ashenfelter. Prior to the court, in anticipation of sentence, the court has ordered a pre-sentence investigation report. That report does show a criminal history score G as in grade. Is there any objection to the criminal history as set forth in the pre-sentence investigation report? Mr. Sweeney?
No objection, Your Honor.
And Mr. Paul?
No objection, Your Honor.
The court finds no objection to the criminal history as set forth. Therefore, it does become part of the basis for sentence herein. Before proceeding to sentence, the court will listen to recommendations from counsel as to appropriate sentence, beginning with the state and Mr. Sweeney.
Thank you, Your Honor. Your Honor, the state is recommending the standard mid-box 15 months, Department of Corrections, the 20% maximum good time percentage, 12 months post-release supervision duration. Ms. Wilson has no jail time credit. This is a presumptive probation case, and then also given the pre-sentencing scoring, she's a mandatory Senate Bill 123 treatment individual. And so given that, the state is recommending the up to 18 months of community corrections probation, with, of course, the Senate Bill 123 treatment kind of being the main focal point in that probation. It looks like the outpatient, if I'm reading correctly, is the first kind of modality in her Senate Bill 123 treatment. Everything else appears to be pretty standard and would ask the court order the same. The state is not requesting a fine. We are requesting $400 in restitution for the lab fees, court costs, corrections fees, supervision fees. The state is seeking $300 payable towards the Senate Bill 123 treatment, and then attorneys and bids fees if the court finds those appropriate.
Thank you, Mr. Sweeney. And recommendations from the defense, Mr. Paul?
Yes, Your Honor, we would concur with the recommendations as outlined by the state, sentence her to the standard number, place her on probation with mandatory Senate Bill 123 treatment. Judge, the only thing that I really need to address is attorney's fees and the bids application fee. Ms. Wilson just started a new job just a few weeks ago. She is making $16.50 an hour, but she's only working 30 hours a week. Judge, I would state that in the PSI, it shows that her costs and everything are going to be over $1,100. I have approximately about $470 in attorney's fees. Judge, I would leave those to your discretion.
Thank you, Mr. Paul. And the court makes inquiry to court services. Does the $1,138, does that include the Senate Bill 123 treatment program Ms. Morgan?
Yes, Your Honor, it does. It's included in that.
Thank you. And Ms. Wilson, prior to the court pronouncing judgment and sentence upon you, is there anything you would like to state in mitigation of your sentence?
I don't believe so, Your Honor.
Do you know of any reason why the court should not pronounce judgment and sentence upon you here today?
No, Your Honor.
And Mr. Paul?
No, Your Honor.
Ms. Wilson, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 15 months in prison. Court does order 20% good time credit, jail time credit of 0 days, post-release supervision 12 months. Court does find that there is a presumption of probation herein, and the court does grant that presumption of probation with community corrections. The court does order all standard and probation conditions as set forth on page 5 of the pre-sentence investigation report. Court orders you to pay all the costs and fees as set forth on page 5 of the pre-sentence investigation report. Based on your lack of financial wherewithal and recent new employment, the court does not impose bids application nor court-appointed attorney fees upon you. The court does order you to pay at the rate of $75 per month, $75 per month on cost and fees herein. The court does advise you, pursuant to KSA 22-3608C, that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you, pursuant to KSA 21-4619G, of any expungement rights you may have, and the court advises you of your prohibition of possession of any firearm. Immediately after this hearing, the court will place you into a breakout room with community corrections in regards to the probation program. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Mr. Paul?
No, Your Honor. Thank you.
Ms. Morgan?
No, Your Honor, thank you.
And Ms. Ashton-Felter?
No, Your Honor.
There being nothing further to come before the court, court is in recess. Good luck to you, Ms. Wilson.
And may I be excused, Your Honor?
Yes, have a good day.
Thank you, Judge.
And likewise, Your Honor, that's my last case as well.
Yes, have a good day.
You too, Your Honor.
Thank you. And let's see, Mr. Fowler.
Judge, Mr. Higinbotm is present at the jail, and we're ready to proceed.
Okay. And Ms. Morgan, are you in on court services for Mr. Higinbotm?
I am, Your Honor.
Thank you. All right, we'll go on the Zoom record at this point. Case is entitled State of Kansas versus Dalton William Higinbotm. Case number 24CR 487. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Higinbotm, appears in person and by court-appointed counsel Joe Favre. Also appearing at this time is Court Service Officer Jessica Morgan and Intensive Supervision Officer with Community Corrections Christy Ashenfelter. This matter does regularly come back before the court this date for sentence. In anticipation of sentence, the court has ordered a pre-sentence investigation report. Court has received the same. I trust that counsel for the state and the defendant have received a copy. And before proceeding any further, is there any objection to the criminal history score as set forth, which does indicate a criminal history score B as in boy, Mr. or Miss Norris?
No objection, Your Honor.
Thank you, Miss Norris. And any objection to criminal history score 10? The criminal history score B as in boy, Mr. Favre.
No objection.
Court finds no objection, therefore it will become part of the basis for sentence herein. Before proceeding to sentence, the court will listen to recommendations of counsel as to appropriate sentence, beginning with the state and Ms. Norris.
Thank you, Your Honor. Regarding count one, the flee or elude, state would be recommending the standard mid-range guideline sentence of 11 months in the Department of Corrections. Defendant could earn up to 20% good time credit and will be subject to 12 months post-release.
It's fleeing and elude night. We've had so many of them from Kansas tonight.
There is one special rule, number 9. This crime was committed while he was on probation or parole, so this case would be required to run consecutive. And Your Honor, he has earned 176 days of jail time credit as of this date. Regarding count 2, the theft, ask the court assign defendant to 12 months. And Your Honor, those counts run. Oh, I'm sorry, Your Honor, that's actually a misdemeanor. So probably ask that the court assign defendant to 10 months in the county jail, and that count run concurrent with count 1, which is DOC time. Your Honor, there is no request for restitution. State would be asking the court to assess the cost of the action to the defendant. Court will also need to address court-appointed attorney's fees and the bid's application fee. Otherwise, Your Honor, I don't think I have any further recommendations for the court at this time.
Thank you, Ms. Norris. Recommendations as to sentence from the defense, Mr. Fowler.
Yes, Your Honor. So first, I'd like to address that we're in a little bit of a different sentencing posture than we are sometimes in cases like this. We had initially intended on filing a departure motion, perhaps, and with the hopes that Mr. Higinbotm would get a drug and alcohol evaluation, which never occurred. Speaking to Mr. Higinbotm, we made the decision to not pursue that path and to instead ask the court to impose the mitigated number of 10 months in this case, which is what we're asking for, which does not require a departure motion. Mr. Higinbotm has already done 180 days almost in the county jail as of this date. So he is aware that he doesn't have much time left on a 10-month sentence. We've sent in 2 letters of support. I just sent them to the court, unfortunately, but they're a letter from Ray Teal from the Thrive program and a letter from his kitchen supervisor where he's working in the detention facility. And both of them speak to his attendance and his efforts at trying to make a plan for post this case. Because the sentencing range is so short compared to how much time he's done, we felt like the best option would be for him just to proceed, ask for the mitigated number, ask for the court to impose the 10-month sentence on count 2, which Ms. Norris has already asked for, run those concurrent. And with the good time credit we believe he's going to be eligible for, we think he won't end up doing too much time in DOC, and he's going to end up making some plans that he's going to implement once he gets out of DOC custody. So that's our request today, that the court impose the mitigated number, mostly based on his good behavior that he's had during the 6 months he's been incarcerated as a basis for that. And then no objection to the standard court costs and fees listed in the PSI. We would ask the court to consider waiving his attorney's fees because, as we noted, he's been in custody for the last 6 months.
Thank you, Mr. Fowler. Further recommendations from court services, Ms. Morgan?
I don't have any, Your Honor. Thank you.
And community corrections, Ms. Ashenfelter?
No, Your Honor.
Thank you, Ms. Ashenfelter. And Mr. Higinbotm, prior to the court pronouncing judgment and sentence upon you, is there anything you would like to state in mitigation of your sentence?
Yes, Your Honor. I truly am sorry for my actions in this case. I'm remorseful about it. I've struggled with a long addiction for the past 10 years, and upon release, I plan on checking myself into a drug rehabilitation facility. And once completing that, I want to try to get into a sober living house and get a job and try to be a productive member of this community. Because I plan on coming to El Dorado once I and released from KDOC. But that's all I have to say.
Do you know of any reason why the court should not pronounce judgment and sentence upon you here today?
No, Your Honor.
And Mr. Phillips?
No, Your Honor.
Mr. Higinbotm, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 10 months in prison. The court does order 20% good time credit and 176 days of jail time credit. Court does place you on a post-release supervision period of 12 months. That's as to count 1, fleeing or attempting to elude law enforcement, severity level 10 person felony. Court does find special rule 9 does apply. The crime was committed while incarcerated or on probation or parole or conditional release. And subsequently, the court does order you to serve that 10 months. Court orders in regards to count 2, theft, class A misdemeanor. Court orders you to serve 10 months county jail. The court does run that sentence concurrent to count 1. Court finds that you're not being placed on probation herein. The court does find that you are without financial wherewithal because you've been incarcerated for approximately the last 176 days, and therefore does not impose upon you your court-appointed attorney fees nor bids application fee herein. The court does order you to pay the court cost herein, and the court does advise you pursuant to KSA 22-3608C that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you pursuant to KSA 21-4619G of any expungement right you may have. And the court advises you of your prohibition of possession of any firearm. Any other matters to come before the court, Ms. Norris?
No, Your Honor, thank you.
And Mr. Favre?
No, Your Honor, thank you.
Ms. Morgan?
No, Your Honor, thank you.
And Ms. Ashenfelter?
No, Judge, thank you.
There being nothing further to come before the court is in recess. Good luck to you, Mr. Higinbotm.
Thank you.
Judge, that's all I got, if we can be excused.
You can be excused, Joe. I think you look like you've been a busy man today.
I was trying to take care of a friend. I was trying to help him out with a hearing in Derby, so I apologize for my lateness. It just
No
stacked
problem.
up that way.
No problem. Take care.
Everybody.
Is that you, Amanda, at the jail? Okay. You look a little different than last time I saw you.
Well, Mr. Langley, you were the first ISO I've ever seen with long hair and a beard. And going on 13 years now.
Well, I've been running juvenile facilities in Michigan for the last decade. So coming back to Kansas, I hadn't been back in, I think I left, well, I'm so old, I left still when it was in the 90s.
All the same, thank you for being here. We'll get to you as quick as we can.
Appreciate it.
Morning, everyone.
Morning, Judge.
Looks like we're without a prosecutor.
Looks that way.
Does anybody need a breakout room while we're waiting?
I would like one with my attorney, Chris Ambrose.
Okay, is that Mr. Tanner?
Yes, Judge.
All right, we can set that up for you. Mr. Langley, what case are you here on?
Judge, I'm the ISO for Brad Smith to talk about his termination.
Okay, thank you.
Betcha.
Richard, is Jennifer McBarity present?
I'm not sure. She said she was going to be here.
Who's on the Samsung SM?
My name's Morgan.
Okay, I've got two of them. The
And
gentleman?
then I'm Gabrielle Chesawala.
Okay. And sir, what is your name in the, looks like a Dr. Pepper shirt?
Yeah, Morgan Shaw.
Okay, thank you.
Yep.
Is Jennifer McBrady present?
Can I get a breakout with Mr. Shaw, please?
Yes. All right, not on the record yet, just trying to get an idea of what we're doing on some of these cases. Richard, what's gonna happen on the Chesawala case?
Judge, I believe we're gonna set that for trial.
Okay. And McBrady, if she shows,
Judge, she has been in the hospital, she had a appendix, I believe, taken out. We've got a plea agreement. I think she's going to take it, but we've got she's on medication and everything, and I think we need to continue it, to be
okay.
honest.
Mr. Ambrose, I'm just doing a quick status, not on the record or anything. Holden, what's gonna happen on that?
We're working through the diversion stuff on her, Judge. I anticipate we're going to have the application with the $200 application fee into the county attorney's office in the next 10 days. She just
Okay.
needed time to get the money together on that.
Who's at the Greenwood County Jail?
That's Lawson, Judge.
Okay, and that's for sentencing and
we're good to,
Cargile's for sentencing.
yeah, Judge, on Cargile, I just got the PSI back. I need to file a departure motion, so I'm gonna be asking for more time. I just got it last night at 4:30.
Okay, let's start running through some of these. Let's take up the Gabrielle Chesawala case. All right, we'll go on the record. This is in the District Court of Greenwood County, Kansas. Case is entitled State of Kansas versus Gabrielle Tatum Chesawala. Case number 24 CR 139. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paw on behalf of Ms. Chesawala, who appears via Zoom at a separate location than counsel.
All right, Ms. Chesawala was arraigned on February 27th. We set today over as a status conference. Any announcements, Mr. Paw?
Judge, I believe at this time we need to set it for jury trial setting.
All right. My next jury trial setting is August 19th at 9 o'clock. Pre-trial August 14th at 9 o'clock.
Jury trial said August 19th.
Correct.
Pre-trial is the 14th.
14th at 9. The 14th, the pre-trial docket is a Zoom docket. The 19th, obviously, the jury trial setting is in person.
Understood.
And those dates work for you, Mr. Paw?
They do, Your Honor.
All right, Ms. Chesawala, did you get those dates written down?
Yeah, so it was August 19th at 9 a.m.
That's for jury trial, but you'll need to
Okay.
appear by Zoom on August the 14th at 9 o'clock for a pretrial conference.
Okay, gotcha.
And Mr. Paw, if you all are able to get something worked out on the case prior to then and want to get on a docket before that, just let us know.
Will do.
All right, anything else on this case?
Oh, Your Honor.
All right, we'll be in recess. Mr. Chesawala, you're excused. Thank you.
Thank you.
All right, so let's take up Bailey Cargile.
Okay.
All right, we'll go on the record in State of Kansas versus Bailey Cargile, case number 24 CR 61. Would counsel announce appearances, please?
The state of Kansas appears by Jill Gillette, County Attorney.
Bailey Cargile appears in person via Zoom at a separate location than counsel Richard Paw.
All right, we're scheduled today for sentencing after a plea was done back in January. Announcements, Mr. Paw?
Yes, Judge. Judge, I just received the PSI late yesterday. I have not been able to review that yet with Ms. Cargile. Also, I believe that based on the criminal history score and a special rule, I need to file a departure motion. So I would ask for a continuance on this sentencing, Judge, due to the late PSI. I know Ms. Donovan worked hard to get it out, but hasn't really given counsel a chance to do anything on it.
All right, Ms. Gillette, your position?
Judge, I believe that the defense needs to do due process. I mean, they have to make reasonable efforts on their end, so I don't have an objection. My office has been working diligently trying to have the journal entry ready for today. So.
All right, and I do know we just received this PSI, I think yesterday afternoon, later in the day. I understand the need to properly go over that with your client and prepare for sentencing, Mr. Paw. I'll grant a continuance for that purpose. May 22nd at 9 o'clock, or let's do 10 o'clock, if that works.
Judge, I'm scheduled for a jury trial in Greenwood County that is going. Do we have something maybe late that afternoon?
No, I'm out that afternoon.
Sorry about that, Judge.
I understand. June 18th at 10 o'clock.
June 18th at 10 o'clock, Judge.
May 18th at 10 a.m.
Yes.
And Judge, due to the criminal history score, I'd ask that the defendant be at the courthouse for sentencing.
All right, sentencing will be continued to June 18th at 10 o'clock. And I think that is a valid request, Ms. Cargile. You'll need to appear in person at the Greenwood County Courthouse. Even though it's by Zoom, you can utilize the Zoom equipment there at the courthouse.
And what if I'm not able to travel? Like, I don't have like the necessary means to travel. I'm trying to pay back everything from this court case right now, and like my job just requires me to be here.
Well, you've got 2 months to make travel arrangements, so I'll expect that that's enough time to figure out a way to get to Eureka, Kansas.
And I'm also on probation here that doesn't allow me to leave here.
You'll need to make the proper arrangements, Ms. Cargile. You have obligations to this court, and I'm ordering that you appear at the Greenwood County Courthouse, Eureka, Kansas, June 18th at 10 o'clock for sentencing.
All right, thank you.
All right, if there's nothing further, we'll be in recess. Ms. Cargile, you're excused. All right, Denisha Holden.
Hello.
Good morning.
Good morning.
All right, we'll go on the record in State of Kansas versus Denisha Holden, case number 24 CR 32. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
May it please the court, the defendant, Ms. Holden, appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal. Judge, we have been discussions between the state and defense. State has sent us some diversion packet information. Ms. Holden has some financial obligations that go along with that. She's going to need another week or two to get that taken care of. And then at that point, she'll get that all sent to me so I can get it to the county attorney's office after I review it.
Can you have this accomplished by May 22nd at 9 o'clock?
That should be fine, Judge.
All right. Ms. Gillette, any objection to setting this over to May 22nd at 9?
No.
All right, Ms. Holden will continue your case to May 22nd at 9 o'clock in the morning. That'll be by Zoom. Be sure you get Mr. Ambrose anything that he needs so he can have everything ready to go by that date.
Yes, sir.
All right, anything else then on the Holden case?
No, Your Honor. Thank you.
All right, we'll be in recess. Ms. Holden, you are excused. Thank you.
All right. Thank you. Have a good day.
You as well. All right, Morgan Shaw. All right, we'll go on the record in State of Kansas versus Morgan Lee Shaw, case number 24 CR 209. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Morgan Shaw, who appears via Zoom from a separate location.
Thank you, counsel. We are set today for arraignment. Does your client need a formal reading of the charges, Mr. McClendon?
No, Your Honor, we would waive.
All right. And are you entering a not guilty plea at this time?
Your Honor, we'd be entering a no contest plea to count 1 in this matter.
All right, to the unlawful possession of methamphetamine.
Yes, Your Honor.
All right, Mr. Shaw, you wish to waive your right to a preliminary hearing today?
Yes.
You understand that at a preliminary hearing, the state would be required to put on evidence to show probable cause to bind you over for trial?
Judge, he's waived prelim with Judge.
Yeah.
I think we're ready just to enter no contest plea.
There was a journal entry on 3-5, Judge.
My bad. All right, Mr. Shaw, I'm going to ask you a number of questions in order to go over your plea. Could you state your name for the record, please? Mr. Shaw?
Did he freeze up? Well, there he is.
I think he's having connection issues, Your Honor.
Mr. Shaw, can you hear me?
Morgan Lee Shaw.
What city are you currently located in, Mr. Shaw?
Yeah.
What city are you currently located in? Where?
Yeah.
I'm not doing a plea with these
Sorry.
internet issues.
Can you hear me now? Yes.
Are you in Eureka?
Wichita. No. I'm in Wichita.
I hear you. Do you have somewhere where you have a stable internet connection?
Yeah, let me try and one sec.
You work on that, and I'm going to go and recess on this case, find a good internet connection, and then we'll come back to your case. All right. Jennifer McBrady, have you had any luck finding her, Mr. Paw?
No, I just recentered the Zoom link, Judge. I think that's the issue. We can, if you want to take up Lawson sentencing, we can do that.
Okay. Mr. Ambrose, is Bradley Smith here?
I believe so. Yes, Judge, he is.
And this is
Brad
the one
Smith.
that Mr. Langley is here on as well.
Yes, Your Honor.
Okay, let's take that up. All right, we'll go on the record in State of Kansas versus Bradley Smith, case number 23 CR 214. Would counsel announce appearances, please?
May it please the court, the state appears by Judge-elect County Attorney.
May it please the court, the defendant, Mr. Smith, appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal, who also appears via Zoom.
All right, we're set today on a motion for early termination of probation. Is that correct, Mr. Ambrose?
Yes, Your Honor.
All right, and Ms. Gillette, are you opposing the motion?
Judge, if he's done everything that's required of him, I'm not opposing that motion.
All right, just for purposes of the record, Mr. Ambrose, just can you give me a little bit of background here?
Yes, Judge. Mr. Smith was sentenced for probation on September 12th of 24. Termination of probation date is a year after that, so September 12th of 25, around that. He's been supervised through the Sedgwick County Department of Corrections since September 24th of 24. Mr. Smith hasn't had any issues on probation. He's been fully compliant with his officer. He's completed all obligations. During this time on probation, Mr. Smith has continued to attend VA outpatient drug and alcohol treatment services 3 times a week. Actually, beyond the end of his formal termination date, they allow him courtesy groups, and he's continuing to take advantage of that. He's paid off all financial balances, and I didn't put this in the motion because I wanted to make sure I was clear on all the details of it, but Mr. Smith is basically asking for early termination because, one, he's done what he needs to. He's made this, very substantial progress, and if the court would remember, Mr. Smith had made a ton of progress before we'd even gotten him sentenced. However, Mr. Smith does have aging family in Nebraska where he's from, and the plan would be, if the court would grant him early termination, he would be moving to Nebraska to be with them.
All right. Thank you, Mr. Ambrose. And Jeremy Langley, you are the ISO out of Sedgwick County that's been supervising him. Is that correct?
Yes, Judge.
And do you take a position on this motion?
We fully support the early termination.
Okay. All right. Well, Mr. Smith, I think people who are successful on probation and get everything done that they need to get done should have an incentive to seek early release.
I fully support Jeremy Langley's hair and beard. I think that's awesome.
With the support of your ISO and no objection from the county attorney's office, I think it is appropriate that you be allowed to be terminated from probation at this time. So I appreciate you working hard and completing your probation early.
Thank you, Judge. I appreciate it.
All right, good luck to you, sir. And Mr.
Thank you.
Lang, I appreciate you being on here this morning. All right, we'll be in recess. Have a good day, everyone. All right, let's do the Amanda Lawson sentencing. All right, we're on the record in State of Kansas versus Amanda June Lawson, case number 23 CR 32. Would counsel announce appearances, please?
May it please the court, the state appears by Judge Gillette, County Attorney.
Richard Paul on behalf of Amanda Lawson, who appears at the Greenwood County Jail via Zoom at a separate location than counsel.
All right, thank you, counsel. We're set today for sentencing. We've had some delays. Miss Lawson, you were in Arkansas and now you're back here, looks like.
Yes, sir.
All right, I have received a PSI. It indicates a criminal history score of E on a conviction of unlawful possession of methamphetamine and a paraphernalia charge. Ms. Gillette, is there any objection to the criminal history score?
No objection to the criminal history score, Your Honor.
All right, and Mr. Paul, any objection to the criminal history score?
No, Your Honor.
All right, Ms. Lawson, you're not objecting to the criminal history score of E?
No, sir.
All right, I will establish criminal history score of E. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing at this time?
I am not.
And Mr. Paul, are you?
No, Your Honor.
All right, this looks like a presumptive probation case due to Ms. Lawson's out-of-state residency. It's not a Senate Bill 123 case. Ms. Gillette, what are the state's recommendations for sentencing?
Your Honor, this is a special rule. This crime was committed while on felony bond. This is, as you said, a presumptive probation. We'd ask for the standard term of 20 months, 12 months post-release supervision, up to 20% good time credit, and for a probation duration of 12 months, following all standard conditions of probation, including that of doing drug and alcohol treatment on her own. There is a second count that is a conviction. It was count number 4, and that is a Class B non-person misdemeanor. We'd recommend 6 months underlying with the same 12 months probation duration, and that the 2 counts run concurrent to each other but consecutive to the case that she was on felony bond for. That she not have any drugs in her possession and submit to breath, blood, or urinalysis testing as directed by the ISO. We would ask that she be placed on community correction based on her awareness score and the special rules. I don't have an objection to a transfer pursuant to interstate compact as long as she complies with all the interstate compact requirements. That's a privilege, not a right. Follow all other rules of the probation that's set out in the PSI. There's a $400 KBI lab fee, court cost, DNA database fee. This is her first felony in Kansas. Community corrections and correctional supervision fee, and a $45 booking and fingerprint fee. Ask for determination pursuant to Robinson for any bids, application, and attorney's fees. The case that she was on bond for is the 4th Judicial District out of Washington County, Arkansas. The case number 72 CR 21-1127. It is a felony. She has jail credit of 68 days, and we will include those in the journal entry and ask the court to order credit for the time that she has spent in custody up to today.
Thank you, Ms. Gillette. Mr. Paw, your recommendations?
Judge, we would concur with the sentencing recommendations as outlined by the state. Sentence her to probation. We agree that the counts run concurrent to each other. Judge, we would like transfer to Arkansas. Approximately, not including today, I have approximately 1,050 in attorney's fees. She has been in custody for the last 45 days. She is unemployed. I would ask that you make the requisite findings under State v. Robinson and waive those attorney's fees. That's all I have, Your Honor.
All right, thank you, Mr. Paw. Ms. Lawson, is there anything that you'd like to say before I pronounce sentence?
No, sir.
All right, Ms. Lawson, for the primary offense of unlawful possession of methamphetamine, a level 5 non-person felony with your criminal history score of E, I will sentence you to the standard term of 20 months with the Kansas Department of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. You are entitled to 68 days of jail credit for time that you've already served on your sentence. This is a presumptive probation case. I will place you on probation from the controlling prison sentence for a period of 12 months with community corrections. You'll be ordered to follow all standard conditions of probation, including obtaining a drug and alcohol evaluation and completing any recommendations. You're not to possess or consume alcohol or illegal drugs. You are subject to random breath, blood, and urinalysis testing. You will need to notify your ISO of any changes of employment, residence, phone number, email address. You're not to violate the law if you have contact with law enforcement.
Reporting in progress.
You need to let your ISO know within 24 hours. Is there any reason why you can't gain employment?
No, sir.
I will order that you gain employment as a condition of probation. There's a request here in the PSI for no contact with the co-defendant. Was that requested formally?
No, sir.
Ms. Gillette?
Judge, I would believe it would be in her best interest not to have contact with him. If there's a need for contact, I'd make it at the direction of the ISOs.
Who's the co-defendant to you?
Dylan Holloway.
And who is that to you?
He was a friend of mine. I haven't talked to him since this case.
Is there any reason why you need to have contact with him?
No, sir.
Okay, I'll order that you not have contact with him as a condition of probation. You do need to submit a sample of your DNA to the KBI database and pay the $200 fee. You need to follow all curfew and travel restrictions that are part of your probation program. Don't possess firearms or dangerous weapons. So your goal is to return to the state of Arkansas?
Yes, sir.
Okay. I'll allow there to be the interstate compact. So you'll need to follow all the requirements. Getting back, do you have a hold out of Arkansas?
No, sir. I'm on parole there. I've just spent the last 18 months in Washington County and then 6 months in prison in Arkansas. And then I came here.
Okay. I failed to address count 4. That's the possession of paraphernalia, Class B misdemeanor. I'll sentence you to 6 months in the county jail on that and run that concurrent with the felony. So you have a controlling sentence in Kansas of 20 months with the Department of Corrections.
So I'm going to prison here for 20 months?
No, you're on probation with community corrections. You have a controlling prison sentence of 20 months. If you violate your probation, you have that hanging over your head.
Okay, thank you for clarifying.
Pursuant to special rules, since you were on felony bond at the time this offense was committed, this case will run consecutive to Washington County, Arkansas case 72 CR-21-1127. So I'll allow there to be interstate compacts, so you can go back. Now, there's a process for that. They have to agree to supervise you, and there's certain rules, but we'll get to that here in a minute.
Okay.
I'm going to order that you pay the court costs of the case. I'm not going to impose a fine. However, I will order that you pay restitution in the amount of $400 to the KBI for the testing of the drugs. You will need to pay the correction supervision fees, as well as a $45 booking fee. What type of work do you plan on doing once you get to Arkansas?
I'm not sure, sir. I was thinking about, I have a list of places in Arkansas that hire felons, and I was going to start applying down the list, honestly.
I'm going to order that you pay the bids application fee.
They have a list of places that hire felons? I mean, I guess, but who would, why would, okay.
And that you pay $250 towards your court-appointed attorney's fees.
Okay.
You may have a right to expunge these convictions from your record at some point in the future, once you've successfully completed either your probation, or if you have to do your time. Once you do that, after a couple of years have passed, you might look into expungement. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one would be appointed for you. As a convicted felon, you can't possess firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. Miss Ashenfelter, what does she need to meet with you in a breakout room when we get done?
Yes, Your Honor, that'd be great. Thank you.
And what, has she already been approved to go to Arkansas, or is that something that will start now that she's been sentenced?
No, Your Honor, that's something that we'll have to do now.
Okay, and then she'll have to remain here in Kansas till she's been approved to go to Arkansas?
No, since she's a resident, she should be able to go back today, and we'll just give her a permit.
Okay, do you have a way to get to Arkansas?
Yeah, my dad's going to come get me.
Okay. All right, Miss Gillette, anything further as far as sentencing recommendations?
Did you order the $200 DNA database fee?
I did, but one thing that I didn't do was establish a payment plan. I'm going to order you pay a minimum of $50 a month towards your costs and fees. I'm going to make the first payment due by the last business day of May and by the last business day of each month until paid in full.
Okay.
So that gives you a little bit of cushion to get back to Arkansas and get a job and make that minimum payment. You'll need to make higher payments at some point.
Okay.
Mr. Paw, anything else that I need to address?
No, Your Honor, thank you.
Do you have any questions, Miss Lawson?
No, sir, I don't.
All right, I'm going to put you in a breakout room with Christy Ashenfelter. She's with our Community Corrections Department, and she'll provide you with instructions on working on this interstate compact.
Okay.
All
Your
right.
Honor.
Yes.
Your Honor, if I may, real quick, special rule number 10, the being on felony bond, it is one of the special rules that has some mixed language in it, and it does require that the court imposing a consecutive sentence should clarify that consecutive sentencing was done in the exercise of discretion and not because of it was mandatory.
Okay, I'm ordering that it's the discretion of the court that she serve that sentence consecutively. Does that satisfy your inquiry, Mr. Bauer?
I believe so. Parts of it says may and parts of it says shall. So the court has to clarify that it was discretion and not mandatory that for the order of the consecutive.
Very well. All right. Good luck to you,
Thank you, sir.
Lawson. I hope we don't have to see you back here.
Likewise.
Good luck, Amanda.
Thank
All
you.
right, we'll be in recess. Richard, is the McBrarity the last case you have this morning?
It is.
Are you ready to take that up?
Yeah, I can't get a hold of her, so yes, Judge.
All right, we'll go on the record in state of Kansas versus Jennifer Leanne McBrady, case number 24 CR 153. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Miss McBrady, who does not appear.
All right, we're set today for a status conference. We were last here February 27th. Miss McBrady was present. She was arraigned that date. We set it over to today to see if a resolution could be made prior to setting it for trial. Announcements, Mr. Paul?
Judge, I got a email from her yesterday. From what she tells me, that she was hospitalized recently for her appendix. She states that she is on medication. We were set for a plea. We are in plea negotiations with the state. I'm not sure why she's not here, but Judge, at the end of the day, I was going to ask for a continuance anyway, because we need to just finalize a couple of things with my client, and but I do not know why she's not here today.
But you spoke with her at least by email yesterday?
I did, Your Honor.
And has she been in good communication with you through your representation?
She has, Your Honor. That's why it's very surprising and concerning to me that she is not here. She told me last night that she was having complications due to her surgery, and since I haven't heard back from her and she's in good contact, I'm afraid she might be back in the hospital is the only thing I can guess at this moment, Judge.
Miss Gillette, what is your position?
I don't have, usually if they're in a hospital, I get something that says they are, but I don't have anything in this case. I would ask for a warrant, but have it stay till the end of the day if Mr. Paul can get me information from her.
All right, under these circumstances, looking at the docket notes, there's no history, at least on this case, of failure to appear or unnecessary delay. Mr. Paul, if you are representing that you've maintained good contact with her and you are working towards a plea under these circumstances, I'm going to grant the continuance.
Okay.
Are you available May 22nd at 9 o'clock?
No, I'm not, Your Honor. Remember, I'm in trial.
Oh. June 18th at 9.
I believe we set something else there on June 18th at 9, so that would be great.
All right, that's where we'll set it. And anything else then on the McBrady case?
Mm-hmm.
All right, we'll be in recess.
All right, thank you, Your Honor. May I be excused?
Have a good day, Richard.
Thank you.
We're taking up some motions on Nicholas Tanner.
Yes, Judge.
What were those again?
Just asking to get the ankle monitor released.
All right, let's go ahead and take that up. And that's all we're doing on his cases today?
Yes, Judge.
All right, we'll go on the record in two cases, both entitled State of Kansas versus Nicholas Tanner, 23 CR 300034 and 23 CR 0001. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
May it please the court, Mr. Tanner appears in person with counsel Christopher Ambrose, Farvis Legal.
All right, there's motions before the court to modify bond conditions in both of these cases. Mr. Ambrose, go ahead.
Yes, Your Honor. We're going to be asking that the court contemplate lifting the bond condition that requires Mr. Tanner to be placed on electronic monitoring. He's been on electronic monitoring for quite a while, and I think we all know that Mr. Tanner has maybe had a rough road for a while. However, I think that for a while now, he's been making positive progress. He completed inpatient, outpatient treatment. He is living in a sober living house in Wichita. He's working there. He got a new job with a construction company. He's not having problems, and that ankle monitor does cause quite a financial burden and has for quite a while. It would be our request today that the court allow that to be lifted.
Okay, this is not me trying to be mean, but I have to ask, and he turned his head just as I hit pause. But is his beard misaligned or is his mouth misaligned? I have to know. It's boggling my brain.
Obviously, all the other no contact order requirements and all that stay the same. That in speaking with him, Mr. Tanner has no desire to have any contact with the young lady that there's a no contact order with. That he's, frankly, I think at this point he's the clearest headed I've ever known him to be, and he's building a life in Wichita and doesn't want anything to do with her because he knows that it could cause some substantial problems for him, and their relationship just wasn't a very good one.
How long has he been on this ankle monitor now?
It's 22 months, right, Nicholas?
Over that, I think it's been 29.
Okay. Ms. Gillette, your position?
Judge, I'm aware of him being in sober living. I'm aware of him moving to Wichita and trying to do treatment and the changes in his life. No contact should remain with the victim in the convicted case as well as the alleged victim in the new case. They're both one and the same. So I will at this time not object to having the ankle monitor removed and him to continue being in Wichita.
All right, I'll grant the motion. Mr. Tanner, I do note that we still have an outstanding warrant to show cause that we're scheduled to come back on June 18th. Is that still correct, counsel?
Yeah. Yes, Judge. Yeah, we're going to take care of both cases will be taken care of at that point. And frankly, Mr. Tanner has every motivation to behave and do what he's supposed to because he has quite the carrot and or stick in front of him at this time, Your Honor. And frankly, he's going to have that for a long time.
That's exactly what I was thinking, Mr. Tanner. So all the other conditions of bond remain in place, but I'll simply allow the ankle monitor to be released. Mr. Ambrose, if you want to submit some sort of an order, I don't know if the electronic monitoring people will need that or not.
We'll get an order submitted, Judge.
All right, anything else then on the two Tanner cases?
Not for today, Judge.
All right, we'll be in recess.
Thank you.
All right, Mr. Battatori is on here. Jill, I wanted to go on the record real quick and clarify some things for this afternoon. All right, we'll go on the record in state of Kansas versus Tanner Levi Cobalt, case number 23 CR 217. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Your Honor, the defendant appears through counsel Edward Battatori via Zoom.
All right, counsel, as you're both aware, we're set this afternoon to hear a number of motions in person over in Eureka. And I had Angela reach out to you yesterday just to see the status, if these are still set to go before everybody drives over there this afternoon. So I know there's been a few emails exchanged. Ms. Gillette, from the state's perspective, are you ready to proceed on these motions this afternoon?
Judge, on the motion regarding the Miranda, we have designated an expert witness. We made arrangements and even offered to do an agreed restriction order, made special arrangements that the meeting would be at the courthouse, upstairs in an attorney-client room, not recorded. And it would just be the evaluator and the defendant. Whenever there is a mental defect claimed, the state is entitled to its own expert witness to evaluate the client. He is claiming a mental defect prevented him from being able to understand his Miranda. Therefore, we're entitled to our expert witness to be able to meet with him. That has been denied by the defense. And the state is entitled to that, and to have our own expert witness review this defendant. And so we are asking for a court for restrictions that.
Miss Gillette, you're cutting in and out.
That's because someone else has noise coming in the background noise.
I'm in a doctor's appointment. Can I step out to my car real quick?
Yes.
Thank you. I'm sorry about this. I'll mute while I'm walking. Okay, Judge, I'm back. I'm sorry about that.
All right. Miss Gillette, you were kind of cutting out then, or the audio wasn't clear to me. Could you go back a little bit, please?
Yes, so the state is entitled to a separate expert witness when a defendant alleges mental defect. The defendant in this case has alleged that because of some mental condition, he can't understand Miranda. When that occurs, we are entitled to a psychological evaluation of the defendant. Special arrangements have been previously made to have that done. Those arrangements were made under the conditions that it would be in an attorney-client room here at the courthouse, not recorded, no law enforcement present. My office and myself would not be present. It would just be solely the psychiatrist and the defendant for the evaluation. Our designated witness is Dr. Robert Barnett, PhD. We offered an agreed order to them that would say those things, that it would be limited to the sole issue of the understanding of the defendant to Miranda. He's already had a competency evaluation and been determined to be competent to understand the issues within his case, but now he's alleging a separate psychological issue, and the defense has refused to submit themselves to the state's expert witness, even under the conditions that we have made arrangements for. But the state is entitled in a psychological issue to have the defendant submit to an evaluation.
Is that by statute or by case law?
State v. Parker 459, Pacific 3rd 793 2020, State v. Davis 394, Pacific 3rd 817 2017. Mental condition of the accused is one of the major issues. The circumstances surrounding interrogation, the ability to communicate with the outside world, background, age, intellect, and officer fairness, and English language fluency, which is probably not an issue here since Mr. Cobalt is a U.S. citizen and speaks primarily English.
And the only reason for the defense to deny that request would be if the defendant had no issues. He's not going to fake it. He's not going to get through lying to a psychiatrist and pull it off. Like, no, they would recognize that instantly. There's even a word for it, and it escapes me at the moment. Malingering. Yeah. So yeah, that's when they fake a condition to the medical professionals, and it's very easily spotted. So that's the only reason that I can see the defense saying they don't want that evaluation done.
Voluntary responses after Miranda are a waiver of Miranda according to Parker.
All right, Ms. Gillette, I don't want to get into arguing the whole motion. I just kind of wanted to get a status of if these things are going this afternoon or not.
Well, since the state's entitled to a psychological evaluation of the defendant, I don't think it's ripe to have.
Mr. Battatori, your position?
Judge, we did designate an expert. Can you hear me okay?
Yes.
Okay, we designated an expert and we forwarded a report from that expert to the prosecution a couple, 2-3 weeks ago in an order for on just, full disclosure. And the hearing approached and there's an ancillary case in Sedgwick County that hearing was continued by the state, and Miss Gillette, like, I want to say 1 or 2 days after we submitted our report to Miss Gillette, she tried to set up an examination by a doctor designated by herself, and it was a rush. And she told me she'd get me an order. That I asked for the authority to do so, and then she said she'd get me an order, kind of setting out the parameters of the examination. And I didn't get it. And it was, like I said, it was like the next day when we were going to try to schedule this. I felt like it was being rushed. I felt like my client needed to be protected. I wanted a court ruling on whether or not this examination is authorized by law or supported by law. And I asked Ms. Gillette, well, if you would file a motion or provide me some authority that you're entitled to your examination, and we'll go from there. And I never got anything until this morning. I was communicating with Ms. Gillette. She sent me a state versus Baker, I think, kind of citation. So, and I haven't even had a chance to look at that. But if the court orders us to do an examination based upon proper authority, we'll submit. But that's really all I asked for. And then as far as the other motions, the Jackson v. Deno motion is tied to the voluntariness of the alleged confession. So, and because of the traveling and distance and cost involved, if we're going to reschedule 1 or 2 of these hearings, I guess I'm not asking for a continuance, but if we're going to reschedule them, I'd like to reschedule them all. So there's 1 trip, 1 cost for witnesses, 1 cost for traveling to the defendant. I thought Ms. Gillette was going to file a motion supporting her claim that she's entitled to an independent examination by an expert of her choice.
Well, I would like to see some briefing on that, Ms. Gillette. If you're making that request, I think that does need to be made by way of a motion. And I don't really want to piecemeal all of this. I would rather, the motion to suppress, that's what this is all about. Then there's the motion to disclose the Brady materials. I did see Ms. Gillette had filed a response. Does that resolve that issue for you, Mr. Battatori?
Partially, but not completely, Judge.
Okay. Well, we need to resolve this issue as to whether or not Mr. Cobalt can be compelled to take or be ordered to do a evaluation at the state's request. So I think these need to be set out so that issue can be fleshed out before we bring a bunch of people in. Are you available, Mr. Battatori, June 18th at 11 o'clock?
Oh, look, Judge, June 18th at 11 o'clock.
And I'm looking at this for a Zoom setting.
I've got a 9 o'clock arraignment in Chanute. So how far is Eureka from Chanute?
I'm talking about doing June 18th at 11 as a Zoom setting.
Okay. Oh yeah, I can do that.
I hate to go out that far to hear that first motion, but we have limited scheduling. Let me look at May 22nd. What's the motion hearing on a State versus Heather Klein at 11 o'clock on the 22nd? Does anybody know, Angela?
It's a revocation, Your Honor. We're hoping that maybe we'll be in deliberations by them on the misdemeanor jury trial. But again, I'll just let you know that is the second day of the misdemeanor jury trial. I've tried to get them to do it Tuesday, Wednesday instead of Wednesday, Thursday, so it won't interrupt the district judge days. But the misdemeanor jury trial has been set on top of the district judge calendars again.
Okay, let's go June 18th at 11 o'clock.
Judge, so just so you know, I'm scheduled in a jury trial in Coffeyville that day. Oh, I'm sorry. Wait, what day? June 18th?
June 18th.
Oh, that one's fine. Yeah, that one's fine. I was looking at the 22nd. 6/18.
All right, and Miss Gillette, if if you can file a motion with the supporting, of the cases you feel support your position on that, prior to that June 18th date. If you all, once you get that motion, Mr. Badatory, if you feel that it's legit and want to go ahead and get that set up, do so. If there's objection to it, then we'll argue that on June 18th and then see where we're at
Okay.
in resolving these other motions. I hate to go out that far, but this is a off-grid case and I don't want any corners to be cut here.
Understood.
Judge,
So,
there is a rape shield victim statute, and the victim is to be protected as far as outside issues. The statute has been updated and more strict. We received a motion for psychological evaluation on the juvenile. Do not believe that that is appropriate based on case law and statute. She is the subject of a child in need of care case. And
okay, Miss Gillette, if you want to file a responsive brief on that, that might be something we can take up on that June 18th setting also.
correct, but there was a business record subpoena without a notice of intent to file a business record subpoena to the Department of Children and Family Services to try to obtain all of her sync records that are with DCF, which I do not believe is appropriate in this matter.
Okay,
And
did you file an objection?
there was never a notice of intent. He just filed the business record subpoena without a notice of intent to file it. So there was not a mechanism to file an objection. I want a seal record on all of those records that cannot be shown to the defendant nor anyone else. They need to be returned or sealed up and should not be disclosed if he has served DCF anything on her child in need of care case.
Well, that'll be the order of the court for now. And then if we need to address that, we can take those up. Take that up when we come back in June.
I believe there was notice, Your Honor.
Okay, again, that's not something I had any idea was even at issue for
Sure.
today. So,
I mean, no objection, even afterwards, like, no, upon ascertaining that the subpoena was issued, there's still been no objection or anything filed.
I believe those records still need to be sealed, Your Honor.
have you received the records, Mr. Badatory?
I honestly, I don't believe I have, but I'll make sure. And if I have, then I will not read them or disseminate, or obviously not disseminate them or disclose them in any way, shape, or form. I'll let the court know and ask the court for instructions on how you'd like me to get it to the court.
Okay, well, that'll be the order of the court until further hearing can be done on that.
Thank you.
All right, so we'll call off the setting for this afternoon for the motions.
Okay.
So, Ms. Gillette, if you can get a hold of any witnesses you had subpoenaed for this afternoon and tell them they don't need to appear today. Mr. Badatory, advise your client of these new dates.
Okay.
And I'm waiving his appearance today because we set this morning just kind of as a status to see if
Understood.
we're needing to go over there this afternoon. So, all right, anything else on Cobalt while we're here, Ms. Gillette?
I don't think there's anything else on it.
Okay, and Mr. Badatory?
I think that's it. Thank you, Judge.
All right, we'll be in recess. Thank you. All right, Morgan Shaw, do you have good internet?
Yeah.
All right, we're back on the record in State of Kansas versus Morgan Shaw, same appearances as before. We had begun barely trying to take a plea in this case to count one. Is that correct, Mr. McClendon? He's pleading to count one and the state's dismissing the balance?
Yes, Your Honor.
All right, and that's how you wish to proceed today, Mr. Shaw?
Yes.
All right, could you state your name for the record?
Morgan Lee Shaw,
And how old are you?
32,
And what is your highest level of education?
11th grade. I got a GED though.
All right, is your plea being made freely and voluntarily?
Yes, sir.
Has anybody made any threats or promises other than the plea agreement to get you to enter into this plea?
No.
Do you understand that even though the prosecutor and your attorney may make certain recommendations to me as to sentencing and probation, excuse me, that the court does not have to follow those recommendations, that those decisions are mine and mine alone?
Yes.
Mr. McLennan, is this going to be a guilty plea or a no contest plea?
No contest, I believe, Your Honor.
All right, Mr. Shaw, when you enter a no contest plea, you surrender and waive certain legal rights you'd otherwise have if you chose to go to trial. Do you understand that you have a right to a speedy trial where your guilt or innocence would be determined by a jury, or if you chose to waive a jury, by a judge?
Yes.
Do you understand at trial you would have the right to confront the witnesses against you and have them cross-examined by your attorney?
Yes.
Do you understand at trial you would have the right to subpoena witnesses who may have information favorable to you and call them to testify in your behalf?
Yes.
Do you understand at trial it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty?
Yes.
Do you understand the judge and the jury must presume you are innocent until the state proves otherwise, if ever, beyond a reasonable doubt?
Yes, I do.
Do you understand if you are convicted at trial, you would have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of Kansas?
Yeah.
Do you understand that when you enter a no contest plea, you give up your right to present any defenses you may have had to these charges?
Yes.
Do you understand you're giving up each one of these rights if you plead no contest?
Yes.
All right, I'm going to go over the possible penalties that can be imposed. I'm holding up a sentencing grid for drug offenses. Can you see that?
Yes.
Have you looked at one of these grids before?
Yes.
Okay. Then you'll know that on a level 5, depending on your criminal history, you could be sentenced from anywhere between 10 months and 42 months in prison. Do you understand that?
Yes.
Where you fall on the grid will depend on your prior criminal history, as I stated before. If you have 3 non-person felonies or less, it's presumed you'd be placed on probation. If you have 1 person or 1 person and 1 non-person felony in your criminal history, you'd fall in a border box, which is presumptive prison. But if the court finds that there's a treatment program available to you and you're amenable to treatment, you could be placed on probation. If you have 2-person felonies or more in your criminal history, it's presumed you'd be placed in prison. Do you understand that?
Yes.
There could also be special sentencing rules that apply if you have multiple felony drug convictions in your criminal history. You could be presumptive prison. If you were on felony bond, felony parole, or felony probation at the time this offense was committed, the court could place you in prison, even if you fell in a presumptive probation box, and the court could run this sentence consecutive to the other case. Do you understand that?
Yes.
The maximum fine is $100,000. Do you understand that?
Yes.
Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs, and you may be ordered to pay back restitution for the state for any testing of the drugs?
Yes.
Do you understand that if you are placed on probation, you'll be ordered to pay the administrative costs of the probation program, and that you may be ordered to pay back your indigent attorney's fees?
Yes.
Have you ever been adjudged mentally ill by a court?
No.
Have you ever had a guardianship or a conservatorship set up to handle your affairs?
No.
Are you presently under the influence of any intoxicating liquors or drugs?
No.
Have you had plenty of time to discuss this case with Mr. McClendon?
Yeah.
Would you like any more time to visit with him about the matters you and I have just discussed?
No.
Keeping in mind the matters we have discussed, is it still your wish to plead no contest?
Yes.
All right, Ms. Gillette, could you please provide a factual basis?
Yes, Your Honor. Deputy Fisher was on duty for Greenwood County Sheriff's Office on November 25th of 2024. He was in the 600 block of East River Street here in Eureka, which is within the bounds of Greenwood County, Kansas. The defendant was in a black 2006 Charger, and there was a black Charger and a white Subaru, both traveling westbound in the 500 block. Both vehicles were traveling behind him, and both tags of the vehicle registered to the driver of the Charger who resides in Wichita. The one tag came back as a 1998 Dodge Neon was on the wrong vehicle. The Subaru cut off the Charger as it merged, and they initiated a traffic stop on the two vehicles. Subsequent to the traffic stops, the driver of the Charger was roommates with a Miss Hoover. They basically were trying to bait the officer to pull over the vehicle to cut the other one off. And Mr. Shaw was in the vehicle with them. They ended up doing a subsequent search of the vehicle, and there were items found in a red bag sitting on the back passenger seat. There was piece of broken glass with both dark and crystalline substances inside of it. There were 10 syringes wrapped in paper towels on the back passenger seat for using to inject drugs. They were given Miranda.
Wait. This was in the vehicle that was trying to bait the officer into pulling over the other vehicle? Or this was the vehicle that the officer got baited into pulling over? Well, either way, duh.
And Shaw admitted that he would test dirty for using the drugs. The drugs were sent to the KBI lab with them testing positive for methamphetamine, fentanyl, both on all the items in the vehicle that were seized.
All right, thank you, Ms. Gillette. All right, Mr. Shaw, the court finds that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find you understand the rights you are giving up by pleading no contest, and that the facts of the case would be sufficient for a finding of guilt. I further find your decision to plead no contest has been freely and voluntarily given, and will therefore find you guilty of count 1, unlawful possession of a controlled substance. Ms. Gillette, is there an announcement regarding the remaining counts?
The state will move to dismiss all remaining counts.
Right, counts 2 through 4 are dismissed. I am going to order a pre-sentence investigation report, and I am going to set a sentencing date. Mr. McClendon, are you available June 18th at 10 o'clock?
No, Your Honor.
Are you available anytime that morning?
Judge, I'm going to be on my honeymoon then.
That's no excuse, Mr. McClendon.
He needs a letter from your wife that she wants you there.
Well, July 24th at 10 o'clock.
I have a severance in Neosho County then. I could do the afternoon on that day though.
Yeah, let me look at my calendar. Would you be available like at 1:15?
Yeah, we could do that.
All right, July 24th at 1:15 will be the sentencing date. Mr. Shaw, you will need to be, it'll be by Zoom, but you need to appear at the Greenwood County Courthouse and utilize their Zoom equipment that day.
Okay.
You have plenty of time to make travel arrangements to get to Eureka July 24th at 1:15. And you're gonna need to meet with court services. Mr. Bauer, what does he need to do? Call you? Or call your office?
Your Honor, if he could call our office in El Dorado, they will get some information from him, get some paperwork sent out, and set him up with who's going to be doing his PSI.
Do you have something to write with, Mr. Shaw?
Yeah, what is it?
The phone number to our office in El Dorado is 316-322-4153.
Okay.
Now, Mr. Shaw, there's going to be some assessments that need to be done since this is a felony drug case. Make sure you get those scheduled and accomplished. If you don't, and we're not able to get you sentenced on July 24th, you might find yourself sitting in jail until those tests can be done. So make sure you get those set up.
Yes, sir.
All right, Mr. McClendon, anything else on this case?
No, Your Honor.
Ms. Gillette?
No, Your Honor.
All right, we'll be in recess. Mr. Shaw, you are excused.
Okay, thank you.
Okay, now we've got 2 sentencing left. Who's there at the Jasper County Jail?
Judge, that'd be Marissa Bettis.
All right, but are you ready to take that up?
I am ready to proceed, Your Honor.
All right, we'll go on the record in State of Kansas versus Marissa Kathleen Bettis, case number 24 CR 111. Would counsel announce appearances, please?
May it please the court, this date appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Marissa Bettis, who appears through Jasper County.
And is that in
It's in Missouri, Your Honor.
Missouri? Okay. All right. Back on January 30th of this year, Miss Bettis entered into pleas of possession of methamphetamine, endangering a child, and DUI. Sentencing is scheduled for today. I have received a PSI indicating a criminal history score of I. Ms. Gillette, any objection to the criminal history score?
No, Your Honor.
And Mr. McClendon?
No, Your Honor.
All right, Miss Bettis, you're not objecting to the criminal history score?
No.
Okay. Can you hear me okay?
Yes.
Okay. All right, the court will establish a criminal history score of I. This is a presumptive probation case. Ms. Gillette, are you aware of any legal reason why we can't proceed to sentencing?
I am not, Your Honor.
And Mr. McClendon, are you?
No, Your Honor.
All right, Ms. Gillette, what are the state's recommendations?
The defendant is under a issue with residency as to Senate Bill 123. She's in Missouri as her residence. Believe I was looking to see when she went into custody over in Jasper County. I don't know what the date was. She was there.
It would have been yesterday.
Oh, okay. So she is presumptive probation with up to 20% good time credit. We're going to recommend the standard box of 11 months as her underlying. There is a special rule. This crime was committed while she was on felony bond, and a new sentence should be imposed consecutively. It is recommended that she have 12 months post-release supervision and be placed on 12 months of supervised probation. Based on her scores, we'd ask that she be placed on community corrections. She has prior cases and apparently subsequent cases over there in Missouri. She does have jail credit of 5 days that needs to be applied in this matter. On count 2, endangering a child, she has a Class A person misdemeanor. We are recommending that she have a 9-month underlying sentence so that if at any time she serves her underlying, the good time credit wouldn't override her having to come back. And then we'd allow the 2 counts to be concurrent with an addition with the 12-month supervising probation. We recommend all conditions of probation as set out in the PSI, specifically that she have an alcohol and drug evaluation and follow up on the recommendations and submit to blood, breath, or urinalysis testing at the direction of her ISO. I believe she is going to seek to transfer her corrections to Missouri. I have no objection to it being transferred. She does have a KBI lab fee of $400, court cost, the DNA database fee in Kansas, corrections and correctional supervision fees, the bids, attorney and application fee. We'd ask the court pursuant to Robinson to inquire as those. I believe that it is appropriate and it is recommended in the PSI for the $400 child advocacy center fee, and the booking and fingerprint fee of $45. The cases that she was on felony bond for when this case was committed, we'd ask that this case run consecutive to that case. She had a different Greenwood County case. It was 23 CR 300045. I believe that case was dismissed at the time that she entered this plea. Just looking for it. And I think those are the recommendations of the state at this time, Your Honor.
Ms. Gillette, I don't think you gave recommendations on the DUI count.
Did they miss it? Oh, yep.
No, it's in there.
It's a Class B misdemeanor, Your Honor. I would ask for the concurrent 6-month sentence and the 12-month probation. It is a first-time DUI, so the 48 hours isn't required anymore, but she already has 5 days of jail credit if the court was going to impose any kind of a dip, and the same concurrent 12 months of probation in that count.
There used to be a provision in the DUI statute that if there were minor children involved, there's mandatory jail time. Is that still the case?
Judge, it is up to 30 days extended sentence on it. And since it's a 6-month sentence, the judge, you could put it as to 7 months. That's discretionary with the court. She has an 11-month sentence that's a KDOC sentence hanging over her head, and I believe that's well in excess of the 30 additional days, plus the reckless driving and behavior with drugs placed this into an endangerment, which she also pled to. But yes, there can be an extra additional 30 days. It's not mandatory jail time, but it is added to the underlying sentence or the sentence that the individual would serve.
All right, thank you, Ms. Gillette. Mr. McClendon, your recommendations?
Yes, Your Honor. I think we have an issue we may need to flesh out here. I believe my client now has a Kansas driver's license, and I believe she may have reported that to Mr. Bauer at some point. I don't know the status of that, but I do believe she is a Kansas resident now, so she may be eligible for Senate bill. Additionally, Your Honor, the bond, and just to make the court aware, the bond that she was on that case has been dismissed. That was 23 CR 33000045. That case has been dismissed in its entirety. So there's no consecutive sentence there for that case. That being said, Judge, I think we would join otherwise on the state's recommendations for sentencing and would be asking for probation in this matter.
Okay, well, regarding the residency, I'm assuming at the time, Mr. Bauer, that you met with her, she was not a Kansas resident?
When I spoke with her, she advised me she was a resident of Missouri and that she intended on staying in Missouri. However, if Kansas residency is what she needed to get Senate bill, she had an address in Wichita that she could use as her residence, so she would qualify for Senate bill. And I explained to her that's not how Senate bill works. You don't use an address in Kansas to get it because it's going to require her to come back to Kansas for all of her meetings and everything. And if she's technically living in Missouri, she's not going to be able to drive back and forth for all of her meetings that she's going to have to be on the Senate bill qualification. So she reported to me she lives in Missouri, but could use an address in Wichita if needed, so she could qualify for Senate bill. And we discussed that, and I told her that that's really not how Senate bill was intended to work.
Mr. McClendon, do you have knowledge that she's established a residency and is living in Kansas or plans to?
No, Your Honor, other than discussions with their mother. She maintains that she's a Kansas resident at this time. I'd have to defer to my client on that matter.
Do you want to visit with her in a breakout room?
Yes, yes, Judge.
All right, let's try to keep it as brief as possible. All right, we'll take a brief recess. Chris, while we're in recess, did you get the updated PSI on Kristen Michael?
Yes, and it doesn't really change anything effectively for us. It doesn't change to where I need to file any motions or anything. So I think that whenever you're ready, we're good to go.
Or does it just add the special rule?
Yes.
That's the only difference?
Yes, Your Honor.
Okay, thank you. All right, we're back on the record in State versus Bettis, same appearances as before. Mr. McClendon, after going into the breakout room, any updates?
Sorry, I was muted. Your Honor, my client, in discussion with her, she claims she has a residence in Wichita. It's Bullinger Street 20. She thinks the numbers are 2731 North Bullinger Street. She also has a Kansas driver's license. I think, and that is where she intends on residing after she's completed with her Missouri cases. And I think that would probably qualify her for Senate Bill 123.
Mr. Bauer?
If she's actually at that residence, like I said, she told me she could use that to get Senate bill, but had no intentions on living there. So if she's actually at that residence, I don't know. She's in custody in Missouri, so with her not living there, I don't know her intentions to go there. I don't know if we can do Senate bill. I would have to look into that. If we could actually do the Senate bill stuff now, or if she would have to get there and then look into Senate bill. If we need to wait till she's out and find out where she actually goes.
And she would have to have some assessments that I'm assuming haven't been done because she was going to be in Missouri. Is that correct?
Correct. We would have to do the SASE assessment as well as a drug and alcohol. If the SASE qualified her, then we would have to do a drug and alcohol assessment as well. And those would have to be done prior to her sentencing.
Mr. McClendon, what's her status in Missouri? Is she serving out a sentence there?
Your Honor, she was picked up, I believe, yesterday. She had a warrant on a traffic ticket and forgive me, I can't remember the name of the county, but in one Missouri county that she had failed to pay. And then she got picked up. I think that was her main reason for being picked up yesterday, and that's why she's in custody there. And she's going to see her kids that live in Missouri with her mother.
So are you requesting a continuance, Mr. McClendon? I mean,
Judge,
I think she can be placed on Senate Bill 123 after she's already been sentenced, can she?
I don't believe so, Your Honor. So I think at this time I will have to request a continuance, and if Mr. Bauer would be obliged, we could do the proper screening and try to figure out something on this residency issue.
Ms. Gillette, your position on this development?
Judge, I know there's different ways that Senate bill occurs now, both pre and post sentencing, but it's appropriate to continue her to do a Senate Bill 123. There'll have to be an updated PSI, so it doesn't matter either way to me.
And we don't even have an evaluation, which I typically like to have on a DUI case. I wish, Mr. McClendon, you would have brought this up before we got started.
I understand, Your Honor, and I wasn't made aware of this situation until yesterday, Your Honor. So
I understand. Well, if she truly intends to establish residency in Kansas and can be eligible for Senate Bill 123, I think, especially on a case with this fact scenario, it might be of benefit for her. Again, if that's truly what her intent is, and she intends to live in Kansas and work here and do probation here and go to treatment here, then I want her to have that opportunity. Mr. Bauer, how long would it take for your office to go through this Senate bill situation with her?
Your Honor, that's going to partially depend upon how long she's going to be in custody, because I'm going to have her come to our office in El Dorado so I can complete the SASE with her. And then from there, we would have to schedule the drug and alcohol, and I don't know how long that would take to get that scheduled. But the SASE needs to be completed, and I'll need her to come in to see me to get that completed.
And Mr. McClendon, you don't have any idea how long she's going to be there in the jail?
no, Your Honor, I think as of right now, she's waiting to be picked up by county in Missouri in which she has a warrant out for her.
All right, well, I think the only date we can realistically use based on prior scheduling is that July 24th date. I hate going out that far. But on the other hand, that should give plenty of time to get all of this accomplished.
I think given this particular scenario, it might be beneficial, Your Honor.
All right, Miss Bettis, is there somebody there that's can write stuff down for you? All right, July 24th at 9 o'clock in the morning. Or actually, let's go 10 o'clock.
But Judge, that's the morning I have. Can we push it to 11? I think 11 I could hopefully.
Didn't we just set one at 1:15 for you?
Yes, Your Honor.
Let's do that. Let's just set both of them there. July 24th at 1:15. Miss Bettis, if you need to appear at the Greenwood County Courthouse in Eureka that day and utilize their Zoom equipment. Unless you are in custody somewhere, then we'll make arrangements to get you zoomed in from there. But otherwise, I want you to appear in Eureka at the courthouse for that sentencing. Even though it'll be by Zoom, you can utilize the Zoom equipment. And Mr. Bauer, do you need to give her a phone number?
She had my contact information, but I can give her my phone number again. My phone number is 316-452-4781. And if she can contact me as soon as she is out and back in Kansas, then I will get her scheduled to get the SASE completed.
Yep. All right, Miss Bettis, it's very important that you make contact with Mr. Bauer as soon as you are out of jail and in Kansas.
Yes.
If you're going to be in for a long period of time, you need to let either Mr. McClendon know or Mr. Bauer know if you can, so we can keep track of you.
Yep. Yes, Your Honor.
So, all right. Any other matters then we need to address on this case?
No, Your Honor.
We'll be in recess. Thank you at Jasper County for having her here and for your patience. We'll be in recess.
May I be excused, Your Honor?
You may. Thank you.
Thank you, Judge.
All right, I think we're finally ready to take up the Kristen Michael sentencing. Appreciate everybody's patience this morning. Wouldn't be a docket if something doesn't cause us to go off the rails a couple times. All right, we'll go on the record in State of Kansas versus Kristen Leanne Michael, case number 23 CR 28. Would counsel announce appearances, please?
May it please the court, the state appears by Judge Ouellette, County Attorney.
The defendant, Miss Michael, appears in person via Zoom with counsel Christopher Ambrose Farvis Legal, who appears via Zoom as well from a separate location.
Thank you. Also appearing, Lori McManus with Court Services, who prepared the PSI. Christy Ashenfelter from Community Corrections also appears. Back on January 30th, Miss Michael entered a plea to possession of methamphetamine. Sentencing was scheduled for today. I have received a PSI indicating a criminal history score of G. Ms. Gillette, any objection to the criminal history score?
No, Your Honor.
And Mr. Ambrose?
No, Your Honor.
All right, Miss Michael, you're not objecting to the criminal history score? You're muted.
Sorry about that. No, I'm not objecting.
All right. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing at this time?
I am not, Your Honor.
And Mr. Ambrose?
No, Your Honor.
All right, this looks like a mandatory Senate Bill 123 case. Your recommendations, Ms. Gillette?
Your Honor, we're going to recommend 15 months standard underlying sentence with up to 20% good time credit. This is, as you said, mandatory Senate bill, post-release supervision of 12 months up to 18 months to complete her Senate Bill 123 program. She does have 29 days of jail credit. There's just one count in this case, Your Honor. I would be recommending for the supervision to be with Community Corrections. Must complete all conditions of Senate Bill 123 and follow all other standard conditions of probation as set out on her PSI and on the actual conditions in which she will sign. This is not a special rule case.
Actually, Ms. Gillette, I received a updated PSI shortly before court that does indicate that she was on felony bond in an Allen County case.
Oh, yes. And I don't know if the Allen County case has been sentenced or not, Your Honor, but we'd ask that they be consecutive. There is a KBI lab fee. Court cost, her DNA is already on file with the database. Community Corrections and Correctional Supervision fee, booking and fingerprint fee, and Senate Bill 123 reimbursement fees. We'd ask the court to inquire pursuant to Robinson as to her attorney's fees. I don't know what her relation is with Millard Ferguson, the co-defendant. We'd ask that they not have contact unless it is approved by the ISO. And one of her conditions should be that she not associate with anyone else on parole or bond or probation supervision. I believe that is the bulk of my recommendations for the court.
Thank you, Ms. Gillette. Mr. Ambrose, your recommendations?
Yes, Judge. We're pretty much in agreement with Ms. Gillette. I will point out a couple things for the court. First off, Ms. Michael has been sentenced in Allen County. She is undergoing treatment as we speak. She is in treatment several days a week. In addition to that, she does undergo mental health treatment too. And because of that situation right now, she is doing just some work, some part-time work for her father to help just make ends meet. She they've got some cattle, and so she's getting stuff prepped out for steers coming in. And then additionally, he owns a manufacturing business where they manufacture oil, well parts, and for sounds like for drilling. And so she does some work there as well, but she's not working full time right now. She's got pretty limited work, and as the court's well aware, when folks are starting this process of treatment, it's a lot. And there's a lot of expectations on her. So she's taking care of that. We're going to ask that the probation in this case get moved to Allen County. We do understand by matter of law that this case is going to have to run consecutive to the Allen County case. No objection to that. I will note that my attorney's fees by the time we're done are going to be about $1,300. Would ask the court to make consideration with Miss Michael's current situation and determining what gets waived or assessed there. Miss Michael got herself into a rough spot, but she's taking the right steps now. I believe she's going to be able to be successful. She's already on probation and doing what she's supposed to there, so hopefully she'll keep it up.
All right, thank you, Mr. Ambrose. Miss Michael, is there anything that you'd like to say before I pronounce sentence?
No.
All right, Miss Michael, for the primary offense, possession of methamphetamine, a level 5 drug felony, with your criminal history score of G, I do sentence you to a controlling sentence of 15 months with the Department of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. This is a presumptive probation mandatory Senate Bill 123 case. I will place you on probation from the controlling sentence for up to 18 months with community corrections. You are entitled to 29 days of jail credit for time that you've already served on your sentence. I will order that you follow all standard conditions of probation, including completing all Senate Bill 123 assessments and treatment. You're not to possess or consume alcohol or illegal drugs. You are subject to random breath, blood, and urinalysis testing. You need to follow any community service requirements of the probation program. I'm going to order that you maintain employment as a condition of probation, that you notify your ISO of any changes in employment, residence, phone number, email address. You're not to violate the law. If you have contact with law enforcement, you need to let your probation officer know within 24 hours. You need to follow all curfew and travel restrictions of the probation program. Don't possess firearms or dangerous weapons or associate with disreputable characters or places. Is there any reason you need to have contact with Millard Ferguson?
No, I don't have contact with him. No.
Okay, he's the co-defendant. I'll make it a condition of probation that you not have contact with him. I'm going to order you pay the court costs in the case, as well as the probation supervision fees. You'll need to pay the KBI restitution in the amount of $400. All right, looks like that Allen County case, is that the one that's in her criminal history?
Yes, Judge.
All right, I'm assuming she was ordered to do the KBI or the DNA fee in that case?
I was.
Yeah.
Okay, so you don't have to do that here since you've just done that. Tell me a little bit about so you're working, doing some kind of part-time work for your dad?
Yeah, just I mean it's seasonal and temporary, just as my schedule allows. I am looking for a job. I just haven't had luck doing that. I'm about to get my driver's license back, which will allow for me more job opportunities, but I've been extremely restricted. And I have meetings at either Road to Recovery or Mental Health literally every day except Fridays. So, and I have one by Zoom on Fridays. They are willing to work with me if I get a job. It's just kind of getting everything in place. But I've been clean since November and really concentrating on my sobriety, and I'm hoping a job falls in place soon.
Are you living in Allen County then?
Yes.
Okay. I'm going to order that you pay the bids application fee and that you pay $250 towards your court-appointed attorney's fees. You will need to pay the Senate bill assessment and reimbursement fees that total $300. So you've got a lot of costs and fees here, Miss Michael. I hope that motivates you to obtain employment. Of course, I appreciate that you're working on your treatment, which is probably the most important part. But unfortunately, there's lots of financial costs to these types of cases as well. So keep that in mind. I'll order that you pay $50 a month towards your costs and fees. Your first payment will be due by the last business day of May and by the last business day of each month until paid in full. That'll give you a little bit of a cushion. There is a $45 booking fee that I'll order. Pursuant to special rules, since you were on felony bond out of the Allen County case, this case will run consecutive to Allen County case 2022 CR 276. You may have a right to expunge this conviction from your record at some point in the future. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one would be appointed for you. As a convicted felon, you're not to possess firearms. And there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. Miss Michael, you don't have much criminal history at all. I don't know what happened to cause you at this stage in your life to get involved in this, but hopefully this is a wake-up call for you to get off the meth that leads to nothing but ruin. So,
Absolutely.
Miss Gillette, is there anything that I haven't addressed?
Judge, what did you say about the attorney's fees? Are they waiving or?
I ordered the bids application fee and $250 worth of fees.
Thank you, Your Honor. I got everything else, I think, written down.
Okay, Mr. Ambrose, anything that I haven't addressed?
I don't believe so, Judge.
Miss,
Okay.
Are you still doing drug court over in Allen County?
I'm actually, I'm returning to drug court. I had to slip up back in November, but I've been clean since November and I'm returning to drug court. The recommendation on May 5th is that I return to drug court and that's in place, to kind of start the program. I mean, basically to start fresh, like a second chance kind of deal.
Okay.
All right, do you have any questions, Miss Michael?
I don't think so.
Okay, this is your second strike on a felony drug case. You're presumptive prison from here on out if you continue to do this. So I don't want you to have to do that. So Miss Ashenfelter, do you need to visit with her in a breakout room?
Yes, Your Honor.
All right. When we conclude here in a minute, Miss Michael, you'll need to go into a breakout room to visit with Miss Ashenfelter. She's with Community Corrections. I'll allow this case to transfer to Allen County if they're willing to supervise you, but you need to report here until that's been accomplished.
Okay.
All right. Good luck to you, Miss Michael.
Thank you.
If there's nothing further, we'll be in recess.
And that's it for me, Judge, so I'll take my
All right.
leave.
I think that's it for all of us today. Jill, do you show any other cases?
Nope.
All right. Have a good afternoon.
Okay. Thanks, Ms. Vachon. That's all for this case.
Thank you.
Thursday, it's 5 days, you gotta do
Can I
that.
please have your name?
You call them if you know that.
I don't know, I forgot all about that.
Talking about the shit was over $1,000. Like, what the fuck?
Did you say that was not the
This was a fucking, it wasn't, I didn't get to talk like that, so I don't know. And they say shit, yeah. They didn't say shit. But they're calling me and ask Dariana what the fuck they done said, because Dariana said she took the fall for everything and I should.
Okay.
Yeah, how'd you like that little hot mic at the end there? I was cuddling with my kitty cat. Yeah. That hot mic at the end just that was Texas. That was Judge Greenwald's docket. I I just had it resting or just had it playing, and I was just going about my business. The case ended, and the case wasn't interesting by any means. And but there was still time left on it. And all of a sudden, I just hear this girl going off. I'm like, oh my gosh, the cursing, the cursing. No idea. They never did that hearing. Or if they did, they immediately took it down. But I tried to find it, but they didn't come back on with that hearing or the one that was immediately after that one, because the court official went through and got everybody's name, like, iPhone, what's your name, number, blah blah blah, what's your name, and yeah. Well, I mean, so obviously they muted her, but yeah, I think they did the case off the off the YouTube or whatever, however you say it. Hi, tiny kitten. Who my tiny kitten? Who my tiny kitten? Guys, it's 5 hours and 40 minutes we went. Yeah. She says take all the blame. Yeah, whoopsies. Yeah, I was cuddling with my kitty, and then my kitty went that way. Oh. Well, we made it. We made the Kansas Marathon. And I'm thinking like most everybody is asleep. There's 40 people watching right now, which is wild. That's absolutely wild, because normally we don't have that many. Oh my God, you're still awake. I thought you'd be number one on the sleep. Oh my gosh, well, I know you are. You've been commenting. Oh, look at you. Yeah, right. Oh, yeah. I survived most of it. I'm not even gonna pretend. Like, yeah, when that storm was rolling and the thunder and the lightning, and like, okay, storms are my happy place. And so and Ava was freaking out under the desk, and I reached down to pet Ava. And so I'm down like this, petting Ava and listening to the storm, and I just zonked. Oh, I have been. Yeah. I had to take a couple bathroom breaks because 32-ounce thermos, 12-ounce bladder. I bet you they will do some. There's gonna be weekend arraignments. I'm guessing Oakland. I bet Stacia Buchanan might do one. I'll keep my eye open. Whatever goes on, I'll probably get it. I know Michigan mostly is shut down, but yeah. Speaking of shut down, I'm gonna shut down. Oh, that's what she does. That's what she does. Look at that. Look at that girl. Yeah. Now that it's not lightning and stuff. When I crawl into bed, she literally like crawls up like alongside me, and like I have to hold her, especially on stormy nights. I have to hold her like she's my freaking husband. So I thought it was so funny. I think it was Isn't That Special said earlier. She's like, do you and your hubs sleep in the bed with all the pets? And I'm like, I am very single. And no, it's just me and Ava cuddling. Oh my gosh, I love this shirt. I really do, guys. Like, I love this shirt. The soft sit tears, felonious judgery. I love the colors. Yeah, I love this shirt. I love how it turned out. And it's like, you know how when you get shirts with print, sometimes they're very stiff and they get cracky and like they feel plasticky. This doesn't. This is very smooth. It's very lightweight. The shirt is very soft. Like, you know, I'm not a t-shirt person. And I really love this. Nope, that's a Judge. This is Judge Hunter. Yeah, so what happened was he had a soft sit that he shut down, clearly. And someone in the comments said something about, I can name 3 felonies that Judge committed in the first minute and a half, or something like that. It was stupid. And so the first thing I thought of when I read that was felonious judgery. And so that's what I made. Oh, I've run him plenty of times. Yeah, he's very wordy. Are you now? Well, I got your fez. I got your fez right here. See it crying? I love the crying fez. I made that. Like, I designed that 100%. That's me. All me. I couldn't believe I did that. Like, I'm so proud of myself. I made a crying, stomping fez. So, yeah. Yeah, Judge Hunter. What's his first name? It even has his name on here. Honorable. It's weird. It looks like cough, but it's not. Why can't I think of his name? Something G. Hunter. That's so weird. Colin! Judge Colin Hunter. Yeah, that's what it is. I'll take the ice cream. I have dilly bars in my freezer from Dairy Queen. Y'all ever had dilly bars? Those things are good. I love the cherry ones and the butterscotch ones. I don't like chocolate though, so I don't go for the chocolate. But so soft serve is my favorite ice cream. Like, you cannot convince me there's anything better. Second is Culver's frozen custard. It's not ice cream, but it's close enough. You don't have to call the embassy. They don't have these t-shirts. You can only get these from me. Yeah, and I don't know how Pepsi tastes mixed with ice cream. Like, you know how some flavors of things just don't mesh well? Like, I think Pepsi and ice cream, for me, it just wouldn't mesh. It would be like drinking orange juice and then eating chocolate. Ooh, horrible, horrible. And I don't like pork rinds. They're slimy. Sorry, I had to say it. Somebody had to say it. I get so I'm sure I've told everybody my trick before, that every time I get Culver's, I always order a kids meal, because you get these. I only have the scoop, but you have these tear-offs on the side of the bag for free scoops, and you also get another one, which is a token. Okay, so every 10 tokens, you get a free meal, a free kids meal, and trust me, it's enough food for a person. It's a full cheeseburger, and then a small fry and a small drink. Or I always get the chocolate milk because I drink my coffee, and so I just save the chocolate milk and give it to my neighbor because he likes chocolate milk in his coffee. And yeah, you gotta help a neighbor out, right? Letterkenny, you'd be proud of me. So anyways, with these tokens, or with the scoops and tokens, right? The free one comes with a token as well. So you buy your first 10 kids meals and save all your tokens, and then you get the free kids meal. But after that, it's every 9 kids meals, because the free one comes with a token. So yeah, like, why not? It's you save so much money doing it that way, plus you get free ice cream with it. And then I get 2 scoops, because I've got tons of these. I seriously have a bin, because my daughter would always get kids meals too, and she wouldn't get the ice cream, so we just save the tokens and save the scoops. And so I have this big bin that's just nothing but ice cream scoops, probably of 100. I used to just take stacks of them, and when we would go to Culver's, I would just walk around and just randomly, like, if I'd see kids at a table, I just randomly set down a couple of scoops on the table. So yeah, so there's that. And then I always get 1 scoop of strawberry, but I get extra strawberry, so it's 70 cents. And then I get a scoop with cheesecake pieces, and then I just mix them together, and I have strawberry cheesecake, and it's amazing, because the concrete mixer's like $7, man. A scoop is like $4. No way. I'm not paying it. I'm gonna find a way to get it cheap or free. That's me, man. I'm a cheap or free kind of gal. You spend all your life poor. It don't matter how much money you got. You still live like you're poor. right. You know, I do remember, I have heard of it done as a float. You're right. You're right. I have heard of that. Now, I'm not a float kind of gal. I don't like root beer at all. Not at all. Not even a little bit. Nope. Not even A&W. I just don't like root beer. Yes. You know, and free always tastes better. It does. Free always tastes better. It's kind of like, you know, when someone else makes you a sandwich, it always tastes better. Like, I can make a sandwich and it's just a sandwich. Somebody else makes me a sandwich and boy, by golly, it's the best sandwich ever. Yeah, oh, like I said, I had always heard, you know, root beer floats are the thing. But at one point somebody did say I think it was Coca-Cola they were doing though. But Pepsi is a lot sweeter than Coca-Cola. Surprisingly, Coca-Cola has a ton more sugar, but Pepsi just tastes sweeter. Yeah, yeah. Hi, Cherie. Tiny Kitten was here just a second ago. She's an in and out kind of gal. I don't know where she went. All my kitties have abandoned me. Yeah, I can't get into root beer. I don't know what it is about it. I've had Pepsi all my life, though, until adulthood. Then I switched to Mountain Dew. I was about 17, 18, and then I switched to Mountain Dew. And I've gone off and on with the Mountain Dew. Like, sometimes I'll just cut it out completely and lose like 70 pounds in 3 months. Not kidding. Like, that happens. Like, if I get too big for my britches, I just stop drinking soda for a year. But I don't know, something always pulls me back into it. It's such an addiction. It really is. Too bubbly. Dr. Pepper is so gassy. I've heard of that. I have heard of that. Yeah, but we don't have Big Red around here. I don't think. I've never seen it around here. But I think Joey Bag of Donuts said they have it in Ohio or something like that. Yeah, it does have that flatness thing going on, but that's what I like. And I think that's why I like Mountain Dew. I mean, I can throw this thing down a flight of stairs and open it up and it's barely fizzy. But nothing for soda, nothing beats Mountain Dew from fountain soda machine. Yeah. You know how the president has the Diet Coke button on his desk, his presidential desk? He's got a button he can push and it will summons a Diet Coke to him. Yeah. Mine, I would have a fountain soda machine on my presidential desk. Oh, and I believe it. Well, and part of it too is with being diabetic, sometimes why I get dozy when I'm streaming. My combination of my medicines, my blood sugar, like so many factors that could happen. But yeah, if it's my blood sugar, I'll take a swig of that and I'll perk right up. Yep. I'm then drowsy, but I'm at least awake. Because you can, like, when you have a blood sugar crash, recovery from it is like you're so worn out. It just takes so much out of you. Same with my asthma. Like, if I have an asthma attack, oh my goodness, I'm like, I'll use my inhaler and flatline. Yeah, people would get injured. I think it does. So one bottle has 240 calories, which, I mean, realistically doesn't seem like a whole lot for, I mean, it depends on how much you have. Like, there was a time in my life, and this is not now. Now I'm like one bottle a day, maybe two. But there was a time in my life when I was working. I was a shift lead at Hardee's in 2 different towns, and I would work from 4:30 in the morning until 2, and then have to drive to the next town and work from 3 until midnight. Yeah, like, my break at work was spent sleeping underneath the break room table. It was that bad. But I literally drank a case of Mountain Dew a day. I had a case of Mountain Dew in each cooler at the restaurants. And I would go through a case of Mountain Dew in a day. It was awful. It was so bad for my health. And then the stores closed down. Yeah, oh, it was terrible. I loved the job, though. I really did. And I had the greatest manager in the entire world. Okay. He ended up when the stores closed, because they closed due to a financing issue, because of when they switched from Hardee's to Carl's Jr., it required every store to put in a $14,000 hood system. And they had too many stores that were in the red, and our main store that I worked at was carrying all the other stores. And yeah, I guess the owner offered the bank, you could have 5 of our Milwaukee stores if we can keep our main star. And the bank was like, no, we want that spot, we want that location. So yeah, it's we ended up losing, like, all of our like, not all. I think he went from 13 stores down to like 8, I think, or something like that. But he lost the number 1 star Hardee's in the state. And yeah, we were the number 1, either state or nationally, but for sure state. And yeah, that was hard. It just all of a sudden one day, just boom, I got a call. You don't got to come into work today. I don't. Why? Am I fired? Well, kinda. Oh, yeah. I don't get that. I'm not prescribed that one. That's Tiny Kitten. Hey, Tiny Kitten. Cherie says hi. You had left the room, and I didn't get a chance to tell you. But come on over. You wanna come say hi? Hold on. You want some treats? Don't be so aloof. You're such a cat. Come on. Yeah, you know you want them. You know you want those treats. Let me move this out of the way. Come on. Come on, tiny kitten Esquire. Ooh, she's here. You can't see her, but she's here. There's my girl. She is the softest cat ever. Ever. I've never had a cat so soft in all my life. You left 1.5 treats and a tiny little crumb. How did you not eat all? Oh, you're going for the whole bucket? No, that's not how it works. Gosh, she's so darn cute. And she's such a talker. She constantly talks to me. Meow, 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 meow. And she runs in front of my feet. Yeah, I love her. You want some treats? Do you want some? No, you're done? You're done? Okay, fine. I'll add them to this food dish over here. Oh, did you hear? Ava heard the word. You heard the word? The treat word? You heard it? You already had treats. I even gave you a couple extra because of the storm. Okay. Have you seen the case where the guy throws his in front of the judge? Throws his what? Throws his what? I have not. But throws his what? Oh, yeah. She heard that word. Treats. Yeah, everybody's favorite paw pet. Throws his cat. Why did he have his cat in the courtroom? Or was it on Zoom? Man, if I was that judge, it would be like instant charges. Instant charges. Animal cruelty. They're really not. They land on their feet quite well. My dad used to always tell me, because my dad did animal control for 36, well, no, not 36. I think the last like 12 years of it, or 10 years of it, the Humane Society took over. But so my dad did animal control for lots of years. And he'd always get calls about my cat stuck in a tree. And they would want the fire department dispatched out, and send ladder 1, and and my dad was like, I've been doing this a lot of years. I've never ever in my life come across a cat skeleton in a tree. It's not going to happen. They come down eventually. They don't get stuck up there. They just don't want to be down here with you. Oh, how did the judge react? What happened? What judge was it? Come on, man. Where's his details? I probably have it. I just don't have it. Because then you'd find them underneath the tree, on the ground. I mean, they are pretty resilient, And I remember as a kid, I mean, we'd toss our cats for play. Well, don't they ever try to get out? You know, I mean, sometimes we open that door and just boom. Billy's an indoor-outdoor cat. He does go outside. Wow, that's unique. That's wild because I have never met a cat that didn't try to get out. All right, guys. Eileen, it is 4:11 where you are. It is time for bed. It's time for me for bed. Thank you guys so much. It it means everything. I tell you this all the time, but I love you guys. I love you guys so much. Ava loves you guys. Right? You love them. Oh, she just winked at you. She just winked at you. Yeah. Oh, did you just fart at them too? Yeah. Yeah, Mama's hands free and she's not patting you. Oh, I'm going to get your eye booger. Ava's eye boogers. Yeah, it's a good girl. You're such a good girl. Such a good girl. Thank you. I appreciate it. You guys make me happy. Right? You make me happy too. Thank you for spending over 6 hours with me. My goodness. Y'all are crazy. Be safe, be well, sleep sweet, and much love.